4th June, if a counsel is not engaged by the petitioners by that date, the matter would be proceeded with. ಇದು ಒಂದೇ ಸತಿ ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ಕೊಡ್ತಾ ಇರೋದು, ಅದು ಇವತ್ತು ಲಾಸ್ಟ್ ಡೇ ಅಂತ. 4ನೇ ತಾರೀಕೊಳಗೆ ನೀವು ಇನ್ನೊಬ್ರು ಕೌನ್ಸಿಲ್ನ ಎಂಗೇಜ್ ಮಾಡಿ. ಅವ್ರು ಬರ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಅವ್ರ ಏನ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಇದೆಯೋ ಕೇಳ್ತೀವಿ. ನೀವು ಬರೀ ಕೌನ್ಸಿಲ್ ಇಲ್ಲಿಲ್ಲ ಅಂತ ಅವ್ರ ಮೇಲೆ ಅಲಿಗೇಷನ್ ಮಾಡೋದಲ್ಲ. ಆಮೇಲೆ ಅದೇನಾದ್ರು ತಪ್ಪಾಗಿದ್ರೆ ನೀವ್ ಹೇಳಿರೋದು ನಿಮ್ ಮೇಲೆ ಆಕ್ಷನ್ ಆಗುತ್ತೆ. 4th June.
Serial number 6.
For the appellate in this case, my lord.
I appear for the respondent in this matter.
Yes.
The execution petition has been filed and delivery warrant has been issued, please, my lord, and the relationship between the parties and brother and sisters. The initially
ಎಲ್ಲ execution petition.
injunctions
Suit
suit was
for
filed
injunction.
and subsequently it has been converted into mandatory injunction.
There are two orders passed by this honorable court, my lords, wherein on the date of filing the claim before the commencement of the trial, wherein the respondent was in the peaceful possession of the property, they had preferred a MFA before this honorable court, wherein during.
Again, we can't take it up. You are for sole respondent, huh?
Please, my lord, sole respondent.
Shri N. Sridhar has appeared for the sole respondent, hence the question of filing acknowledgement would not arise. Counsel for the petitioner is granted 2 weeks' time to comply with the office objection.
It's only one of.
The respondents are restrained from any manner dispossessing the petitioner till the next date of hearing. Considering that today is the last day before vacation, the matter cannot be taken up for hearing today.
Date might be fixed, my lords.
4th June.
Okay.
Serial number 7.
Appellant in this case, my lords, filed a suit for injunction which got dismissed. Grounds that I have, there is a dispute in the title of the suit schedule property, my lords.
Yes. Then how can a suit for bare injunction be maintainable?
My lords, I am in the position, I have proved that I am in the possession
But
of
if there is a dispute on title, Bucci Reddy case clearly says that.
Anatula Sudhakar versus.
Sudhakar
So they
versus
have
Bucci
relied
Reddy.
on that judgment, my lord, but I am
Apex
in the
Court also
position,
has recently said
my
that.
lords, I am in the possession of the property.
So what?
I have,
If there is a title dispute, you can't maintain only a suit for injunction.
no, that is disputed by the defendants in the trial.
Who else will dispute? You yourself will dispute your
No,
title.
no, my lords, no, what has happened is I was in the position, they tried to interfere me, I filed a suit for injunction. So prior to the sale deed of the respondents, my
Mr.
sale deed.
Counsel, the suit has been dismissed on account of the suit being not maintainable due to reliefs not being sought for.
Yes, my lords.
That continues even today. File mado correct ag madi.
My lords, I have proved my position.
Right.
I have proved my position.
Learned counsel for respondent seeks fund is granted 4 weeks' time to file a statement of objections. You're bari in ellargu nanu.
Status quo may be maintained, my lord.
PM Narayan Swami, you appear for all respondents?
Only one
We received
respondent.
the copy last time, last date of hearing.
KVT yargappa file madidira?
28/4 only they have received the copy.
Ibru respondent gu file madidira KVT?
I'm proxy counsel and
Very nice.
after vacation. We'll file the.
Filed in IA, my lord. Let them maintain status quo because during the pendency of the suit also there was an order for status quo.
Shri PM Narayan Swami has filed KVT for respond number 2. He accepts notice for respond number 1 also. Respondents are restrained from interfering with the possession of the petitioner appellant till the next date of hearing, released on 4th June.
That's all.
Serial number 8. Ganapati Bhatt.
Therefore, petitioner,
Hearing for respond number 1, my lord.
they have filed the report, my lord. We have to file objection on that report.
In report upon.
Ins-
1 week time may be granted.
Counsel for the petition seeks fund is granted 2 weeks' time, released on 4th June.
Much obliged.
Serial number 9. Sirajuddin Ahmad.
Lords, appear for respondent number 2, Lords.
So and so submit that you file wakalatnama for respond number 2.
I undertake to file my wakalat, Lords.
What about respond number 1?
Respondent, I'm not yet appeared. Yes,
Respond number 1. no?
we will serve with the hand summons, my Lords, so I have appeared. Respondent number 1 is college, my Lords. I'm for the Bangalore University.
Bangalore University. Error? She so and so is direct to accept notice for respond number 1. None
Chaitanya V.
appears.
Joshi, my Lords. Chaitanya V. Joshi.
Chaitanya V. Joshi. What is this matter? Education matters. Mr. Sirajuddin, none appears for the petitioner, relist on 5th June.
None check.
Serial number 10.
For the petitioner, my lord.
Yes.
Seeking adjournment, my lord, it may be listed
The
soon
request
after
of counsel
vacation.
for the petitioner, relist on 5th June.
Serial number 11.
Let's I appeal for the petitioner, Mullah. An order under section 74 of GST came to be passed without specifying what is a fraud played upon.
ಮಾಸಾಮಿಗಳೇ ನಂದು ವಿನಂತಿ ಮಾಸಾಮಿಗಳೇ 437 ಜನಕ್ಕೆ ಪರ್ಮಿಷನ್
Serial number 11
ಹೌದು ಸರ್ ಹೌದು ಮಾಸಾಮಿಗಳೇ
serial number 11 ಅಲ್ಲಿ ಇದ್ದೀರಾ ನೀವು? ನೀವ್ಯಾರು?
ನಾನು ಸದಸ್ಯ ಸ್ವಾಮಿ
ಇಲ್ಲ, ನಿಮ್ದಲ್ಲ ಇದು.
ಎನ್ಜಿಎಫ್ ನೌಕರ
ಬೇರೆ ಲಿಸ್ಟ್ ಬೇರೆ.
ಎನ್ಜಿಎಫ್ ನೌಕರ ಗೃಹ ನಿಯಮ
ಅದು ಲಿಸ್ಟ್ 1 ಬೇರೆ. There is Mr. Niralgi. Yes, what is this about?
Let's an order under section 74 of GST came to be passed without specifying what is a fraud played upon by me, Mullah. That goes exactly in contravention with Annexure T, Mullah.
Pass over, let Mr. Niralgi come.
Please.
Hearing on IS. Serial number 12.
Lordship, for appellant, your lordship seeks adjournment, your
You
lordship.
notice on IA 1 of 25, returnable by 12 June.
Obliged, your lordship.
Serial number 13.
For the petitioner, my lord.
Pass over.
Case. Pass.
Serial number 14.
Applying for petitioner, my lord.
My lord, they can go, alternative remedy is there, my lord. First appellate,
Lordship, may I make submission here?
Yes.
The objection number 2 and 3 is complied, my lord. Objection number 1 is concerned. I make correction, my lord. Petitioner is concerned anta ಮಾಡಬೇಕು ಅಂತಿದೆ prayerly. That will do it, my lord.
ಯಾವ್ದ್ರಲ್ಲಿ Mr. Jain, you are appearing in 14.
14, my lord.
Why is
I
it?
appeal for respondent, my lord.
Yes, what is it that you are challenging here?
Nagaraj ji.
YC Shivkumar ಅಂತಿದೆ 14.
Sorry, my lord.
List 1 ಅಲ್ಲ, ಇದು ಬೇರೆ.
Sorry.
I appeal for respondent, my lord.
Ms. Jyoti
This matter may be
Murthy,
taken up after vacation, my lord.
respondent, none appears for the petitioner, relist on 5th June.
Much obliged.
Number 15.
Yes.
Therefore, respondent, Lord. In this case, my lord, I am filing my objections. Lord, the matter is the institution which is called as a learner support center of Karnataka State Open University. They wanted to express the cause of the students, whereas, my lord, they have no power to admit the students. They have nothing. Students have not been admitted to, even there is no admission of these students, and they are not assigned, they have not submitted any assignment, and examination fees is not paid. Now 8th is examination. Now, my lord, through this institution wants to, my lord, get the admission of students. This institution has absolutely no right, my lord, legal right to, my lord, say anything on behalf of the students. This directly.
They have an agreement with you.
The agreement, my lord, only for, not for the admission, only for, my lord, for this learner support center, which, my lord, they would help the students only in assignment and last date giving information also.
ಬರಲ್ಲ
That's all.
Mr. Vasant.
My lord, Annexure D, only students.
ಬರಲ್ಲ. They don't have power to enter into an agreement. You don't have power, this one to admit. CBI inquiry has been ordered. ಏನಾಯ್ತು CBI inquiry?
ಏನಾಗಿಲ್ಲ ನಮ್ಗೆ.
Relief ಸಿಗಲ್ಲ.
Because
1 month ಆದ್ರೆ next year admission ಆಗೊಳ್ಬಹುದು ಆ ಹುಡುಗರು directly they can
first
admit
year
at least
ಅವ್ರು
there is no-
ತಕೊಂಡಿದ್ದಾರೆ ಪರೀಕ್ಷೆ.
ನೀವು ಬಂದ್ಬಿಟ್ಟು ಡಿಫೆಂಡ್ ಹೆಂಗ್ ಮಾಡ್ತೀರಾ ಇದನ್ನೆಲ್ಲ?
ಫಸ್ಟ್ ಇಯರ್ ಪರೀಕ್ಷೆ ತಗೊಂಡಿದ್ದಾರೆ ಸ್ವಾಮಿ.
All
I am
the,
opposing them, my lord. I am not defending.
This is second year, they are studying in second year.
The studying ಅಲ್ಲ admission ಆಗಿಲ್ಲ. Where is the question of studying?
But first year they have taken the examination.
through KSOU or
Please, my
KSOU
lord.
conducted or you conducted?
Case you only conducted.
Where is that?
I have not produced those documents, but first year they have taken the examination. These
Shows
students,
that it has been done by KSOU. We'll direct one more. We'll invite them to one more investigation. ನೀವೇ ಇದು ಮಾಡ್ತಾ ಇರೋದು. How many people you are putting into trouble?
No, my lord, there is absolutely no problem, my lord, in this case. My lord, this is called, this institution, my lord, they call it itself as an institution. What they do, case namdu online everything would be there. Student can directly admit, these students have been directly admitted to students through online, my lord. There is no necessity for students to go any institution and get the admission. ಅವ್ರು ಏನ್ ಮಾಡ್ತಾರೆ, ಇವ್ರು ಏನ್ ಮಾಡ್ತಾರೆ, ಕೆಲವು ಹುಡುಗರನ್ನೆಲ್ಲ ಕರ್ಕೊಂಡ್ ಬಂದು ನಾವು ಮಾಡಿಸ್ಕೊಡ್ತೀವಿ ಅಂತ ಅಂದ್ಬಿಟ್ಟು, ಇನ್ಫ್ಯಾಕ್ಟ್ there is a complaint, ನಮ್ 25,000 fees ಇದ್ರೆ 35,000 ತಗೊಳ್ತಾರೆ. There is a complaint from the students also. They are not supposed to take it, and they are not supposed to admit any students. ಆನ್ಲೈನ್ ಅಲ್ಲಿ ಅಪ್ಲೋಡ್ ಮಾಡಿ ಇದು ಮಾಡೋದು ಹೆಲ್ಪ್ ಮಾಡೋದು ಅಷ್ಟೇ ಕೆಲಸ ಇವ್ರಿಗೆ. ಆಮೇಲೆ ಇಂಟರ್ನಲ್ ಅಸೆಸ್ಮೆಂಟ್ ವಿಲ್ ಬಿ ದೇರ್. ಇಂಟರ್ನಲ್ ಅಸೆಸ್ಮೆಂಟ್ ಗೆ ದೇ ವಿಲ್ ಹೆಲ್ಪ್ ಅಂಡ್ ದೇ ವಿಲ್ help the students to do the internal assessment and send they will assign and they will value and send the marks to the university. ಅಷ್ಟೇ ಅವ್ರ ಕೆಲಸ ಅವ್ರದ್ದು. So after first year is over, 117 students ಇದ್ದಾರೆ ಇವರು. But we do not know what happened to these students. They did not admit. Last date ಎಲ್ಲ ಆಗೋಯ್ತು, ಜೂನ್ ಜುಲೈ ಎಲ್ಲ ಲಾಸ್ಟ್ ಡೇಟ್ ಆಗೋಯ್ತು. ಲಾಸ್ಟ್ ಇಯರ್ ಅಡ್ಮಿಷನ್ ಆಗೋಗಿದೆ, ಇಂಟರ್ನಲ್ ಅಸೆಸ್ಮೆಂಟ್ ಅಕ್ಟೋಬರ್ ಅಲ್ಲೇ ಟೈಮ್ ಆಗೋಗಿದೆ. Now my lord, from December the examination date has been announced, paying fixed examination that they have not paid. Now up to it was extended up to January.
For the first year did you conduct the exam?
ಹೌದು.
Second year what is the only
admission ಆಗಿಲ್ಲ ಹುಡುಗರು, ಅಡ್ಮಿಷನ್ ಆಗಿಲ್ಲ.
first year ಹೆಂಗ್ ಕಂಡಕ್ಟ್ ಮಾಡಿದ್ರು?
First year every year they have to admit.
Second year admission.
ಹೌದು, ಸೆಕೆಂಡ್ ಇಯರ್ ಹುಡುಗರಿಗೆ ಇವರಿಗೆ ಸೆಕೆಂಡ್ ಇಯರ್ ಅಡ್ಮಿಷನ್ ಆಗಿಲ್ಲದ್ರೆ ಹೆಂಗ್
Last date was.
ಏನ್ ಮಾಡ್ಬೇಕು ಅವರು? What do they need to do?
Melody, Melody, now the examination is on 8th. Next to June, they can admit for second year again.
They lose 1 year.
Oh, they are not admitted, Melody. It's not our fault.
All your matters will just adjourn by 1 year and say only 1 year it is being adjourned. 1 year for a student is not a small period.
I know, my lord, students are not there before your lordship, my lord.
So what is it that they need to do to safeguard the students' interest?
Lord, they can admit next year and they can.
Apart from that, for this year.
Well, there is no internal assessment, they have not filed. Examination fees has not been paid. And admission fees they have not paid.
It's only the money.
Money, my lord.
Finally, it is the money only you are speaking of.
My lord,
so they'll pay the money.
They have to attend, my lord. Contact classes will be there, my lord, for 3 weeks. That they have not attended.
Contact classes.
Now ಮಾಡ್ತೀವಿ ಅದನ್ನ, ನಮಗೆ ಹತ್ರ ಬರ್ಬೇಕು ಅವರು. ಅದು ಮಾಡಿಲ್ಲ, ಅಡ್ಮಿಷನ್ ಆಗಿಲ್ಲ, ಮಾಡೇ ಇಲ್ಲ, ಬಂದೇ ಇಲ್ಲ ಅವರು.
My lord, we made the request on 11/2/2025, annexure D to the writ petition, my lord. Students only they made the request to us. Annexure D, page number 15.
Did you admit them? Did they attend have they completed all the formalities?
Please, my lord.
Where are what have you produced to show that they have
My lord, annexure D specifically speaks. ವಿಳಂಬ ಮುನ್ನ ಮಾಡಿ ಮನ್ನಾ ಮಾಡಿ 2023-24 ಸಾಲಿನ ಪ್ರವೇಶಾತಿ ಶುಲ್ಕವನ್ನು ಪಾವತಿಸುವ ಬಗ್ಗೆ ಈ ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ KSOU ದಲ್ಲಿ 22-23ನೇ ಪ್ರವೇಶಾತಿ ಪಡೆದುಕೊಂಡಿರುತ್ತೇವೆ. ಆದರೆ 23-24ನೇ 2ನೇ ವರ್ಷದ ಪ್ರವೇಶಾತಿಯನ್ನು ನಮ್ಮ ವೈಯಕ್ತಿಕ ಕಾರಣಗಳಿಗಾಗಿ ಪ್ರವೇಶಾತಿ ಶುಲ್ಕವನ್ನು ಪಾವತಿಸಲು ವಿಳಂಬವಾಗಿರುತ್ತದೆ. ಆದ ಕಾರಣ ತಾವುಗಳು
This is only for the payment
of admission fees.
Now, any other, what are the formalities that they have to comply with? The contact classes ಎಲ್ಲಿದೆ, ಅದು ರೂಲ್ಸ್ ಎಲ್ಲಿದೆ? As per what?
Annexure R1 may kindly be taken. This is a circular which was issued in 19th October 2024. Which my lord says, my lord, the fees, my lord, admission fees has to be paid, my lord, which is what it says.
Fees ಬಿಟ್ಬಿಡಿ, fees ಬರುತ್ತೆ, ಬೇರೆ ಏನಾದ್ರು ಮಾಡ್ಬೇಕು ಹೇಳಿ.
Then my lord,
fees is the least of the problem. If there is anything material which they have not complied with, then yes. If it's only fees, they'll pay the fees.
Fees ಎಲ್ಲ ಕಾಂಟ್ಯಾಕ್ಟ್ ಕ್ಲಾಸ್ ಅಟೆಂಡ್ ಮಾಡಬೇಕಂತ.
ತೋರಿಸಿ ಯಾವುದು ಅಂತ. What are they required to comply with which they have not complied?
Yes, kindly pass over, madam.
Pass over.
Serial number 16. Indian.
Appearing for petitioner, my lords. My lords, I am
the respondent, my lord, kindly pass over.
Pass over.
17.
My lordship, press per time, my lordship, after
the request of counsel for the petitioner released on 5th June.
18. Santosh Sagar.
For the respondent.
None appears for the petitioner, 5th June.
Serial number 19. Anil Kumar.
I appear for the petition. It's a GST matter, my lords.
Yes.
My lords, what has happened is.
Mr. Nilal has to appear.
No, state, my lords. Madam.
I am appearing for the respondent, my lord.
Yes, madam.
My lords, what has happened is there was an audit conducted by respondent number 3. He investigated. He issues the final audit report. The very same officer proceeds to issue show cause notice. Thereafter, he adjudicates the show cause notice. All three has been done by the same officer who has done the investigation. And identical matters.
Madam. We can't hear you.
To state government, my lord. This matter may be posted after vacation. We will file detailed statement of objection, my lord.
Identical matters, this honorable court.
No, my lord.
Who has passed the order?
Yes, my lord.
And my lords may kindly see the
ಆ
order.
ಪ್ರೊಸೀಜರ್ ಇದ್ದಿದ್ದು ಇಂಡೈರೆಕ್ಟ್ ಟ್ಯಾಕ್ಸ್ ಅಲ್ಲಿ ಸೆಂಟ್ರಲ್ ಗವರ್ಮೆಂಟ್ ಅಲ್ಲಿ ಇದೆ ಸೇಮ್ ಪ್ರಾಪರ್ ಆಫೀಸರ್ ಅಂತ ಕ್ವಶನ್, ಆದ್ರೆ ಸ್ಟೇಟ್ ಗವರ್ಮೆಂಟ್ ಗೆ ಬರಲ್ಲ, ಆತರ ಕ್ವಶನ್ ಬರೋದಿಲ್ಲ.
Central government has issued a circular where it clearly says the person who conducts the audit cannot adjudicate the matter.
State government ಗೆ that will not applicable, my lord. I will file statement of objection detail, my lord.
Circular by the central
Similar
government.
orders passed in other matters.
Yes, ma'am. Where show cause notice has been stayed, ma'am. Here I have contested the order.
The show cause notice being stayed is different.
Now, my lords, where the proceeding 65 audit was conducted by the officer, then he, very same officer issues the show cause notice. So they challenge the show cause notice.
Raised in this. Same issue has been raised in another matter where there is a stay, madam.
And similar orders.
Stay may be granted, my lord. They may be posted after vacation, my lord. I will file a statement of objection.
Notice for all three, Alva.
Yes, yes. Notice has been issued on Tuesday.
Merely Leonard counts CGP accept notice for respondent number 1 to 3. Then a similar issue has been dealt with at the interim stage by a coordinate bench of this court in WP 14711 of 2022. In that view of the matter, the operation of annexure A.
Yes.
He stayed till the next date of hearing. Connect the above matter with WP 14711 of 2022 and relist on 5th June.
Serial number 20, Kartika.
Macho.
Senior head up in Madras High Court, my lord. Kindly pass.
Paso.
21,
Connected, my lord.
Paso.
23 also connected, my lord.
20. I appear for the petitioners in 22.
23 Paso. 22.
22. 22 is a matter wherein I have challenged the taking into possession of a vehicle and its goods by the respondent number 2 under section 129 subclause 1 of the KGST, please, my lords. The rules.
What was being transported?
Scrap, please, my lords. Page 17 is the order, and the initial, my lords, the order when the movement was happening at page 23, it was intercepted by the respondent number 2, and at page 23 a statement is recorded. In that statement, at the last line, please, my lords, we have produced the documents recorded in the annexures relating to the goods transportation, which I have duly certified and signed as correct. He has ticked it. There are two documents which has to be produced and which has been produced as per annexure B and B1. Now, subsequently, please, my lords, that is dated 28/3/2025.
This is 27 March. B is 27 March.
27 March. That is the bill and bill of that is the e-way bill as well as the
invoice and e-way bill.
E-way bill. And when it was in movement on 28/3/2025, it was intercepted. Documents were searched and it was recorded that it is to the satisfaction of the respondent. Though such being the case, at page 25, please, my lords. Initial order dated 28/3/2025 came to be passed, saying it has to be temporarily taken into the custody. The reason is and verification.
It is suspected.
Please, verification order submitted by the so and so. It is noticed that the petitioner of the so and so transportation is suspected. Hence, it is required for further verification. They suspect. They don't say what is the grounds.
And it is 14,630 kgs only which was seized.
Please, and they have done physical verification. Physical verification is according to the verification in the invoice, etc., etc. So, such being the case, they have passed the order after a lapse of about 16 days, which is at annexure A. This, my lord, has been covered by decision. My lord, I can pass over this judgment, please.
My lord, this is the case.
Yes, madam, this is the case.
Where, my lord, we have a received inspection report, enforcement report saying that the petitioner is involved in a bogus transactions. Where they have purchased the materials, the person is non-existing person. So to claim the ITC, they have created themselves a non-existing person receipts. After receipt of notice, we have issued a show cause notice. We have not temporarily detention is taken place, and we issued a show cause notice. Let them come and appear before the respondent and file a submission. Instead of submitting their documents and reply, they have approached this honorable court Hence, this honorable court don't have a jurisdiction to entertain this writ petition. First of all, second is the first appellate authority is already there. They can, if they are aggrieved, they can go appeal. Instead of going appeal, they are approaching this honorable court at the stage of show cause notice.
If I make
Without
Not a show cause
appearing.
notice. This is the order of detention at Annexure A. Where the
Yes,
show
my
cause-
lord. Show cause notice is issued on 17.
Page,
They have not
23.
submitted, my lord.
No, page 25, please, my lords. This is the initial order.
that show cause notice is culminated in Annexure A.
Please.
17/4/2024 opportunity of also provided, my lord. They have not. They have submitted on 23/4/2024. Still, we are awaiting further documents. They have not submitted. They have not appeared before the respondents. Directly, they appeared before this honorable court, my lord.
Required by them is at rule number 130, please, my lords. What I have to produce is mandated under rule number
What do you want them to produce, madam?
138A, please.
They have produced the
Lord,
invoice. They have
we
produced
have
the-
received an internal.
And furthermore, please, if I make one submission, please, my lords. My lords, may I kindly have page number 17 for a moment.
Please,
I'll just clarify, please, my page number
My lord,
17.
we have
Yes.
received an internal report saying that the petitioner is involved in a bogus transactions, my lord.
What is the interim relief that
It
you are
is
seeking?
covered by
Page 17, I want
Ecom
to
Gills
show.
case, Supreme Court judgment, my lord. If they come, we will take fair judgments, my lord. Let them appear.
Let them file their objections.
My lords, my humble submission. Page 17 may be seen, please, my lords. What is the bogus transaction? It is coming out.
They're saying it's a bogus transaction. Let them place it on record.
We have received the report, my lord.
I may be given that
Place
response.
the report on record.
My lord,
Nothing
one
will happen in a
humble
month.
request, my lord.
Nothing
One
will happen
humble
in a month.
request, let them appear before the respondents, we will pass an order. Let them, afterwards they can take action.
It's odd.
We have not
If I
yet
make
passed
one
an order.
submission- If I may make one submission.
Yes.
My lords, may kindly see page 17. As on that date, they say this, the goods were purchased from Messrs. Pinnacle Enterprises, bearing number so and so. These goods are intercepted because it was purchased from Pinnacle Enterprises. Messrs. Pinnacle Enterprises has purchased, in turn purchased it from Aqua Enterprises, located so and so. Aqua Enterprises has purchased it from an unregistered. So 3 layers above me, it is unregistered. Now, my lords, may kindly see page number 27 for a moment.
Can you go and place the documents before them?
My lords,
Or
even
should we
I have
just
placed
adjourn
it.
it after vacation?
No, I have placed it.
Want to do?
I have placed it. This is a final order, please, my lords. Now, my lords, may kindly see section
No, no,
rule
we have not
138.
passed a final order, my lord.
Number 1 and 2, she seeks for 2 weeks' time to place the inquiry report on record, released on 5th June.
My lords, my humble submission. I may be permitted to move the vacation bench, please, my lords, because the
at
entire
all.
vehicle is with them.
Not at all.
Please, my lords.
B group matter, serial number 24.
B group. None appears, released on 5th June.
25.
Appear for petition, this case, your lordship. In this case, your lordship, the entire tax liability has already been discharged by the
There is
service.
Mr. Neeralgi pass over.
List number 1. For being spoken to, serial number 1. Go Gherle.
For the respond number 3, my lords. It's just that in the cost title, senior's name is not being. Sorry. Respond number 3. The Balakrishna Shastri.
Internal page, my lord, lordship has been, my lord, referred his name.
Either.
In the cost title, it's not being referred.
What is it required? Registry is direct print the name of Shri G. Balakrishna Shastri as that appearing for respond number 3 in the past title and issue a fresh certified copy.
Order, serial number 2.
Your lordship has passed the order, connected matter. Your lordship has passed it because successive petition. Your lordship, there is a flag which has been.
HCG paid. Pass over.
She's.
You are appearing, madam?
HCG.
Put the order last time.
Lord, in criminal petition number 3027 of 20, my Lord, your Lordship on 21st October 2020 passed the order, my Lord, in crime number, same crime number, which is now 482 petition which has been filed. Because of that reason, my Lord, this matter is posted before your Lordship. Crime number 35 of 2020. Identical matter, my Lord, this honorable court is already stayed. Copy is given. CA, Lord, your Lordship has transferred the matter from Lord the.
One was already before CID, so the other also.
Now
went
the
before
charge sheet which has been filed by the CID itself.
So now charge sheet has been
filed.
Yes.
The identical matter, this honorable court is already stated similar issues which has been involved. Lord, inquiry, similar kind of inquiry, department inquiry was also been, my Lord, conducted against this petitioner. They're all exonerated, my Lord, from the inquiry. Same set of charge sheet, my Lord, has been filed. On that ground, my Lord, this honorable. Lord, this is volume 2 only. This. Lord, page 489, my Lord. Is the, my Lord, inquiry report which has been conducted by the, my Lord, as per the, my Lord, orders of this honorable court in writ bill number 261, my Lord, that is annexure. Before that, my Lord, annexure.
Hey, what is the charge sheet?
Charge sheet has been filed, my Lord.
Implicated.
Same set of, my Lord.
You are implicated.
Yes, my Lord.
You're given a false certificate to get an employment.
No, but similar charges, same charges, my Lord, which has been there in the department inquiry. There I have exonerated, my Lord. The inquiry has been.
Department inquiry is different. Here, there's a fabrication of the mass card.
True, my Lord.
There's a serious issue.
No. Because fabrication, my Lord, it is only approval. Not in a fabrication means, my Lord, I printed the, my Lord, mass card which has been
Still,
produced.
we are not
It is not like that,
received
my
the
Lord.
report also.
It is, my Lord, it is because instead of approving, no, my Lord, instead of
The
approving.
charge sheet which has been laid, now there's nothing to stay on it.
Lord, here, the identical matter which has already been stated by this court.
Very
Same,
serious offense. We are not inclined to say.
Same, two matters which has been already stated by this court.
We are seeing lot of these mass card being fabricated.
Sorry, my Lord.
Boards which don't
No, my
exist
Lord.
giving
See,
mass
that's why, my Lord,
cards.
even, my Lord, everybody, it is in the mind of that, my Lord. It is not like that I have created a mass card. My Lord, instead of approving the, my Lord, in the Ubli, my Lord, I have taken approval from the, my Lord, examination has been conducted. All ticket has been issued. Mass card has been issued by the same authority. Same set of facts, my Lord. That time, it is not like that mass
Same
card.
set of facts, madam, 11284.
Same, my Lord. Same CID which has been.
Verify 11284 is the same one, pass over. The same, then they'll also be entitled for the benefit.
Please.
Public.
Serial number 3.
Appearing for
Delhi Muralidhar.
serial number 3.
None appears for the petitioner.
I'm
Realist
appearing
on.
for respondent in serial. Petitioner has deposited the amount.
Madidara.
The respondent has filed an application seeking to withdraw the amount.
Withdraw.
Both are residing together. Earlier, there was an order
Oh, it's disposed of matter.
of respondent's application. Respondent has filed this application seeking to withdraw the amount which has been deposited by her husband. Now they are residing together. Earlier on 31/1/2018, there was an order for releasing of the amount in favor of the
To the
respondent.
petitioner. To the petitioner.
No, respondent.
The amount in deposit is directed to be refunded to the
Deposited by the
petitioner.
petitioner towards the maintenance amount.
Para 6 says the amount in deposit is directed to be refunded to the petitioner after complying with all the formalities.
Or respondent.
ನಿಮ್ ಕೇಳಿದ್ವಿ ಅವತ್ತು since they are living together petitioner ಗೆ ಕೊಡಿ ಅಂತ ಹೇಳಿದ್ರಿ. That is why specifically we remember this matter.
Withdraw ಮಾಡ್ಕೊಂಡಿಲ್ಲ.
It's been directed to be refunded to the petitioner. You are living together. What is the problem?
He is residing in Chennai.
His wife is also living with him now.
Weekend. Earlier, there was an order to return the amount to the respondent.
But
On
there is a
31/1/2018. On 31/1/2018.
Then you will have to get a affidavit of the petitioner.
She has submitted no objection.
She is. She is the respondent.
Respondent.
That is why the direction has been to refund it to the petitioner.
No, respondent. Earlier it was
Petitioner is the one who has deposited Alapa.
petitioners deposited.
So is no objection is required.
Yes, he is given no objection
Ellide.
on the presentation form.
Presentation form.
Copy of the application has been served on.
Ellide, objection, no objection.
The application has been served on the petitioner.
Application has been served is different from saying no objection.
I will get this no objection.
Counsel for the petitioner seeks for and is granted 4 weeks time to file an affidavit of the petitioner
Yes, ma'am.
indicating no objection on part of the petitioner to refund the amounts deposited in favor of the respondent. Released on 9th June.
Serial number 4.
Lord, this is regarding memo of calculation. In first matter 4, I have received some instructions. And in 4.1, I had to receive some instructions. I'll file it memo of calculation because this pertains to the Gulbarga airport. Certain files are at folder there.
Seeks for and is granted 3 more weeks time to obtain instruction and furnish his memo of calculation.
Yes, ma'am.
Released on 4th June.
My lords, may I request the matter to be considered part heard?
None of them will be parted.
Much obliged.
Serial number 5. 11.
Your lordship, senior is not well. Kindly grant time, your lordship.
At the request of counsel for the petitioner, released on 9th June.
Oblige, your lordship.
Serial number
My
6.
lords.
Sid Kumar has entered appearance for respond number 2.
Serial number 5 was that.
Hence, memo of retirement filed by Sri Vivek Parda is accepted. He is discharged from the matter. Registry is direct. Delete the name of Sri Vivek Parda as that appearing for respond number 2. Yes.
I'm appearing for respond number 2.
Hmm.
Here, the prayer of the petitioner being complied with regard to payment of stamp duty for the
In comply ಮಾಡಿದೀರಾ?
Hypothecation bond is
Because
concerned.
they have
Next.
challenged the order passed by the
Assistant Registrar.
Joint Registrar of Cooperative Societies
Annexure.
with regard to the final application for impounding the document.
Impounding of one document, my lord.
So now you are refunding the,
No, my lords, we are,
Court has rejected the application on the ground that I am a quasi judicial authority. I have no power to impound, my lord, which is contrary to section 33.
34
So
of
that order
the-
is challenged before my lords.
you are individuals, private parties.
Yes, please. They are the bank. They produced one document during the course of evidence in 70 proceedings. So that I sought for impounding because it was not stamped at all. The court said, I am a quasi judicial authority, I cannot impound.
Finding it, my lord, page number 21, no, item number 2.
JRCS has impounded it.
Please, please.
No. JRC is rejected my application to
Who is
impound.
impounded?
it is not impounded, my lords, it was, application was filed to impound.
My
the document.
application for impounding the document got rejected, my lord. At page number 22, if my lord.
22, it's been rejected. ತಿರಸ್ಕರಿಸಿದೆ.
Against which I am before my lord.
Ah.
The JRC says I am a quasi
What is
judicial.
your submission?
My lords, I am ready to pay the stamp duty and we have requested the direct registrar, district registrar for
So
calculation
the
of-
mortgage is in your favor.
Please, my lords, mortgage is, I'm in the bank. Please.
So you don't want to lose your security.
Because
They're
they
willing
are-
to pay.
He wants it has to be adjudicated. my lord. Now he wants to,
Nothing survives in this petition.
Please,
the direction has to be issued for adjudication and payment of.
They are willing to pay and then JRCS will verify and if required, refer to the district registrar.
State has to.
my lords, okay, I've already given a letter to the district registrar along with the memo.
Bari letter and ದುಡ್ಡು ಕೊಡ್ಬೇಕು.
I'm ready, that's what my lords, if once it is, what is the amount I have to be paid, my lords, I'll pay the amount and.
The adjudication has to be done by the appropriate authority.
Petitioner is before this court seeking for the following reliefs. Respond number 2 had raised a dispute with respond number 1 GRCS as regards amount said to be due by respond number 1 to 3 to respond number 2. In the said proceedings, an application under section 33(1) and 33, read with 33(1) and 2 of the Karnataka Stamp Act had been filed seeking for impounding of the documents produced therein, namely the hypothecation agreement, on the ground that the same is not adequately stamped. The said application having been dismissed, the petitioners are before this court. The submission of Shri Rakshit Kumar, learned counsel for respond number 2 now is that respond number 2 is willing to make payment of any deficit stamp duty on the said documents, and as such the matter could be referred for adjudication to the district registrar. In that view of the matter, nothing survives for consideration in the present petition. As such, I pass the following order. Respond number 2's request would have to be placed before the respond number 1, who could refer the matter to the concerned district registrar for adjudication.
Number 7.
Respond. The purchaser.
Fresh matter.
Fresh, please.
And AG accepts notice for respond number 1, 2, and 3.
Please.
Issue notice to respond number 4 to 7.
Yes.
Returnable by 27 June. The operation of
Lord,
annexure
one submission, my lord.
A.
This case is concerned, my lord. Initial order is passed by this honorable, direction is given to my lord in favor of the lot is my lord. Page number 88, my lord. They're challenging the
88.
annexure N, my lord, challenging the order. Lord, page 88, my lord, the abstract. The last page, my lord. Page number 96, my lord.
They can still challenge this.
Please, not
Issue annexure A. He stayed till the next date of hearing. Process fee and copies to be furnished by end of day 5th May. Petitioner and respond number
4 to 7.
4 to 7 are restrained from any manner alienating, dealing with, encumbering property till the next date.
Please.
Number 8. Raju HB.
8, my lord, voting. Voting matter.
Matter where Rajgopal sir said that he would want to make submissions with regard to
Pass over.
reference.
Our next.
My senior was submitted, my lord, it has to be referred to the division bench, that argument.
ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಬೇಕಲ್ಲ, ಇವತ್ತು ಆಗತ್ತೆ ಇಲ್ವೋ ಗೊತ್ತಿಲ್ಲ.
Maybe taken after vacation here.
ಆಸ್ ಎ ಲಾಸ್ಟ್ ಮ್ಯಾಟರ್ ಅಂತ ಅಡ್ಜರ್ನ್ ಆಗ್ತಾ ಇದೆ.
Actually, your lordship said after vacation only.
Date also.
12th June.
Released on 12 June.
That intermatter was granted, my lord, to stay the order passed by your lordship, my lord.
ಸಾರಿ, ಇದರಲ್ಲಿ ಆಗಿದ್ದು ಕರೆಕ್ಟ್. That matter. Why it is listed is that 8285 was not posted on that.
Please. It was not posted, but we made submission, my lord.
Correct.
Since
ಅದಕ್ಕೆ ಇವತ್ತು ಲಿಸ್ಟ್ ಆಗಿದೆ. ಅವತ್ತು ಪೋಸ್ಟ್ ಆಗದೆ ಆರ್ಡರ್ ಮಾಡಕ್ ಆಗ್ತಾ ಇರಲಿಲ್ಲ ಅಂತ. 8 ಅಲ್ಲಿ ದಿ ಆಪರೇಷನ್ ಆಫ್ ದಿ ಆರ್ಡರ್ ಡೇಟೆಡ್ D425 in WP number 8285 of 2025. He stayed till the next date of hearing. Released on 12/6. ಅದು ಇಲ್ಲೇ ಮಾಡಕ್ ಆಗಲ್ಲ.
ಇವತ್ತು ಟ್ಯಾಬ್ ಆಗಿದೆ.
My lords, this is a matter pertaining to conduct of elections. My lords, my instructions are that they have sent the communication later. They're supposed to send in the month of June. They sent it by September. And they have said there are no ineligible voters. So 90 days we are.
Petitioner is before this court seeking for the following reliefs.
In this case, my lords, I have produced the audit reports, my lords. They have.
Oh, you are objecting. Yearly audit report.
ಏನ್ ನಿಮ್ದು objection?
Relevant page.
Page 3. Terminal page 2, my lords. In 2019-20 ಅಲ್ಲಿ 479 members ಇದ್ದಾರೆ. In next page number 3 ಅಲ್ಲಿ ಹಾಜರಾತಿ ಪುಸ್ತಕದ ಪ್ರಕಾರ ಹಾಜರಿದ್ದವರ ಸಂಖ್ಯೆ AGM ಅಲ್ಲಿ 108. Rest of the members they have not attending the meeting.
Yes.
And then my lords, page number 4 ಅಲ್ಲಿ the defaulters list, my lords, that year.
loan defaulters.
Please,
ಇದು 2020, 1920 ಇದು.
1920, next
5 years,
2020.
prior to 5 years.
Next ಹಾಕಿದ್ದೀನಿ.
2021 ಅಲ್ಲಿ.
ಹಾಕಿದ್ದೀನಿ.
2021 ಎಲ್ಲಿದೆ?
Page number 5. ಅದರಲ್ಲಿ
in this case,
ಮಿಡಲ್ ಆಫ್ ದಿ ಇದರಲ್ಲಿ ಸಾಲ ಕೈರಿಗೆ ಇದ್ದಂತೆ 488 ಜನ ಟೋಟಲ್ ಮೆಂಬರ್ಸ್. ಭಾಗ 2 ಅಲ್ಲಿ ಇದರಲ್ಲಿ ಅಂಡ್ ದೆನ್ ಮಲೋಸ್ ದಿ ಆ ಇಯರ್ ಅಲ್ಲಿ 56 ಜನ AGM ಗೆ ಹಾಜರಾತಿ ಆಗಿದೆ.
21, 22, 22, 23 also is there.
Up to 23, 24 ವರೆಗೂ ಹಾಕಿದೆ.
ಇದೆಲ್ಲ ಮೇಡಮ್.
Society has sent ಯಾರು ಸುಸ್ತಿದಾರರಿಲ್ಲ ಅಂತ ನಮಗೆ ಕಳಿಸಿದ್ದಾರೆ. But society has to clarify whether this
Now that the
audit
balance sheet has been filed, take action against the society for giving wrong information.
and we'll conduct election as per the.
They have to conduct.
Balance sheet says something, you are not aware, who appears for the society?
Not
That madam.
Madam Ansuya.
My instructions, my lord, I am permitted to withdraw them, my lord, because
Ansuya,
You are giving false information. ಅದಕ್ಕೆ ನಿಮ್ಗೆ
Society.
ಹೇಳ್ತಾರೆ ಎಲ್ಲ ಕೋರಿಲೇಟ್ ಆಗ್ಬೇಕು ಇದ್ರಲ್ಲಿ ಬಹಳ like MCA website you have to set it up.
We are working on it, my lords.
All these balance sheets 13D have to be interrelated. So they can be cross checked.
Meetings are concluded, we are implementing it is what my instructions are.
ಇಲ್ಲಿ ಬಂದೇನೋ ಹೇಳ್ತಾರೆ, we'll also believe it, you will also believe it. We'll take action and then withdrawal ಅಂತ ಬರ್ತಾರೆ. Not Mr. Sunge's fault, he is briefed wrongly what to do. But this action will be taken against the society for trying to mislead this court. ನಿಮ್ದೇನಿಲ್ಲ ಅವ್ರ ಮೇಲೆ. ನೀವು ಡೈರೆಕ್ಟರ್ಸ್
ಹೌದು ಡೈರೆಕ್ಟರ್ಸ್.
Then bad luck. Petitioners are before this court seeking for the following reliefs. Respond number 7, having entered appearance, it is contended that there are no defaulters and as such elections could be held. Learned Additional Advocate General had sought for a short accommodation to verify and make a submission. Today she submits that this information was submitted by the society belatedly in
In the month of September, my lords.
in the month of September 2025,
24,
24,
please.
and as such given 90 days time, elections would be held. Learned
And they
counsel
have submitted that there are no ineligible.
on the basis of the submission of the society that there are no ineligible voters. The Sandesh Learned Counsel appearing for respond number,
Impleading, my lord.
application.
impleading application.
ಅಲ್ಲ ಕಂಪ್ಲೇಂಟ್ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕೇ ಇಲ್ಲ ಅನ್ಸುತ್ತೆ. I don't know. They have not served a copy to me also. ಕಾಪಿ ಕೊಟ್ಟಿಲ್ಲ ನಮ್ಗೆ.
Who appears for the impleading applicant in IA 1 of 25, who claims to be
One of the member of the society.
who claim to be members of the society, has also produced the balance sheets
ಕಾಪಿ ಕೊಡಿ ಅದು.
of the society from the year 2020 to 2024, along with memo dated 25/4/2025. He submits that in terms of balance sheets, the society itself has categorically indicated that a large number of persons had not attended the meeting and therefore it violated section 22A Roman 4 of the KCS Act. His further submission is that even as per the balance sheet, there are several persons who have defaulted in payment of the loan amount. Therefore,
ನನಗೆ ನಾನು
being defaulter under section 22A Roman 5. When the balance sheet discloses so, the society cannot contend that there are no defaulters and therefore there are no ineligible voters. As such, he submit that the procedure under Rule 13D of the KCS Rules 1960 has not been complied with in a proper manner, and therefore the elections cannot be held by indicating ineligible voters to be eligible voters. Heard so and so peruse papers. The submission of the Sungelar and counsel for the petitioner is that the society has complied with the requirements under Rule 13D. The submission of Ms. K.S. Anusuya Devi and counsel for respondent number 7, society, is that they have complied with the requirements of Rule 13D. This submission is falsified by the balance sheets which have been produced by the impleading applicant, which balance sheets categorically indicate that there are several persons who are defaulters and who cannot be considered to be eligible voters in terms of Rule 13D of the KCS Rules 1960. The submission made by the society that there are no ineligible voters is contra to the balance sheets which have been placed on record. It would therefore be required for the registrar to conduct a proper inquiry into this matter and take necessary action. At this stage, Sri Rajan Kumar Sungel and counsel for the petitioner seeks permission to withdraw the above petition. I am of the considered opinion that such withdrawal cannot be permitted when the society has sought to mislead this court, on which basis orders were to be obtained by the petitioners. In that view of the matter, the above petition is kept pending with a direction to the registrar to conduct an inquiry and submit a report within a period of 6 weeks from today. Released on 26th June. Registrar Cooperative Society.
Number 10, Mohammed Ali.
IA 1 of 25 for impleading is allowed. Counsel for the petitioner to carry out necessary amendment, file amended cost act.
Lord, 10 is concerned, my lord. Statement is ready, my lord.
Yes, 10.
And my lord. Statement is ready, my lord, regarding Sarkari Gundutoku, my lord, land. And moreover, my lord.
Abolition, my lord, without issuing notice.
Petition is, my lord.
This is that construction demolition.
Please. And also, my lord, moreover, my lord, petition has not, my lord, no locus. Regarding, my lord, there is a government order, my lord. The society has been amalgamated.
Copy is served now, my lord.
Kindly see, my lord.
The AGA has filed a statement of objection. Same is taken on record. Counsel for the petitioner seeks for and is given 2 weeks time to go through the same and make his submission. Released on 5th June.
Please.
Number 11.
We announce the results, my lords. Announce the results.
Announce results. 11, declare results. It's formatted.
12.
Declare results.
Appear for the petitioner.
12. Yes.
12, my lord. Regarding, my lord, the challenging the, my lord, society's order, my lord, to suspension of the, here, my lord, petition is, my lord, not maintainable because, my lord, the appealable order, my lord, initially, my lord.
106.
Please.
Suspension order.
Please. Moreover, my lord, petitioner, my lord, challenging 2 occasions, my lord, regarding demotion of the petitioner, my lord, he earlier challenging this petition, my lord. Lordship, my lord, pass an order to approach the, my lord, K18.
Same petitioner had come earlier.
Please.
Had come earlier.
2 occasions, my lord, challenging, first of all, my lord, regarding the demotions. Thereafter, my lord, challenging the, my lord, to internal order to regarding that.
To approach the appellate authority.
Please.
Idralli?
There is, my lord, there is no interim order, my lord. There is a reason again, my lord, he filed.
Same matter, 28391.
Please, please,
ಎರಡು copy
please.
ಕೊಟ್ಟಿದ್ದೀನಿ.
I'll-
ಎರಡು ಸತಿ ಅನ್ಕೊಂಡು.
Sorry, sorry.
So this was,
Lord, this case.
Lord, none, my lord, regarding 32874 open. There is a two order.
ಅದು ಕೊಡಿ.
Madam, madam.
ಇದು ಕೊಟ್ಬಿಡಿ. ಅಲ್ಲ, ಅದು ಕೊಡಿ. ಅದು ಕೊಟ್ಬಿಡಿ.
Same petition.
ಇದು ನಾಲ್ಕನೇದು. Yes, Mr.
In that, my lord, we are not on this matter. I'm no doubt, I was still working. Only thing is the question of demotion was not.
Now the matter is before the tribunal.
Please.
Now the matter is before the tribunal, challenging the fact that I have been illegally removed as the CEO. That matter is pending. I've gone before the tribunal, that matter is pending. Now, in the meanwhile, in violation of section 28B, even though the period prescribed by the board has since expired, they continue to function and pass an order after their tenure has become over.
You raise it in that matter, pending matter. Why are you raising it here as a writ petition? The fourth writ petition you are coming, costs have been imposed on you.
No,
Still coming.
No, what has happened is, there is one writ petition which is still pending, where there is an interim order restraining me from removing me.
Which
I
is
will
that
actually-
writ petition still pending?
I have made a mention of that in the writ petition. One, I'll make a submission.
28391, 232874 ಆಯ್ತು dispose.
2839.
30490 ನು dispose ಆಗಿದೆ. ಇನ್ಯಾವ್ದು pending ಇದೆ?
One, I'll give.
26476.
23, yes,
23476.
476 of 2024.
23476 or 26476? ಇಲ್ಲಿ ಪ್ಯಾರಾ
My lord, one.
28 ಅಲ್ಲಿ 26476 ಅಂತಿದೆ.
I'll give the order. I'll give the order copy. It's there with me.
ಇಲ್ಲಿ ಪ್ಯಾರಾ 19 ಅಲ್ಲಿ 2347. ಇನ್ನ ಎರಡು ಇದಾವ.
281.
One ಇದೆ, one matter is pending where there is an interim order. I think it is 23476 of 2024.
Para 11, my lord.
11 ಪ್ಯಾರಾ 19 ಅಲ್ಲಿ 23476
Please.
ಪ್ಯಾರಾ 19 ಅಲ್ಲಿ 26476.
Yes, my lord. Lordship, this copy, I have got a copy of the order.
Connect the above matter with WP 23476 of 2024 and relist on 5th June.
Please.
Number 30. For the petitioner, Your Honor.
Yes. Yes, madam.
Your Honor, there was a caveat petition in this case. The court has ordered to serve the petition copy. We had called the respondent number 14 to 13 advocate. They were out of station, so they told us to serve to the parties. We went to Chalpatna, but the parties have refused to receive the copy. So we have served through Gmail and WhatsApp to respondent number 4 to 13 advocate, Your Honor. So filing a affidavit.
None appears for the caveator. Counsel for the petitioner submits that when the caveator counsel was approached for service, the said counsel had called upon the petitioner to serve it on respondent number 4, which has been done by way of email
Email and WhatsApp.
and WhatsApp. A submission is placed on record. Operation of Annexure A and B, he state till the next date of hearing, issue notice, learn AGA accepts notice for respondent number 1 to 3. Issue notice to respondent number 5 to 13 written by 27 June. The petitioners and respondent number 4 to 13 are restrained from any manner dealing with alienating so also.
Number 14.
Office objections to be complied by next date of hearing, failing which interim order will stand automatically.
For the
Paying
caveat
for
respondent,
petition,
my lord.
Yes, Mr. Jain.
Objection number 2 and 3 complied, my lord. For as objection number 1 is concerned, prayeral correction madbeka may be permitted in the.
Correction ಮಾಡಕ್ಕಾಗಲ್ಲ amendment ಆಗ್ಬೇಕು.
ಅಲ್ಲ, petitioner is concerned ಅಂತ ಆಗಿದೆ.
ಆಯ್ತು.
That is only
Yes, ಹೇಳಿ.
small thing.
ಹೇಳಿ.
May I make submission, my lord? In this
On
petition,
submission,
I am
my lord.
challenging the
In submission, my lord.
sale action notice.
Sir, file objection, my lord, and one more thing, my lord. Earlier also they challenged the action proceeding, my lord. This honorable granted 4 weeks to deposit 25% amount. Till today not deposited, my lord.
ಮಾಡಿಲ್ಲ.
Interim order automatically vacated, my lord. Conditioner. Therefore, I issue the fresh notice, my lord. Till today is not.
ಯಾವತ್ತು ಆಕ್ಷನ್ ಇರೋದು?
Action will be next
29/5, my lord.
next month.
Last time ಎಷ್ಟು 20%.
25% ಹೇಳಿದ್ರು, ಆದ್ರೆ ₹1 ಕೊಟ್ಟಿಲ್ಲ. 15 ಕೋಟಿ ಬರ್ಬೇಕು ಸ್ವಾಮಿ.
25% on the date of the auction.
Please, my lord.
Let them give some on or before that.
Okay,
ಇದ್ರೆ
please.
otherwise go ahead with the auction.
Allah, lordship, here, one submission, my lord. Here, my lord, the borrower asked my husband, my lord. He borrowed around 14 crores, my lord.
Mr. Jain, you had come before this court. There was a interim order passed in your favor. 25% subject to.
Allah, ಎರಡು ನಿಮಿಷ I may be permitted.
ನೀವು ಕೊಟ್ರ ದುಡ್ಡು ಹೇಳಿ, ಆಮೇಲೆ you can go. First ಈ ದುಡ್ಡು ಕೊಟ್ರ ಅಂತ ಹೇಳಿ.
My submission, my lord. ಇಲ್ಲ, ಕೊಟ್ಟಿಲ್ಲ. ಕೊಟ್ಟಿಲ್ಲ, that has become infructuous.
No equity.
Reason is that.
It is not become infructuous.
Allah, reason is that, my lord.
This stay order is only a discretionary order.
Please.
Your equity, what you have done, your conduct will play.
Please.
If your conduct is this, no order.
Lordship, may I make submission 2 minutes, my lord? I will convince you, lordship.
ಹೇಳಿ.
There is serious legal infirmity in the execution proceedings, my lord. The award is passed, my lord. It is a limitation order on its execution, my lord. Award clearly says that, my lord, first they have to exhaust the mortgage property. Then if anything recoverable, then they have go against the guarantors, my lord. This is a clear award, my lord.
ಎಲ್ಲಿದೆ ಅದು?
Yes, my lord. Award, lordship, kindly see page.
First go against the principal debtor and then the guarantor and
Yes,
all.
my lord.
Order
Page
ಇದೆ.
number 50, my lord.
50.
Annexure E, my lord.
Order. Relevant portion.
Then portion of it. Page number 73, my lord.
Yes.
Paragraph 2, may I read now? ಒಂದು ವೇಳೆ ಮೇಲ್ಕಂಡ ಡಿಗ್ರಿ ಮೊದಲು ಎದುರಿಯವರು ಪಾವತಿಸಲು ತಪ್ಪಿದಲ್ಲಿ ಎದುರಿಯವರು ಸಾಲ ಪಡೆಯಲು ಆಧಾರವಾಗಿ ನೀಡುವ ಸ್ಥಿರ ಸ್ವತ್ತುಗಳನ್ನು ಮಾರಾಟ ಮಾಡುವ ಮೂಲಕ ವಸೂಲು ಮಾಡಿಕೊಳ್ಳಲು ಆಧಾರ ಮಾಡಿದ ಸ್ಥಿರಾಸ್ತಿಯಿಂದ ಬಾಕಿ ಹಣ ವಸೂಲಾಗದಿದ್ದಲ್ಲಿ ಎದುರಿಯವರ ಇನ್ನಿತರ ಚರ ಮತ್ತು ಸ್ಥಿರ ಸ್ವತ್ತುಗಳನ್ನು ಜಪ್ತು ಮತ್ತು ಮಾರಾಟ ಮಾಡುವುದು. Here, my lord, the property is worth around 100 crores, my lord, is mortgage for 14 crores, my lord. Wherein they have already sold 3 properties for 32 crores 65 lakhs, my lord. Even for very meager market price, my lord, even without getting assessment of market value, more property 32 ಕೋಟಿ 65 ಲಕ್ಷ ಮಾರಿದ್ದಾರೆ. 14 ಕೋಟಿ ಲೋನ್ ತಗೊಂಡಿದ್ದು. My husband died in the accident, my lord. There are several properties, my lord, which are mortgage. Lordship, kindly see annexure P, my lord. I have produced a list of properties along with market value, my lord.
Page?
Page number, my lord, 168. This serial number 1 to 7, my lord, they have sold for 32 crores 65 lakhs. Then item number 8 may kindly be produced, my lord, 169 only. That is a commercial land, my lord. It comes around 48 crores, my lord. They have attached this property. They have issued sale notice, but they are absolutely not providing any status to me, my lord. They are not allowing in the bank. Then further serial number, my lord, serial number 9, 98/8. Again, they have issued attachment notice as well as sale notice. Status update illa sir. Then serial number 10, my lord. There's again 1 acre it stands in the name of principal debtor. Then 11, my lord, 11 and 12, there are 24 residential sites which are clearly mortgaged in favor of the bank. They have not taken steps in that, those properties. Serial number 13, my lord, again 3 acres. These are all, my lord. Then residential property also there, my lord, serial number 17. All these worth around 50, more than 70 crores of properties are mortgaged still remaining, my lord.
What is the amount due?
Why?
Total,
It's
as on
15
date,
crores there.
15 lakh crores, my lord.
As on date.
Please, ma'am. As per action notice dated, annexure A, my lord.
Then why are you wanting to auction all these properties?
ಎಲ್ಲದಕ್ಕೂ ಮಾಡ್ತಾ ಇಲ್ಲ ಸ್ವಾಮಿ, ಈ ಪ್ರಾಪರ್ಟಿ ತಗೊಂಡಿದೀವಿ.
ಯಾವ ಪ್ರಾಪರ್ಟಿ?
ಇವಾಗ ಶೆಡ್ಯೂಲ್ ಕೈಂಡ್ಲಿ ಸಿ page number
It is
29.
my dwelling house, my lord. I am residing in my, it is self-acquired property.
25.
Till number 22 ಅಲ್ಲಿ ಹೇಳಿದ್ದೀನಿ.
29 page number, my lord.
ಅಲ್ಲಿ
27 schedule, my lord, in notice.
Oh, sorry, my
Open
lord.
notice.
27, my lord.
Page?
Annexure A.
27, my lord.
Page 27.
Schedule is.
ಯಾವ ಪ್ರಾಪರ್ಟಿ?
It is situated at Ravindra Nagara, Shivamogga, my lord. It is my dwelling house. I am widow residing in that house.
Why do you want to sell it? Dwelling?
They are taking away the every properties, my lord.
Item number 7 to 13 ಬಗ್ಗೆ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ ತಗೊಂಡಿತ್ತು ಸ್ವಾಮಿ. ನನಗೆ ಏನಾಗಿದೆ, ಕೆಲವು ಕಂಟಿನ್ಯೂಸ್ ಕೇಸ್ ಮೇಲೆ ಕೇಸ್.
ಯಾವ ಪ್ರಾಪರ್ಟಿ ಸೇಲ್ ಮಾಡಬಹುದು ಹೇಳಿ?
ಅಲ್ಲ, ಇವಾಗ ಇವ್ರು ಕೇಳ್ತಾ ಇರೋದು
15 crores ಗೆ ಅಂದ್ರೆ the only property which can be sold is sale number 8.
ಅಲ್ಲ, ಇವರು ಮೋಸ್ಟ್ ಪ್ರಾಬಬ್ಲಿ ಎಲ್ಲ
8 ಗೆ you won't have any objection.
8 ಮಾಡಬಹುದು. ಉಳಿದ ಪ್ರಾಪರ್ಟೀಸ್ there are 24 sites there, my lord.
ಅಲ್ಲ,
ಬಾಕಿ ಎಲ್ಲ ಚಿಕ್ಕ ಅಮೌಂಟ್.
ಅಲ್ಲ, 24 sites ಇದೆ, ಅದರಲ್ಲೇ ರಿಯಲೈಸ್ ಆಗುತ್ತೆ.
50 ಲಕ್ಷ ಎಷ್ಟು ಅಂತ ಮಾಡಕ್ಕಾಗತ್ತೆ?
ಅಲ್ಲ, ಸೈಟ್ ವ್ಯಾಲ್ಯೂ.
So only serial number 8 is available, which has a considerable value. So you won't have objection to sell serial number 8.
Yes, my lord.
But
they have to assign the market value and
ಒಂದು ಮೇಲೆ ಒಂದು ಕೇಸ್ ಆಗ್ತಾನೆ ಇದೆ ಸ್ವಾಮಿ. ಸಿವಿಲ್ ಕೋರ್ಟ್ ಅಲ್ಲೆಲ್ಲ ಕೇಸ್ ಪೆಂಡಿಂಗ್ ಇದೆ.
Record Mr. Jain's submission that he won't have any objection for selling serial number 8 at page 169.
We'll take instruction.
Instructions ತಗೊಳ್ಳಿ.
Please
pass over.
Please.
You also get instructions properly. We'll record your statement.
Please.
Affidavit ಅಂದ್ರೆ ಶಿವಮೊಗ್ಗದಿಂದ ಬರಲ್ಲ. We'll record your statement on instructions. So serial number 8 at page 169, you won't have objection. And
You
they
have
won't
to
sell
assign
this.
the market value, then ಎಲ್ಲ SR value ಮಾರ್ಬಿಟ್ಟಿದೆ.
That they will follow.
To the known person.
ಬೆಂಚಿನಿಂದ ಇಲ್ಲಿವರೆಗೆ ಹಿಂಗೆ ಕೇಸ್ ಹಾಕೊಂಡೇ ಬರ್ತಾರೆ ಸ್ವಾಮಿ. ಒಂದು ರಿಕವರಿ ಮಾಡಕ್ ಆಗ್ತಾ ಇಲ್ಲ.
ಕೇಳಿ serial number 8.
Please, I take instruction. Oblige.
Then the regular serial number 15.
15, my lord.
Yes.
Court may kindly recollect an interim order was made permitting us to exercise our franchise. In respect to the same society, this honorable court has already directed the result to be announced. I request the court to kindly see page 8.
You are challenging the constitutional validity.
That is the only difference between the other case and this case.
So you want to continue to challenge or you want to give up the challenge?
It may be kept open. It may be kept open.
Kept open andre here you won't insist on challenging.
Yeah.
Your prayer A.
Yes, yeah,
you will give up.
I respectfully agree. That's the only difference between the other case.
If you give up your prayer A, then we can consider prayer 1, Roman 1. We can consider Roman 2.
I respectfully.
Yes. Any objection for declaration of result?
In fact, court may kindly recollect, I am ready to address, but the learned government advocate took time to file objections.
My lord, it's matter already, my lord, adjourn on 12/6, my lord.
No, if they give up Roman 1.
Please, please.
We can declare the result.
Please.
My humble
Subject
request.
is Lokre not having objection.
Yes, we have an objection.
Yeah, objection.
Because the previous order has been challenged in the writ appeal, it's pending. It's likely to be moved in the vacation. Maybe taken up on the same date which was listed, that may be matter could be disposed.
12/6 is the court all moved.
Yes.
Allah, if they want to challenge, let them challenge it.
Come on the same
Kindly
day.
see the order that has been passed
Why are
in respect to the same.
What is your, are they the violators of 20A4 or 20A5?
20, A4, my lord.
A4, We are liberal on that.
No, my lord, but
A5 we won't accept.
I'll go through and make submission, but only request is that because the previous order itself is under challenge. And
See,
they
A4,
were-
COVID time, they could not attend the meeting is what we have held.
Moreover, the law is not retrospective. It can't operate prior to the, because our term commenced much prior to the amendment. They can't pull the legislation.
If my
to a
pleading
period.
application is allowed, I'll make submission.
No, I'm opposing that application.
Then we'll have to hear on the impleading application before we come to the meeting.
Please,
Yeah.
Yearly. Any IA number?
IA number 2 of 2025, may
You have
kindly
filed
be
your
allowed.
objections?
ಮಾಡಿ-
ಮಾಡ್ಬೇಕಾ?
Connected matter like.
ಮಾಡ್ಬೇಕಂದ್ರೆ ಅವ್ರಿಗೆ ಏನ್ ಬೇಕು ಅದೇ ಆಯ್ತು. Land Council for the
Connected
petitioner
matter
seeks
also we
for
filed.
and is granted 3 weeks time to file objections to IA 2 of 25, released on 12/6.
ಇದು ಸೇಮ್ ಸೊಸೈಟಿ ತಾವು ಆರ್ಡರ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ದೀರಿ ಟು ದಟ್ ಲಿಮಿಟೆಡ್ ಎಕ್ಸ್ಟೆಂಟ್ ಮೈ ರಿಕ್ವೆಸ್ಟ್.
But we can't distinguish now in the ballot box. So
ಅಲ್ಲ,
until orders
that has
are,
been already done. Kindly see the order that has
that
been.
may be,
Ah.
but until all of them are in the same box,
That
No, they're-
order
they're-
may continue, my
They're
lord.
kept separately.
ನಿಮ್ದು ಬೇರೆ ಬಾಕ್ಸ್ ಅವ್ರದ್ದು ಬೇರೆ ಬಾಕ್ಸ್ ಇದೆಯಾ?
No, that previous
Kindly see the order that has been passed in there.
previous order is properly made. It will not be disturbed.
Put up.
If an order is
Order
passed
copy
in
could
this
read.
case, it will be amounting to disturbing that previous order.
Kindly see the order dated 3rd April, passed in WP 6285 at page 8.
6285. 6285 is not here.
No, I've given a copy.
60
The
Not
court of.
put up.
285.
Kindly
Yes.
see the operative portion
Hmm.
at 2.
Yes.
The returning officer is directed to announce the result within 7 days of the receipt of a copy of this order by taking into account the votes cast by the petitioners in the above matter. In the event of any proceeding being filed in relation to the results of the election under section 70(2), all the contentions raised herein and any that may be raised are left open for consideration in accordance with the applicable law. This order is sufficient for
Well, this order has been passed in that matter.
that matter in respect of the same society.
Same society.
In respect of the same allegations against the petitioners therein.
Therein.
The
But
only
now-
difference is they challenge the law.
Now there is an opposition.
ಅಲ್ಲ, only challenge ಇಲ್ಲ, ಅದರಲ್ಲಿಲ್ಲ, opposition ಏನಿಲ್ಲ.
ಇವಾಗ Mr. Lokra is
ಅಲ್ಲಿತ್ತು, ಅಲ್ಲೂ ಹಾಕಿದ್ರು.
Allo
ಅವ್ರು ಅರ್ಜಿ
hakide.
consider
That
ಮಾಡ್ಲಿಲ್ಲ.
application was filed for impleading in that case also.
It was
But
not
because
entertained.
they pressed for the order was passed. Anyway, on that ground and other grounds, writ appeal is pending. I request this honorable court, same order which was passed to call on the previous date of hearing, next date of hearing, it may be called. Meantime, we'll secure
The
one.
announcement
I'll
of,
give up the prayer. I'll give up the
That may
prayer.
be recorded, but no orders may be passed.
ಅದ್ ಕಷ್ಟ ಆಗೋಗುತ್ತೆ ನಿಮ್ ರೆಕಾರ್ಡ್ ಮಾಡಿದ್ರೆ ಆಮೇಲೆ. You will get benefit of both
No, that submission is
without you
made.
getting anything.
That
ಏನಾಗಿದೆ ಈಗ?
submission is made, it may be recorded.
Similarly circumstanced petitioners, they came first and law was challenged. The next batch felt it is not necessary since it is already under challenge. ಈಗ ನಮಾಜ್ ಮಾಡಕ್ ಹೋಗಿ ಮಸೀದಿ ಕಡ್ಕೊಂಡಂಗಾಗಿದೆ ಈ petitioners.
Lokra ಅವ್ರು ಬಂದ್ಬಿಟ್ರು ಮಧ್ಯದಲ್ಲಿ.
All contentions were kept open, my
So,
lord. Lordship
it may be-
directed the parties to.
Anyway, there is already a
If
protection
Mr.
given.
Lokra were to agree, we'll pass the same order.
No, my
But
lord.
if he is opposing this, then we'll have to
This
hear.
matter, I am
I leave it.
seriously opposed.
We'll have to hear.
I'll leave it to them.
Objections to IA 1 of 20, 2 of 25, released on 12/6.
Please.
I appear for petition in this matter, my lord.
Hmm.
LRs of respondent number 3 have filed impleading application, have not received the copies as well, so I don't know who are the LRs.
My lord, I am for the impleading respondents number 3, my lord. We have served with the copy, my lord, but I think there is some confusion. I'll give her
Give her-
another copy.
Lord Council who has filed an application to bring the legal heirs, IA 1 of 25, seeks for 2 days' time to furnish a copy of IA 1 of 25 and the counsel for the petitioner. Counsel for the petitioner seeks for and is granted 2 weeks' time to make payment of necessary process fee in respect of unserved respondents, as also to file applications in respect of other deceased respondents. If process fee is paid, registry is directed to issue notice to unserved respondents returned by 27 June.
Interim order. will be-
Interim order earlier granted is extended till next day.
Grateful, my lord, obliged.
17.
Here, Basavarajappa.
Modification in
RTO report ಏನಿದೆ? The Registrar Judicial has placed a report on record. The same is accepted. None appears for the petitioner. Relist on 27th June.
Here, number 18.
18.
For petitioner. Challenge the.
ಏನ್ recall ಮಾಡಬೇಕು Mr. Reddy?
That order is recalled, the lordship.
Recall ಆಗಿದೆಯಾ?
ಆಗಿದೆ, ಅದು dispose ಆಗಿಲ್ಲ ಅಷ್ಟೇ. Lordship has said, take any action.
ಎಲ್ಲಿ recall ಆಗಿದೆ?
Lordship, because the CEO has not taken the summons ಅಂತ. Lordship has passed an order for which we have filed an IA for recall. Lordship has said not to take any action.
Registrar of Cooperative Society is directed to take action.
Thereafter, my lord.
Last date of.
Last date of hearing, my lord, your lordship.
Recall ಎಲ್ಲಾಗಿದೆ? He only refrained from court taking action. Registrar to take action is there. You filed an application for recalling this order.
Recalling the order, my lord, with respect of taking action.
That registrar will take care. Registrar should take care in a few matters, then only it will work. We are not going to recall this.
But I have filed an
Additional action that we wanted to take because of what statement he made, we did not. Registrar will make an inquiry and issue necessary instruction to all the CEOs to appear in matters. Unfortunately, it was your CEO ashte.
This is refusal, my lord, to take summons. File an affidavit stating the reason, my lord, how it has happened.
ಏನಂತ affidavit ಹಾಕಿದ್ದೀರಾ? He can see what is being given to him. He doesn't have to know what file, what papers are being given to him.
No, the papers, they only shown, my lord, it's not even summons, my lord. They only given me an acknowledgement and saying that it has to be signed.
So let there be an inquiry into this. Let him conduct an inquiry.
Since I have appeared, my lord.
Good, thank you. One Cadbury's 5-star bar ಕೊಟ್ಬಿಡಿ. ಹೇಳಿ, what is the merits? IA-2 of 25 has been filed for recalling the order dated 9/4/25. This court has consciously directed the Registrar of Cooperative Societies to take such action as may be necessary after conducting an inquiry. And as such, I do not find any reason to recall the said order. IA-2 of 25 stands dismissed. The time granted to the registrar to file the report is extended by 4 weeks. Report shall be filed on or before 5th June.
Yes, my lord, the order on your F is challenged, my lord. Passed under section 31(1) of the act. The order has been passed on the ground that, my lord.
Records ಬಂದಿದ್ಯಾ?
Please.
ನೋಡ್ಕೊಂಡಿದ್ದೀರಾ records?
ಎಲ್ಲ ನೋಡಿದೆ. ಇಲ್ಲಿ the only two submission is that, my lord, petitioner number 2, according to him, he has not tendered his resignation. And one Nagraj has tendered his resignation as per Anejuri on 21/2/2025, and in his place petition number 7 has been co-opted by resolution dated 7.
Nagaraju is petition number 1.
Please, my lord.
Number 1, Nagaraju.
Nagraj is the president, and yes, there is no allegation. Here, my lord, except the respondent petition number 2, all others are still, they have not tendered their resignation and they are not claiming anything, except petition number 2. Petition number 2 is stated to have tendered his resignation, whereas according to him, he has not tendered his resignation, and he wanted to continue. And so far as another petition number 7 is concerned, my lord, he was co-opted in place of one Nagraj, son of son of
Resolution is focused.
Nagraj, son of Puttaswamy Gowda, Puttaswamy. So
ರೆಸಿಗ್ನೇಷನ್ ಕೊಟ್ಟಿರೋ ಶಿವಕುಮಾರ್, ಮಾರೇಗೌಡ, ರಾಜು,
ಹೌದು,
ಶಿವಣ್ಣ, ಬೈರೇಗೌಡ, ನಾಗರಾಜು.
ಹೌದು. Out of them, my lord,
ಸಿದ್ದೇಗೌಡ.
ಸಿದ್ದೇಗೌಡ, ನಾಗರಾಜು
7 ಜನ ಆಯ್ತು.
7 ಜನ ಇಲ್ಲ, 6 ಜನ. ಈ 6 ಜನರಲ್ಲಿ ನಾಗರಾಜ್ ಅನ್ನೋರು ಮೊದಲನೇ ರೆಸಿಗ್ನೇಷನ್ ಕೊಟ್ಟಿದ್ರು. ಇಟ್ ವಾಸ್ ಅಕ್ಸೆಪ್ಟೆಡ್ ಅಂಡ್ ಇನ್ ಹಿಸ್ ಪ್ಲೇಸ್ ಪಿಟಿಷನ್ ನಂಬರ್ 7 ವಾಸ್ ಕೋಆಪ್ಟೆಡ್. ಸೊ ಮತ್ತೆ ಅವ್ನು ಕೋಆಪ್ಟ್ ಆಗಿದ್ದಾದ್ಮೇಲೆ ಅವ್ರ ರೆಸಿಗ್ನೇಷನ್ ಒಂದ್ಸಲ ಅಕ್ಸೆಪ್ಟ್ ಆದ್ಮೇಲೆ ಮತ್ತೆ ಕೊಡ್ಲಿಕ್ಕೆ ಬರೋದಿಲ್ಲ. So far as Bairegoda is concerned, my lord, he has not tendered his resignation. Shivkumar, Maregoda, Raju, Shivana is concerned, my lord, we are not claiming anything.
My lord, as per my instructions, my lord, there is no such resolution is bogus, my lord, regarding that, my lord. And also, my lord, 11 members are selected, my lord, 6 members are given the resignation.
Only 11, total 13.
My lord,
Total 11, my lord. 11 is, my lord, the 6 members has been given resignation, my lord.
11 al 6, 5 ಆಯ್ತು.
Please, my lord, there is a, my lord, there no quorum, my lord, we have appointed the special officer. Annexure, my lord, F, my lord, 39, my lord, clearly stated. And original records also here.
My lord, according to their own pleadings, my lord, the resignation was given on 5/3/2025 and 6/3/2025.
Correct.
My lord, this resolution which they are purporting to co-opt another person to have quorum, my lord, is on 7/3/2025. And the proceedings, we have, CO is present, my lord, with the minutes of the book. These resolutions which they have produced and the meetings, my lord, in the book, completely different. Yes.
The Nagraj, said Nagraj son of Puttaswamy has tendered his resignation on 21/2/2025. So meeting was called on 7/3.
And this, my lord, this book was taken, my lord, by Mr. Nagraj and tried to, my lord,
3/3/25 ಅಲ್ಲಿ ಬಂದ್ರೆ ಮುಗ್ದೋಯ್ತು.
6 is already, my lord, the board has gone.
No. Board, according to them, the resignation is dated 6/3. 6/3. Whereas, my lord,
ಯಾರು?
Nagraj.
ಶಿವಣ್ಣ, ಬೋರೇಗೌಡ, ನಾಗರಾಜು on 6/3.
Even Nagraju has also tendered resignation and 6/3. Whereas even according to his my lord, he has tendered his resignation on 21/2/25. So that resignation has been considered on 7/3/2025.
ಎಲ್ಲಿದೆಯಪ್ಪ co-option?
My lord, your lordship may kindly see, my lord,
Annexure
annexure B, the 7/3/2025.
In page 20, my lord, item
That
number
resolution
6.
does not carry any
Co-option.
co-option, neither there is a quorum, my lord. Your lordship may see that annexure B which they have produced.
So
Completely
7/3
different.
meeting ಎಷ್ಟು ಜನ ಅಟೆಂಡ್ ಮಾಡಿದ್ರು? ಬರೀ 4 ಜನ.
4 ಜನ.
4 ತಮ್ಮ ಇಂಪ್ರೆಷನ್ ಇದೆ.
Some impression is a knock ಇದೆ. And that too, my lord, this was written by one Mr. Nagaraj has taken this book. And he has written and tried to, my lord, create. This was not, then CEO went to his home, said that the book is not missing, where is it? Then he bought it. Then he saw this. Then thereafter, my lord, he did not take any action with regard to that because there was no quorum. He has kept quiet. Later, my lord, now your lordship may kindly see annexure B. Annexure B, they try to, my lord, similar page 14. They try to create the same thing in different book. 17, my lord, page 17.
ಇದೆಲ್ಲಿಂದ ಬಂತು ಮಿಸ್ಟರ್ ರೆಡ್ಡಿ?
Yes, that is the question.
Annexure B.
It has been furnished by the petition number 1.
And these are
Please,
not
Miller.
the same.
Please, Miller.
The minutes in the book and the minutes you have produced are not the same.
I've not gone through that minutes book, Miller. Whatever the document that has been furnished by the petition number 1, I have produced it, Miller.
No signature, nothing.
No, you will, we are not finding any
Please,
fault with the
madam.
advocates.
I-
Because we know in these matters now, by now we know. Your parties are more intelligent than the court also. They are the most intelligent people. So if they are so intelligent, they will have to face this.
Definitely.
ನೀವು ಅವ್ರೇನೋ ತಂದು ಕೊಡ್ತಾರೆ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ನೀವು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ತೀರಾ. ಏನ್ ಇದು ನಿಜಾನಾ ಕರೆಕ್ಟಾ ಅಂತ ಒಂದೆರಡು ಸತಿ ಕೇಳ್ಬೋದು ಅಷ್ಟೇ. ಇದು ಸುಳ್ಳು ಅಂತ ನೀವು ಹೇಳಕ್ಕಾಗಲ್ಲ. ಬಟ್ ಇವಾಗ ಸುಳ್ಳು ಆಗಿದೆ ಅದು. ತೋರಿಸಿ ಅವ್ರು ಪಾಸ್ ಓವರ್. ಇದು ಒರಿಜಿನಲ್ ಕೊಡಿ, ಇನ್ಸ್ಪೆಕ್ಷನ್ ಕೊಡಿ ಅವ್ರು ಪಾಸ್ ಓವರ್. If that is the case, then we'll have to recall 9/4/25.
Yes, my lord, that is the CEO is also present, my lord.
Then we'll have to recall 9/4/25.
They have done something, my lord, therefore.
ನೋಡಿ
Right.
ಆರಾಮಾಗಿ ನೋಡಿ ಅದು.
90. Pradeep JS.
Petitioners,
Permission to prosecute, why?
petitioners are site owners of several sites in the land now resumed under annexure A and B. They were not parties
1/25
before
has been filed by site owners who claim to have purchased the same from the purchaser, and they are not being parties to the proceeding before the AC or DC.
DC.
Since I-1/25 is allowed, the petitioners are permitted to prosecute the matter.
51 years in delay. Delay in
EGA accepts notice for respond number 1 to 3. Issue notice to respond number 4 to 13, returnable by 27 June. Operation of annexure A and B is stayed till the next date of hearing. The petitioners and respond number 4 to
My lord,
13 are restrained from
Here
any
may I make
manner
a submission,
alienating,
Lord?
dealing
Now,
with, encumbering the property.
let there not be any restriction on the petitioners because
Also, you can't alienate. Released on 27th.
my lord, several of them have already mortgaged the properties. Even if there is a discharge, there might be a contempt.
Henceforth. The order will be from today only.
Instead of encumbering, my lords, could there be a not to alienate is
Don't encumber also by any agreement of
even
sale.
if a mortgage is discharged, there will be an encumbrance, my lord.
Mortgage discharge is not encumbrance, it's clearance of encumbrance. It's the reverse. You don't create any encumbrance.
Serial number 20.
This petition is by the purchaser, my lord. The respondent number 2, after an inordinate delay of 60 years from the first sale transaction, has allowed the
Prepare for odd three,
petition
my lord.
filed by the respondent number
AGA
3,
accepts
my lord.
notice for respond number 1 and 2.
R3.
Wait for R2.
3, my lord.
3. Ms. Ashika Gurumat, who has filed caveat for respond number 3, accepts notice for respond number 3. Issue notice to respond number 4 to 7, returnable by 27th June. Operation of annexure J and H are stayed till the next date of hearing. Petitioner and respond number 3 to 7 are restrained from any manner alienating, dealing with, encumbering, so and so, from 27th. Process fee by 5th May.
Much obliged.
21.
Petitioner. Lord, 20 is concerned, my lord, connect with serial number 7, my lord.
20.
Please, please.
7.
Please. Serial number 7, my lordship, I already passed an order, my lord, the same serial number, different.
HN Basuraju.
Please. This is also, my lord.
20 connect to 7.
Please.
That's for petition serial number 21. Challenging annexure Q, my lords, where I've been demoted from senior assistant to junior assistant. My lords, on the respondent 3 order.
Challenging the order of
the
25/9.
25.
Also, my lord,
And
sorry.
AGA accepts
I've
notice.
challenged this before the society, that is respondent number 2.
106, you'll have to go.
Hello.
No, my lord, 70.
70.
One second.
Dispute.
Now that has been, I've filed in stay application in before the respondent number 2. Now they say it will be considered with the merits, my lord. On that order, I have approached Karnataka Appellate Tribunal also. Even they have the same contentions. On that basis, I'm here before this. Your lordship.
Consider and accept or reject. You can't say I'll consider with merit when there's a suspension.
Regarding, my lord, promotion matter, my lord, this is to kindly see, my lord.
What is the interim order that you sought for before the KAT?
To stay on the annexure Q, my lords, where I've been demoted from senior assistant to junior assistant.
Should you not consider it?
Annexure Q, page number 99.
Regarding, my lord, once the final order, main order, both of them of the same. my lord.
ಅದುವರೆಗೂ suspension ಇರಬೇಕು.
My lord, some fraud.
Suspension alla summa. Demotions.
Demotion.
Please. Regarding once, my lord, demotion order is decided, my lord.
Either accept
Please.
or reject.
Please.
My lords, one small submission. There was a criminal case against this. This honorable court has quashed that proceedings, which is against me.
Criminal proceedings are different.
That's a submission.
Those are different.
The service matter, my lord, is not applicable to, my lord, criminal proceedings. Sir,
But ಅವ್ರು ಅಲ್ಲೂ ಹೋಗಿದ್ದಾರೆ.
please,
ನೀವು ಕನ್ಸಿಡರ್ ಮಾಡಿಲ್ಲ.
lordship, my lord, direction.
So we will direct respond number 2 to consider the request. And AGA accepts notice for respond number 1 and 2. Notice to respond number 3 is dispensed with in view of the proposed order to be passed. Petitioner is before this court seeking for the following reliefs. Petitioner had approached the second respondent challenging the order of demotion where an application for stay of the said order had been filed. The second respondent, while order dated 4/12/2024 at Annexure S, had indicated that the same would be considered along with the main. The petitioner filed an appeal before the Karnataka Appellate Tribunal. The Appellate Tribunal also, while its order dated 23/25, had indicated that the said application for stay would be considered along with the main. The petitioner having challenged the demotion and an application for stay having been filed, it was required for both the respond number 2, firstly the respond number 2, and thereafter the KAT to consider the application for stay on merits and pass necessary orders, rather than postpone the consideration thereof until the final hearing. In that view of the matter, I pass the following order. Writ petition is partly allowed. The matter is remitted to the second respondent to consider the application of stay filed by the petitioner, which shall be so considered and necessary orders passed within a period of 60 days from the date of receipt of the copy of this order.
Great.
22, SP Giridhar.
Counsel appearing on behalf of the petitioners, my lords.
Yes. Yes.
My lords, the petitioner in this present writ petition had basically acquired the Schedule A property through a sale deed, my lords. But the respondent number 5 in the present writ petition, he had acquired the survey number 14, a plot of land measuring 2 acres and 20 guntas that was being at a fixed price through an open auction. That is, may I request the court to kindly see the paragraph number 1 of the writ petition, my lords, as at page number 4. So there, my lords, the market determined and sanctioned by the government, which property is more fully described in the schedule to the present writ petition. And furthermore, what happened? The total purchase amount of rupees 445 was paid to the government treasury on 25/3/1994. The said cultivation certificate is hereby produced as at Annexure A. Later on, what happened? What has happened, my lords? That is, in paragraph number 3 of the page number 5. That is, the respondent number 5 executed a deed of gift in respect of the scheduled property in favor of his wife, duly registered in so and so, and the said gift deed is being produced under here at Annexure B. Further on, what has happened? Another purchaser has come wherein an agreement to sell was being executed. Due to the inclined, as at page number 6, paragraph number 5, the holder of the agreement to sell was not being inclined to the purchase of the scheduled property. Hence, what he has done is that He had instituted a suit registered as original suit number 56/2017. So the said
Her
judgment.
wife also joined the execution of the agreement of sale.
Indeed, my lords. So the said judgment and decree is produced here with
What
us.
is your
Annexure C.
relationship with respondent number 5?
My lords, I am the purchaser of the property, my lords.
Under a gift deed.
Not under a gift deed, under a sale deed, my lords.
Where is the sale deed?
The sale deed is produced here with us, Annexure E, my lords. Annexure E at page number
77.
This was after the
77
suit
to
was
83.
filed in OS number 56 by the other purchaser.
by the other
It's your
purchaser.
wife and respondent number 5.
Indeed, my lords. So
And
that
you purchased it during the pendency of the said suit.
during the pendency of the suit, the whole 4 lakhs amount was being repaid back to the holder of the agreement
All
to
of
sell.
you collude with each other.
No, my lords. Cancellation of agreement to sell was being executed. The same also have been produced.
Yes.
So that is being produced here with us, Annexure E, cancellation of the agreement to sell between Dasa Shetty and the other party, that is the holder of the agreement to sell. Later also,
File your objections.
later on what has happened is that
And
the
AGA
respondent
accepts
number
notice for
7, my
respondent
lords.
number 1 to 4. Issue notice to respondent number 5 to 7, returnable by 19th June.
My lords, entry order maybe.
Sorry, not in this.
No, my lords. So the land has already been.
You are colluded, you are trying to do a lot of things which will come out.
No, we have not colluded, my lords. Agreement, cancellation agreement was being executed.
You'll see once they come.
My lords, the lands will be vested back to the government, my lords.
Yes. Mr. Anandeshwara?
After 45 years, the petition is filed. It's a sale 28/11/1966.
Why so many petitioners?
Uh,
Sites agidava?
It was converted, sold as sites.
Sites.
We were not made parties, we came in late.
Petitioners ಇದೆ sir. Respondents ಇಷ್ಟೊಂದು ಜನ ಇದ್ದಾರೆ.
WP 9254 of 25.
Why so many respondents?
The other purchasers, as office took the objection that all of them have to be
And
made
AGA
parties.
accepts notice for respondent number
1 and 2.
1 and 2. Issue notice to respondent number 3 to 71. Returnable by
3, your lordship may confine it to 3 to 7. We are filing a memo.
7. Returnable by 27th.
It's good.
Notice to respondent number 8 to 71. Is dispensed with in view of the memo filed by the counsel for the petitioner on the ground that respondent number 8 to 71 are other purchasers in the layout form in the subject property.
Please.
And there is no interest contra that of the petitioners in the present petition. The operation of annexure A and B is stayed till the next date of hearing. The petitioners and respondent number 3 to 7 are restrained from any manner alienating, dealing with, encumbering the properties also. Process fee by 5th May.
Please. There is, I will give the connected number, my lord.
Pepper D, who has filed affidavit for respondent number 4 is directed to accept notice for respondent number 4. None appears for respondent number 4 today.
Please. It may be posted
Innondu
along
other idea, connected matter idea.
9254 of 25.
Connect with WP 9254 of 2025. 196 madvi idನ್ನು.
24. Lady Prasad Shetty.
That's one number 5 in this case.
Yes.
My lords, these prayers are infructuous is my submission. My lords, annexure G is questioned. G
What do
is
they want?
questioned wherein inspection was fixed on 16/4/25. My lords will get in the first column, annexure G, page 89.
12/4, all dates have passed.
16/4 is the primary society before my lords, Antar Sante. 16/4 is already lapsed and they have filed the petition itself on 28/4.
Inspection is done.
Yes.
Allala. Not inspection is, according to me, inspection is not done still.
La ಮಾಡಿದೀವಿ ನಾವು. We have finished the inspection. They kindly see their prayer.
ಹಿಂಗ್
ಪ್ರೇಯರ್
ನೋಡ್ಬೇಕು.
ನಾನು ಅದೇ ಇದನ್ನ ಇನ್ಸ್ಪೆಕ್ಷನ್
Annexure
Can't be a
G,
dispute on such a fact.
Because Annexure G has spent itself.
ಒಂದು 2 ನಿಮಿಷ ನಾನು ಹೇಳ್ಬಿಡ್ತೀನಿ. After here not your lordship. 64 inquiry was initiated. 68 order was passed. There was a finding against one Anusuya, who was the cooperative development officer then. Now the present DRCS, who has passed the impugned order. There was a finding against her. She preferred an appeal against 68 order. She preferred an appeal before the DRCS. Appeal was dismissed. Then she preferred a writ petition. Writ petition was allowed. Matter was remitted back to DRCS to hold fresh for a fresh inquiry. Thereafter, the 68 order itself was set aside. 64 all ಏನೇನಾಗಿದೆ ಅದನ್ನೆಲ್ಲ set aside. That will inure to the benefit of this petitioner society also. Finding against her was set aside and entire 68 order was set aside. I have produced this.
Where is that order? Entire
That order
68.
not at page annexure F, my lord. Page 85. Operative portion is at page 88. This is filed by Anusuya. 85. This is not only against the petitioner, not that is set aside. ಒಂದನೇದುದಾರ ಆದೇಶ ಸಂಖ್ಯೆ ಸೋ ಅಂಡ್ ಸೋ ದಿನಾಂಕ 6/10 ನಾನು ವಜಾಗೊಳಿಸಿ ಆದೇಶಿಸಿದೆ. ಈ ಆದೇಶವನ್ನು ಉಲ್ಲೇಖಿಸಿ ಸೋ ಅಂಡ್ ಸೋ.
Where is the order dated 6/10/20?
Or 6/10 is the 68 order, no?
ಎಲ್ಲಿದೆ?
At
Separate
page,
orders ಇದೆಯಾ?
at page 55 annexure D.
55.
Operative portion is 61. This is the 68 order. 6/10/2020.
64.
Page 61. Now against the.
So it's a common order.
Yes, now against the same charge, they want to hold an inquiry upon taken inspection by the same officer who had filed the appeal. Now she is the assistant registrar.
My lords, may kindly see what is it that which
No,
has been done under annexure G. It has nothing to do with 64, it's nothing to do with 68.
No, I have
It is
pointed-
a regular inspection, my lords, which
64
happens under the act under section 65, my lords. There is a guideline. If my
Statutory
lords sees-
inquiry,
My lords,
statute-
may kindly see what is annexure G. What is being argued is completely different. Annexure G, my lords, may kindly turn to page 89.
Yes.
Annexure G, my lords, is a ಪರಿವೀಕ್ಷಣಾ ವರದಿ ತಯಾರು ಮಾಡಲು ಅಧಿಕಾರಿ ಸಿಬ್ಬಂದಿ ನಿಯೋಜಿಸುವ ಬಗ್ಗೆ. This is a
ಏನಾಗಿದೆ?
routine inspection
my
which
lord,
happens amongst all the primary
Lord, they did
societies.
not-
And my lords, this particular communication has spent itself. On 16/4, we have finished the inspection.
You have finished. the-
Yes,
They have
and
not
they have
kindly-
come to the
You
court on
record the
28/5.
statement of the additional advocate general saying that the inspection has been completed.
If they have any
If
grievance,
not
let them
completed,
challenge
they
the
were
further
happy.
process.
They do not want this society to participate in the election. Earlier also, my lord, they did not take steps to hold election. Kindly 50,000 cost was imposed on the returning officer, saying, Lord, why you are not holding the election? A direction was issued.
That
my lord.
is different.
No,
This
that is not different. That is, and now they want to, some inspection is recorded, but they don't want to, now they will supersede the society.
It is not some.
This is the
Can you-
purpose, my lord, they're doing it.
Mr. Shetty, 16/4/25, you filed a petition on 28/4. It's already spent itself and they are saying that they have conducted.
This
the
is
inspection.
appointment of an
Any
inquiry
further-
officer.
If any order is passed in person thereof, you'll have to challenge that.
Lordship,
ಇವಾಗ annexure G stay ಮಾಡಿ ಏನ್ ಪ್ರಯೋಜನ? Already
ಇವಾಗ
inspection
ಅವ್ರು ಏನ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿಲ್ಲ. ಅವ್ರು ಏನಾದ್ರು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ರೆ.
statement
My lords,
inspection
the
ಆಗಿದೆ
the
ಅಂತ.
inspection is, my lords, my
Inspection
statement may be
report will be
taken on
done.
record
According
that
to which, my lord,
recorded.
According to me,
Sorry. Petitioner is before this court seeking for the following reliefs. Learned additional advocate general submits that in terms of annexure G, inspection is scheduled to be held on 16/4/2025 has already been completed, rendering the above petition infructuous. Placing our submission on record, the petition stands dismissed as infructuous.
Great.
25, Sandesh Bibi.
petitioner, my lord, ಇದರಲ್ಲಿ ಡಿಫಾಲ್ಟರ್ ನೋಟಿಸ್ ಎಲ್ಲ ಕೊಟ್ಟಾಗಿದೆ. Only thing, my lords,
The stage it was stopped. You come so late. DGA accepts notice for respond number.
Instructions is my lord RP, they are not send the notice under RPAD my lord. Register post ಮಾಡಿದ್ದಾರೆ ಅಂತ ಮಾಡಿದ್ದಾರೆ.
there is no ineligible.
ಹೇಳ್ಬೇಕಲ್ಲ.
There is no ineligible defaulters ಇದ್ರು ಅವರಿಗೆ we have issued a
notice, my lords. Kindly see the annexure.
AGI accepts notice for respond number 1, 2, 4, please, 5. TL Kiran Kumar for 3. Issue emergent notice to respond number 6, returnable by 5th June. Respond number 5, he is directed to place on record compliance with Rule 13D, please, of the KCS Rules 1960 by next day.
Further hearing, serial number 26.
Enaita affidavit,
Filing affidavit.
full detailed.
Full date. It is detailed.
You've seen it all.
I've seen. What is in it?
The manner of minute book and refusal register, how it is done.
We have extracted that particular provision, my lord. My lord should kindly notice page 4.
This senior sub-registrar affidavit. IGI is directed to file a detailed affidavit as regards the dispute on Theodido. You're still filing the senior sub-registrar.
My lord, this is the affidavit of the IGR. My lord.
No, what we have is the senior sub-registrar 2-5.
That is this, I think IGR.
That is an apology affidavit that.
This is IGR affidavit.
Other IGR.
The paragraph 4 may be relevant.
Para 2 and 4. Issued up to എടുക്കಂತಾರ ನೋಡಿ.
So there's an appeal preferred.
5 years later. Paragraph 4 would be very relevant. In paragraph 4, also there's an extraction of 71. Most important is, and on application made by any person executing or claiming under the document shall without payment give him a copy.
Yes, anything you have to say on this?
Well, it's just paragraph 4, my lords, was pleased to
Yes.
see, my lords. They categorically state that it was sent to the legal heirs on 10/11/2000. It was sent according to them. But even if the legal heirs want reasons, my lords, 71 is extracted to say you file an application, you get the reasons. That's how 71 reads. Appeal is filed after 5 years, my lords. And as I pointed out, my lords, there's no provision for condonation of any delay, my lords. Though then application also was kept pending, no orders passed on that application, and also the appellate power, they don't have the power to condone that delay. So, my lords, it should be barred by limitation was what we had continuously pointed out. Now, what they say in paragraph 4 would be of relevance, my lords, that a copy had been sent. Now, my lords, if for any reason they're not able to rebut this aspect of it, my lords, then the appeal itself goes. And now the impugned order, my lords, though there's an application still pending for condonation of delay, that application is still not touched. Main order is passed.
Mr. Arnoldi. Or ಕೊಟ್ಟಿದ್ದೀರಾ copy? You're appearing for Mr. Arnoldi.
I've sought a copy.
We've received a copy, my lords.
Want to say anything on that?
If time may be granted, we'll file a counter for this affidavit.
We'll pass over, check with him if he wants to make any submission. If he makes a submission, we'll reserve it. If you really want time, we'll have to give you time.
Indeed.
Pass over.
And I put it also filed. My lord, records the time.
ಬರ್ಲಿ ಅವ್ರು.
Serial number 27. Vivek Kolla.
Petition.
You
Yes,
received the
ma'am,
copy. They're given up the project.
My lord, but only just one submission, my lord. In the affidavit, they've only stated that the objections may be read as part and parcel of this. In their objections, they've made various allegations against us. They just,
No, but now that they've given up the project,
Yes.
nothing can survive.
yes, but just two requests, my lord. Liberty may be granted to us to approach the civil court to claim for
Any
damages.
File a suit, pay court fee,
Yes,
government will be happy.
my lord, and another request is at the time of obtaining the bank guarantee, we had submitted certain original documents to the bank. The bank requires the original bank guarantee to be furnished in order to obtain. So if those, if the authority may be directed to
The original documents are with KDB.
KDB. So if,
All the original documents you'll have to return.
if they hand it over to us,
Yes. Petitioners are before this court seeking for the following reliefs. The reliefs which have been sought for in the present petition are premised on the fact that the respondent is implementing the Bengaluru Aerospace Park at Devnalli. An affidavit of the CEO and DM of KDB has been filed on 29/4/2025, categorically stating that the Union of India Ministry of Commerce and Industries, having withdrawn the grant, the KDB, the proposal for implementation of the Bangalore Aerospace Park, Devnalli, has been given up and is not going to be implemented. Such being the categorical statement, the relief which have been sought for in the present petition would not survive for consideration. The submission of learned counsel for the petitioner at this stage is that the petitioner has submitted several original documents to the KDB, which would have to be returned back to the KDB. If at all any original documents have been furnished, the KDB cannot retain the said documents and would have to return the same to the petitioners at the earliest, at any rate within 45 days from date of receipt of a copy of this order on the petitioner furnishing duly authenticated photocopies thereof. With the above observation, petition stands disposed.
Obliged. My lord, liberty may be granted to approach
Liberty
the.
is reserved to the petitioner to approach the appropriate forum, agitating any relief or damages, if at all the petitioner were so desirous, which shall be decided in accordance with law. All contentious are left.
Obliged.
In other judgment, il bariyada bada.
28. Yes, Srinivas?
My lord, TSD has requested for a passover in this matter.
Passover.
A group matters, serial number 29. We are
In this, I appear for petitioner, my lord.
Yes.
My lord, the lands, my lord, subject land were, the Hakkadari rights were granted to the petitioner as per Annexure A. That is, my lord, at page 11. The typed copy of the same, my lord, is called out at Annexure E, page 18, my lord. There, my lord, there was an option for the.
You filed your objections, illa.
My lords, unfortunately, today I do not have the benefit of the file, my lords. May I
Don't
request
have the
for a
file.
passover?
My lord,
I've asked for the file.
On several
That
occasions, my
idiot doesn't even
lord,
have the file and.
I apologize, my lord.
my lord, I had, my lord, on several occasions, not once or twice, my lord, when it came up before coordinate benches, my lord, the same submissions were made. Otherwise, I would have not complained like that.
ಒಂದು ಕಾಪಿ ಕೊಟ್ಬಿಡಿ ಅವ್ರಿಗೆ.
Hmm.
One copy of the petition. IA 1 of 23 and IA 1 of 25 are allowed at the request of learned AGA, released on 4th June.
serial number 30.
This matter, my lord.
Yes.
Identical matter was filed and withdrawn. I have already produced, my lord, a copy of the judgment. May I, my lord, show it to your lordships again? On the same cause of action, the lordships may kindly peruse, my lord, the judgment.
The lordships, it was withdrawn as there was no
Lordships may see page
authorization
3.
to file the
I'll just complete
petition.
my submission.
Let's see if there's any liberty reserved.
Page 4, my lord. That withdrawal memo was filed impugning the same order. The writ petition is
Liberty
dismissed.
to file a fresh.
Alla munde, file a fresh petition if available in law. So
It is available in law, your lordship.
how, my lord, it is available, they have not stated in the writ petition. If, my
That
lord,
we'll
if
consider.
available.
That we'll consider. See, if liberty is not being reserved, then the petition memo for withdrawal ought to have been dismissed.
Correct. But if available.
Allowed liberty would have to be.
Yes,
given.
now your lordships may see the petition, my lord. It is not stated how that liberty is available. That's all. I will not state anything on merits.
ಅದು ಬಿಟ್ಟು merits ಮೇಲೆ ಹೋಗ್ಬೇಕು.
ಅಲ್ಲ ಮೆರಿಟ್ ಮೇಲೆ ನಾನು ಹೇಳ್ತೀನಿ ಐ ಹ್ಯಾವ್ ಅ ಕೇಸ್ ಆನ್ ಮೆರಿಟ್ಸ್ ಮಿಲಾಡ್ ದಟ್ ಇಸ್ ಅನದರ್ ಇಶ್ಯೂ ಬಟ್ ಒನ್ಸ್ ಫೈಲ್ಡ್ ಅಂಡ್ ವಿತ್ಡ್ರಾನ್ ಮಿಲಾಡ್
Liberty is reserved.
if available in law I will not stand on formalities. It will appear, my lord, that I don't.
We won't stand on technique.
I'll
Liberty
argue
reserved,
on-
liberty reserved. Otherwise, we'll tell them no withdrawal.
If available in law ಅಂತ ಮಾಡಿದ್ರು
If
ನಾನು I had
available.
opposed granting liberty. What had happened, my lord, to ಇದರಲ್ಲಿ authorization ಹಾಕಿರ್ಲಿಲ್ಲ ಫೈಲ್ ಮಾಡ್ಲಿಕ್ಕೆ.
ನೀವು ಲಾಸ್ಟ್ ಅಲ್ಲಿ ಏನೋ ಹೇಳಿರ್ತೀರಾ ಅದಕ್ಕೆ ಇಫ್ ಅವೈಲಬಲ್ ಇನ್ ಲಾ ಅಂತ ಬರ್ದಿರೋದಲ್ಲಿ.
ಅಲ್ಲ ಆಗ್ಬೋದು. ಐ ವಿಲ್ ನಾಟ್
ಇವಾಗ ಇವರು ಮುನೀಶ್ ಕುಮಾರ್ ಹೇಳ್ದಂಗೆ ಲಾಸ್ಟ್ ಲೈನ್ಸ್ ಬರುತ್ತಲ್ಲಿ. That technicalities we won't go on.
they'll argue. I go down whatever.
Want
I'll
to
not-
file your objections and
I'll file objections.
the counsel for respond service is complete.
Yes.
Respond number 2 here. Notice not
Ombudsman, your
ordered.
lordships, we have sealed their order.
May not be.
Who is for respond number 2? Any standing counsel?
No.
Ombudsman?
No, that they don't, my lord. It's only a body, but your lordships may, my lord.
Notice ಹೋಗ್ಬೇಕಾ ಬೇಡವಾ?
No, your lordships, we have assailed the electricity
They are the
ombudsman
Notice
order.
to respond number
We're not-
2 is dispensed with in view of the order of respond number 2 being under challenge in the present proceeding.
Briefly.
Respond number 2 not being entitled to defend the said order. Learned counsel for respond number 1 seeks for and is granted 4 weeks time to file a statement of objections. Released on 4th June.
Briefly.
Next matter, my lord.
Clarification you wanted.
Sorry.
Clarification.
Yes.
What clarification you want?
ಅಲ್ಲ ಅದು ಕ್ಲಾರಿಫಿಕೇಶನ್ ಅಲ್ಲ ಇದು ಬೇರೆ ಇದು
ಇದು ಬೇರೆನಾ?
lordships may see, my lord, the first matter It is regarding the applicability of the tariff, my lord. May I now persuade your lordships to see the connected matter first and then I'll argue this matter.
31.1.
That connected matter, simple request is, my lord, to reduction of load. This matter is pending. Lord, the applicability of the tariff HT2A agbeka, B agbeka anta ಆ ಕೇಸಲ್ಲಿ ಇದೆ. Now, my lord, I asked for increase of the load, they grant. For reduction of load, they are not granting, saying that this matter is pending, my lord. This innocuous request that this, my lord, I want reduction of load because I shifted this premises.
31.1
Yes,
is WP 12.
yes, my lord. Simple prayer is, my lord, my
And you are
represent.
asking for 2,26,59,725.
Yes, that is, my lord, the amount illegally collected from me as demand charges month on month, despite my request for reduction of load. Kindly see, my lord, page 85. A detailed representation is filed, annexure B, my lord.
Yes.
I simply say that, my lord, I want to reduce the load. We are so and so, company registered under so and so, and my lord, we have said we had a contract demand of 500 kVA, page 86. My lord. Vide application number so and so. Application was considered vide so and so. Consequently,
4,000 kVA to 300 kVA.
yes, because I shifted the premises from one place to other place. ಈಗ ಇದರ ದೊಡ್ಡಬಳ್ಳಾಪುರದ ಹತ್ರ ಶಿಫ್ಟ್ ಆಗಿದೆ. This is, my lord, that manufacturing unit for iPhones. And I am saying, Lord, I have shifted my premises. Please reduce ಮಾಡಿ ಅಂತ. You reduce ಮಾಡಿ ಅಂದ್ರೆ ಮಾಡೋದಿಲ್ಲ. And for increase of load, they have increased the load and collected money.
That is when you will give them money.
ಅದೇ ಅಷ್ಟೇ. That's all that is.
Your lordships we understand that there is an error, your lordships, in this matter. We
Error?
will reduce the load, your lordships may pass an order. We will abide by this.
Grateful.
31.1 will have to be allowed.
Yes. Please, your
31.1. Petitioner is before this court seeking for the following reliefs. The petitioner is a private limited company carrying on the business of original equipment manufacturing of computer hardware and other products. The petitioner had established ಮಾಡಿದ್ರಿ?
Yes, that in first area is not this Pina Industrial Estate, page 86. ಈ registered office ನಲ್ಲೇ ಇತ್ತು. ಆಮೇಲೆ ಈಗ ಬೇರೆ ಕಡೆ.
Had established its manufacturing facilities in Pina Industrial Area, Bangalore, wherein the contracted load initially was 500 kVA and subsequently was enhanced by 3,500 kVA up to 4,000 kVA. In pursuance thereof, the petitioner was making payment of the demanded amount from time to time. However, thereafter, the petitioner shifted its manufacturing facility from Pina to Doddaballapura, and therefore requested for reduction in the contracted load from 4,000 kVA to 300 kVA, since the manufacturing activity was not being carried out. The said request came to be rejected by the respondents vide annexure A to A21 on the ground that since another writ petition relating to the same was pending in WP number 20389 of 2021, the same could not be considered. It is challenging the same, the petitioner is before this court. Shri Sridhar Prabhu, learned counsel appearing for the petitioner, would submit that even when the request for enhancement was made from 500 kVA to 4,000 kVA with the enhancement of 3,500 kVA, writ petition WP number 20389 was pending and the enhancement was made in the year 2024. That is, submission is that when the pendency of the said proceedings did not come in the way of enhancement, the pendency of the proceedings cannot come in the way of reducing the contract load. Consent or?
Your lordships will pass orders.
You give one submission.
Your lordships are only submission is that because the matter was pending before your lordship, before this honorable court, they did not reduce the.
I should have
sanction.
taken leave of the court, Antena.
Then counsel for the respondent seeks to support the said orders on the ground that due to the pendency of the matter in WP 20389 of 2021, there being a loss which would be caused to the respondents, no reduction could be caused without permission from this court. And as such, the representation of the petitioner at Annexure B was rejected by the respondents. It was for the petitioner to approach this court and obtain such leave. The petitioner not having done so cannot find fault with the respondents. Third, so and so produce papers. Though the learned counsel for respondent seeks to support the rejection of the representation of the petitioner, I do not find any substance therewith. Inasmuch as, firstly, the petitioner, when had sought for enhancement, was carrying out manufacturing activities in Pinya Industrial Estate. Subsequently, the manufacturing facility has been shifted to Dodbalapura, where similar power connection has been obtained by the petitioners. And the petitioner are making payment of the due contracted load at the Dodbalapura. The petitioner not carrying out manufacturing activity in Pinya Industrial Area, at the unit in Pinya Industrial Area, cannot be forced to make payment of contracted amounts both at Pinya and Dodbalapura, thereby, which would result in unjust enrichment on part of the respondents. Be that as it may, even otherwise, if at all a entrepreneur or a manufacturer were to reduce the manufacturing and seek for reduction in the contract load, whether it's shifted to any other premises or not, the manufacturer cannot be forced to continue with the contracted load merely because such a contracted load has been sanctioned. It is for the manufacturer to decide what load the manufacturer wants to avail of and seek for such reduction as the manufacturer intends to. If at all there is any excess usage, there are always provisions available under law to take necessary action. The manufacturer cannot be prevented from reducing the contracted load so as to work out the modalities and finances of the manufacturer when the manufacturer does not want to carry out such manufacture in that unit. In that view of the matter, I pass the following order. Writ petition is allowed, a certiorari is issued. The demand charges at Annexure A to A1 issued by the respondent are quashed. Respondents are directed to, a mandamus is issued. Respondents are directed to consider the representation dated 24 September 2024 submitted by the petitioner at Annexure B for reduction of the contract demand favorably, taking into consideration the relevant aspects within a period of 15 days from the date of receipt of this order. Needless to say, if the petitioner has not used the contracted load, no demand could be made on the petitioner for any amounts.
Lordships may similar instead of Dodbalapura, it is Narsapura. Sorry.
Narsapura.
Sorry.
31 ಏನು
ಅದರಲ್ಲಿ ಒಂದು ಪ್ರೀಪೇಮೆಂಟ್ ಮೀಟರ್ ಹಾಕ್ತಾ ಇದೀವಿ ಎಂಟೈರ್ ಇನಿಷಿಯಲ್ ಸೆಕ್ಯೂರಿಟಿ ಡೆಪಾಸಿಟ್ ಆಲ್ಸೋ ಶುಡ್ ಬಿ ರಿಫಂಡೆಡ್ ಅಂತ ಒಂದು ಪ್ರೇಯರ್ ಇದೆ ದಟ್ ಲಾರ್ಡ್ಶಿಪ್ಸ್ ವಿಲ್ ಸಿ ಐ ಆಮ್ ಸಾರಿ
31
yes ಅಲ್ಲ ಇದೆ this case only my lord page 88 that representation contains a request for lord refund. Yes
proportionately they'll have to do it.
ಅದೇ ಇದು initial security deposit has to be refunded, all aspects contained in that representation.
What about
yes
31?
connected this matter my lord, straightforward case my lord, where I'm a manufacturing unit. I'll just complete it.
An adjournment, your lordship, posted after.
Objections have to be filed.
ಇಲ್ಲ ಇದರಲ್ಲಿ ಇಷ್ಟೇ ಸ್ವಾಮಿ ಇಲ್ಲ ಅಬ್ಜೆಕ್ಷನ್ ಇದೆ ನಾನು ತೋರಿಸ್ಬಿಡ್ತೀನಿ ಸ್ವಾಮಿ ಇಟ್ಸ್ ಕವರ್ಡ್ ಮ್ಯಾಟರ್ ಲಾರ್ಡ್ಶಿಪ್ಸ್ ಮೇ ಪರ್ಮಿಟ್ ಮಿ ಜಸ್ಟ್ 1 minute.
Kindly posted after.
ಅಲ್ಲ ಒಂದೇ ನಿಮಿಷ
You got one order.
ಅಲ್ಲ ಒಂದೇ ನಿಮಿಷ ತೋರಿಸ್ more than 1 minute I'll not argue.
Fair price shop ration ಒಂದೇ
ಇಲ್ಲ ಬೇಡ ಅಲ್ಲ ಇದೇ ಮೇನ್ ಇತ್ತು ನಾನು
if you want some time probably a senior wants to come and argue. Let him come. The counsel for response seeks for and is granted a short accommodation to get ready and address arguments. Released on 4th June.
Interim order
earlier granted.
That's a voting my lord.
And AGA accept
Process is
notice.
completed, my lord. Representation ಆದ್ಮೇಲೆ ಕೂಡ ಕೆಲವು bills ಇದೆ. So additional representation also.
Needless to say, cannot be charged ಅಂತ ಅದಕ್ಕೆ ಹೇಳಿದ್ದು. It covers everything.
Election is completed, my lord. Declare active.
Election
And
is
AGA accepts notice for respondent number
necessary.
134.
my lord, it is my lord, already notice is order. my lord.
ಆಗಿದೆ, my lord.
ಆಗಿದೆ, ಆಗಿದೆ.
Voting ಕೂಡ ಆಗಿದೆ.
Regard voting.
Voting
my lord.
ಆಯ್ತು.
ಆಗಿದೆ, ಆಗಿದೆ. 26.
Declaration.
Please.
32 declare results.
Everybody.
Number 1, serial number 2.
Yes, ಯಾರು ಇದ್ದಾರಪ್ಪ? State.
She was there.
Paso,
So 230,
230.
please.
Serial number 14. Nagaraj S. Jain.
Paso.
18.
ನೋಡಿದ್ರ ಮಿಸ್ಟರ್ ರೆಡ್ಡಿ? Paso. 26 Paso.
My lords, I've taken instructions from my senior, my lords. He won't be appearing today. If a short date may be given, we'll file we've actually made a detailed submissions. We finished the detailed submissions. If a short date may be given, we'll file a.
26. Learned AGA has filed an affidavit of the senior sub-registrar as also the affidavit of the IGR, which is taken on record. Learned counsel for respond number 3 and 4 seeks for and is granted 2 weeks time to go through the same and make his submissions. Relist on in GM. Relist on 4th June.
Much obliged, my lords.
28.
I apologize, my lord, I was on flex. Lord, the instructions is this, my lord. They say, my lord, this with regard to that marks card.
Yes,
please. Lord, they say the DigiLocker application will provide only basic information about the certificate being scanned, my lord.
Government to government basis.
That this is the.
Nobody has that wherewithal to do that. Papa
That
students.
conducted on government to government basis, in the sense, my lord, the words in the sense, my lord, from the.
We'll have it after vacation. Please prevail upon them to come up with something for the students.
That is the reason, my lord. The second part, additionally, as mentioned earlier, verification of educational certificates can be facilitated through Indian embassy in respect of country.
Embassy has so much of work. If you give 1 lakh students certificates, you know how many students apply to US a year?
But
You
for
want
that,
the embassy to do it. If you have that thing, we'll note it and say all students can approach the embassy. And one line in the certificate saying that if any verification is to be done by the student or by the university, they can approach the concerned embassy having jurisdiction. ಬೇರೆ ಎಲ್ಲ ಕೆಲಸ ಬಿಟ್ಟು ಇದು ಮಾಡ್ಬೇಕಾಗತ್ತೆ ಅವರು. There are lakhs and lakhs of students who are up.
no, my lord, but they say, my lord, that apart, they cannot do anything more than.
Do they even understand the implication of it?
My lord, I tried telling them, my lord. In fact, it's true that, my lord, I made all my efforts.
We'll note the observation, give you time so that at least they understand then.
Please.
Learn DSGI. By referring to the email of
Dated 1st May 25.
one Mr. Gaurav Kare, dated 1st May 2025, of the Digital India Corporation submits on instructions that apart from the limited information that is available through by scanning the QR code using the DigiLocker application, verification of all the details can be facilitated through the Indian embassy in the respective countries. And this method is currently under discussion and development. And the verification process will be conducted on a government to government basis. The submission essentially is that if a student wants his marks cards to be verified, then he could approach the concerned embassy.
That is under discussion ಅಂತ ಹೇಳಿದ್ದಾರೆ. Second line, this method is currently under discussion and development.
Even under discussion, what it means is that.
And development.
Would essentially mean that the concerned student could approach the concerned embassy for verification, or the concerned university stroke college could approach the concerned embassy for verification. Ex facie, the said solution does not appear to be practical, in as much as there being lakhs of students who apply for their further education, for their education in foreign universities and or foreign colleges. If all of them were to approach the embassy of the concerned country, and if the universities or colleges were to approach the embassy for verification of the marks card of these lakhs of students, the embassies would be swamped with work and would not be able to do any other work. It is for the concerned to come up with a proper, suitable, practical, and efficient solution.
As what is there now, instead of that, the entire marks card to be.
As per the efficient solution to cater to the above problem, one of which could be the making available of all the information as available in the marks card in the DigiLocker application, subject to right to privacy, etc., which would have to be looked into by the concerned persons. Released on 12th June to enable the learned GSDI to secure instruction, make his submissions. ಅಷ್ಟೇ ಎಂಬೆಸಿ ಮುಗಿದೋಗತ್ತೆ. ನಿಮ್ಗೆ ಇರೋದು 10 ಜನ ಅಲ್ಲಿ, ಒಂದು ಅಫಿಡವಿಟ್ ನೋಟರೈಸ್ ಮಾಡ್ಕೊಡಕ್ಕೆ 15 ದಿನ ಆಗುತ್ತೆ.
I told them, instead of getting that one e-verified, there's no problem in scanning this itself. When they scan, QR code is scanned, if this is reflected, the whole problem will be solved.
Everything will be solved.
This is what I told Milord, but the instructions was that. Now you're
Everybody wants status quo. Nobody wants to go beyond. ಅದಕ್ಕೆ
your lordship's order is complied, Milord. We are complying it, Milord, faster.
you are making your efforts. What to do? People who have to do it are moving a little slower than what you are. They'll catch up.
Number 2, passport matters. Serial number 11.
That's
Sauri HR.
Mr. Nirali.
That's an order under section 74. The CGST came to be passed, my lords, without specifying what is a fraud played by me. That goes exactly in contravention with Annexure T, my lords, page 184.
Annexure?
T.
Page?
Page 184. This is the instruction issued by the Ministry of Finance, my lord. The relevant page is 185. Paragraph 3.3, my lord. May I read, my lords? From the perusal of wording of section 74(1) of CGST Act, it is evident that section 74(1) can be invoked only in cases where this fraud or willful misstatements or suppression of facts to evade tax on the part of the said taxpayer. Section 74(1) cannot be invoked merely on account of non-payment of GST without specific element of fraud or willful misstatements or suppression of facts to evade tax. Therefore, only in the case where the investigation indicates that there is a material evidence of fraud or willful misstatements or suppression of facts to evade tax on the part of the taxpayer, provisions of section 74(1) of CGST Act may be invoked or for issuance of show cause notice, and such evidence should also be made part of the show cause notice.
Evidence should also be made part.
Please, let's kindly see
Page?
page 86, Manoj. The order, annexure B.
Show cause notice.
The order, Manoj.
Show cause notice. Where is the
Show cause notice is it? Annexure A, Manoj. The relevant page is at Manoj.
There has to be an allegation in the
Page
show cause
38.
notice.
Page 38 is the show cause notice, Malats. Grounds for extended period of limitation.
para 5, my lords, at the bottom.
Page
Page 38, my lords.
38. Hmm.
The GST is payable, may I read, my lords? Para
Yes.
5. On a self-assessment basis, the taxpayer, though is aware of legal provision, has availed ITC irregularly and has not paid or short paid GST in certain cases. It clearly shows the fact that the registered person had an intention to evade the payment of tax. This is all that they say, my lords. If I read
Where is
page
the evidence, Mr. J. Nirali? Where is the evidence that you are required to place on it? 3.3 prakara.
There is no evidence. Subject to my lord, what they say, I have sent the paper.
well, it's evidence.
In fact, my lord, otherwise appealable order.
Union of India ಯಾರು? ASG not filed.
Union of
ಆಗಿದೆ,
Indian
notice ಆಗಿದೆ.
Notice
Since compliance with
with respect to annexure Q3, my lord, legible copy that I'll furnish it.
para 3.3 of annexure T being the instructions issued by the Ministry of Finance in pursuance of the order passed by the Honorable Apex Court has not been followed with the evidence of the alleged
Fraud and suppression.
fraud, not I mean made part of the show cause notice. The operation of annexure A and B are stayed till the next date of hearing.
Annexure A need not be stayed. Annexure A has culminated into an order.
Annexure B, my lord.
A also did not have the
Show cause notice.
ಮತ್ತೆ ಬಿ ಸ್ಟೇ ಮಾಡಿದ್ರೆ ಇನ್ನೊಂದ್ಸತಿ ಆರ್ಡರ್ ಮಾಡ್ತೀರಾ?
Annexure B, the justification that they give is the
Annexure
same.
A and B is stayed till the next date of hearing.
My lord, otherwise it is an appealable order.
Well, it lacks the
Objections to be
jurisdiction. my lord.
filed within on or before 6th June, released on 12th June, 11th June.
Otherwise it is an appealable order under section 107.
Without jurisdiction, if you
Without
have
jurisdiction,
violated
have an
Supreme Court
citation, my
judgment,
lords.
why should they go to appeal? Comply with your requirements.
Most, my lord, matter has to be remanded, that's all, to verify the suppression.
What do you want? You want us to remand now only or?
No, my lord, I'm awaiting instructions. I wanted some, my lord, pre-deposit, because if they had gone in an appeal,
You have to-
10% compulsory.
You have to give issue a show cause notice in compliance with the Supreme Court judgment. That show cause notice itself will have to be quashed.
See,
To get
I'll get the
instruction.
instructions, subject to what?
Yes.
Serial number 13, PD Subramania.
Please.
Yes.
In this case, Lord, initially my submission is that, my lord, without authorization, Lord, they have inspected the premises and seized certain documents and the cash, my lord. The authorization was in the name of Sadashivan, father of the petitioner. There was no authorization to search and seize the document of the petitioner. They are all the independent businessmen, my lord. They are real estate businessmen.
You are residing in the same house.
Same address, house.
You're residing in the same house.
It is my house, man. It is my house.
Sadashivam is also residing in the same house.
Same house, man. That is why, my lord, to inspection, my lord, they have tagged that the DIN number, my lord, given to the father. To, my lord, issue summons and the assess my liability for tax, my lord. No separate authorization is taken because we are independent businessmen. On the first count, second count, in the real estate, my lord, it is they are selling either the vacant site or the completed house. In that count also, my lord, the GST is not attracted. Despite that, my lord, my submission is let the authorities conduct the assessment, but they release the original documents and the cash, my lord, because it is
Original documents are in whose name?
it in the name of Prabhakaran. It is belonging to Prabhakaran only, my lord. In the annexure B, my lord, they have seized the documents of the Prabhakaran. Annexure B, my lord, I produced the Mahajar, and the annexure to the Mahajar show the documents. In fact, my lord, more than 200 documents have been seized. They are not even documented. There is therefore, my lord, the apprehension on the for the petitioner, some document may be misplaced. And the provision says, my lord, that for providing copies, the application for providing copies, my lord, under section 160.
List of documents is there.
Hazard is there, my lord. Inventory
Hazard is there.
There are 85 documents is there. But what party says, my lord, they have seized more than 200 documents. Serial number 85 and 83.
We can only direct 85 documents. That was.
ಅವರು ಅದನ್ನೇ count ಕೊಡ್ಲಿ. ಯಾಕಂದ್ರೆ in the bag, my lord, they have given the count to the bag only, bag also. In the bag, there are so many documents there. They have mentioned like that only, my lord.
There is a provision to seize.
Yellow
my
color
lord,
cover
copies
with various bank documents, accounts and.
These documents cannot be returned now. Your interim relief that you are
Are
seeking
they
for
provision,
cannot be
what the
granted.
provision says, my lord? Provision, my lord, under the act, my lord. There are two provisions, my lord. One says, my lord, to give the copies. Another says, my lord, section 67 clause 6.
You will have to go before them and say that these are properties belonging to you. You got it from your funds.
That is, my lord, that is,
Explain
I have given the annex.
ನಿಮ್ಮ ಹೆಸರಲ್ಲಿ ತಗೊಂಡ್ರು ನೀವು ನಿಮ್ ದುಡ್ಡಿಂದ ತಗೊಂಡ್ರು ಅಲ್ಲಿ ಹೋಗಿ ಹೇಳ್ಬೇಕು.
That is, my lord, I have produced before this honorable court, my lord, showing that, Lord, I have given the reason, I have given the bond. They are calling me, my lord, every day, but they are not conducting any inquiry. It is simply harassing the petitioner, my lord. In fact, my lord, I have given the under.
Where is your
Annexes.
reply for each of these documents? Have you filed it along with your petition?
Along with the petition, I have submitted
Yelli the reply.
annexure E series, my lord.
Where is your statement?
F, my lord, annexure F and G. Request for return of original documents.
Ashte. But have you explained each of those documents?
That is, my lord, since, my lord, it is not in the inventory, even I cannot identify without, my lord.
ನಿಮ್ಮ ಹತ್ರನೇ
Let
85
lordship may say not what are the documents under the merger, my lord. And I believe that authorities.
Give a reply.
ಅಲ್ಲ ಅದನ್ನ ಈಗ provisional, my lord.
Counsel for the petitioner. Submit that given 4 weeks time. A detailed reply would be issued by the petitioner as regard the documents and cash seized, which could be considered cash seized to indicate that they belong to the petitioner and that the purchase of the properties have been made from and out of the funds of the petitioner, as also that the cash seized belongs to the petitioner. In that view of the matter, if such a reply is submitted by the petitioner, respondent number 3 is directed to consider said reply
That has
and
been
take
already
necessary
given.
action.
That is the submissions, my lord, regarding the source of fund and, my lord, the request for.
ನಿಮ್ಮ annexure F ಅಲ್ಲಿ ಏನೂ ಇಲ್ಲ.
Annexure F.
There is nothing in annexure F.
Annexure G ದಲ್ಲಿ ಸ್ಟೇಟಸ್ ಕೇಳಿದೀನಿ, ಅದರಲ್ಲಿ ಹೇಳಿದೀನಿ ನಾನು annexure G ದಲ್ಲಿ.
ನೀವು ಬರೀ ವಾಪಸ್ ಕೊಡಿ ಅಂತ ಇದ್ದೀರಾ ಅಷ್ಟೇ. ನಿಮ್ದು ಅಂತ ಇಲ್ಲಿ what do you have to prove?
Annexure C1, my lord, annexure C1, my lord.
Will be considered necessary orders passed within 30 days thereafter. Released on 17th June.
Please.
Serial number 15. Vasanta AK.
Yes. What are the compliances?
Orders with regard to return of documents.
Huh?
May not be an adjudication process as such.
Well, then pass orders on his request.
On his request.
Yes,
Return of
sir,
documents.
first. Yes.
The UGC regulations, my lord. UGC regulations.
Page?
Page, my lord, 19, my lord, annexure R5.
Of my objections.
Of my, along with my statement of objections, my lord, today we have filed.
Yes.
My lord, next page, my lord, page 20, the learner support center, or my lord, to or definition. Last learner support center means a center established or recognized by the higher education institution. Higher education here institution, not in this case is KSI. Higher education for advising, counseling, providing interface between the teachers and learners, rendering any academic and other related services and assistance required inter-alia by the learners of the open distance education mode and meet accessibility standards and introspectivity of the access to the learners also. Learners requirement to enroll all these programs, my lord. This is the learner, this is the duty of the learner supporting center. Now, my lord, next, my lord, part 4, 14, my lord, 14, next page number 22 nalli, 4 may kindly be seen. Admission of learners and higher education institution for a program is open and distance education or online mode shall be offered in a transparent manner and made directly by the headquarters of the higher education institution, which shall be solely responsible for final approval relating to admissions and registration of learners. Provided, and this is important, that a learner support center shall not admit a learner to any program and open and distance education learning for and on behalf of education institution. So my submission is, my lord, they have no power to admit any students. So when they have no power, Lord, they cannot. Lord, here the center is before this court, not the students, not none of the students. My submission, they have no locus standi to maintain the petition.
ಅಲ್ಲಿ ಏನ್ ಇದು ಬಿಟ್ಟು ಇನ್ನೇನ್ ಕಂಪ್ಲೈನ್ಸ್ ಮಾಡಬೇಕು? What are the students to comply?
My lord, students, my lord, in the regulation itself, regulation 15 may kindly be seen. Evaluation. Common provisions for open and distance education. Otherly, number 3, my lord, may kindly, clause 3, A3 nalli. The evaluation shall include 2 types of assessment: continuous or formative assessment and summative assessment in the form of end semester examination or term of examination. Provided that this is important. Provided that no end semester examination or term end examination shall be held in a subject unless the higher education institution is satisfied that at least 75% of the program of study stipulated for a semester or year
Yes,
has been
the
actually
things.
conducted. Next, my lord. For open and distance education mode, the learner has minimum attendance
Yes,
of 75%.
Mr. Vasant, please show us what you have done to comply with
Contact program also. is
15.
Please, my lord. My lord,
But these are the documents, my lord, which shows that we have done the contact programs and everything is over in March.
ಇವ್ರು ತೋರ್ಸ್ಬೇಕಲ್ಲ ಏನ್ ಮಾಡಿದ್ದಾರೆ.
my lord, with respect, my
15 compliance ತೋರ್ಸ್ಬೇಕು. 14 will ignore payment.
Please,
We'll direct them to accept. 15, that is provided if you show 15.
my lord, prior to that, I am going through entire gadget notification with respect to the education. But here, my learned friend only produced before this honorable court a selective pages. I am going to now 13 program launching process for higher education institution. I think copy 13.
ಅವ್ರಿಗೇನ್ ರಿಲೆವೆಂಟ್ ಅವ್ರು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದಾರೆ. ನಿಮ್ಗೇನ್ ರಿಲೆವೆಂಟ್ ನೀವು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿ.
My lord,
ಮಾಡಿಲ್ಲ ಅವರು ಅದಕ್ಕೆ ಹೇಳ್ತಾರೆ ನನ್ನ ಕಾಪಿ ಕೊಟ್ಟರೆ.
ಇದರಲ್ಲಿ ಪೇಜ್ ಎಂಟೈರ್ ಗೆಜೆಟ್ ನೋಟಿಫಿಕೇಶನ್ ಕ್ಲಾಸ್ 13 ಸಬ್ ಕ್ಲಾಸ್ ಬಿ 13
ಇಲ್ಲಿಲ್ಲ ನಮ್ಮ
ಇಲ್ಲ ಇಲ್ಲ ನನ್ನಲ್ಲಿ ಒಂದು ಕಾಪಿ ಉಂಟು ಸ್ವಾಮಿ, ನಾನು ಅದನ್ನು ಓದ್ತೇನೆ, ನಂತರ ನಾನು
ಓದಿ. ಬಟ್ ಇವ್ಯಾಲ್ಯೂಯೇಷನ್ ದಿಸ್ ಹ್ಯಾಸ್ ಟು ಬಿ ಡನ್ ಅಲ್ವಾ?
ಪ್ಲೀಸ್ ಮೈ ಲಾರ್ಡ್. Provisions for open and distance learning mode. A higher educational institution offering program in open and distance learning mode shall, in order to facilitate the pace of learning and multiple choice for learners, prepare self-learning material as per Annexure 6 and Annexure 7, taking into consideration the following, namely self-learning material to at least 60% self-learning materials, as well as I am further proceeding to clause 18 of the gadget notification, learner support services. A higher education institution offering programs in open and distance learning mode and online mode shall have guidelines for learner support services,
27.
which is made available to all the coordinators, councils, mentors, and it has been done. And in the meantime, same in 18(4), the higher education institution shall provide facilities for online guidance and counseling facilities to the learners.
They have provided all of it, but your students have not attended ಅಂತ ಅವ್ರು ಹೇಳ್ತಾ ಇರೋದು. That is clause 15.
Yes, please, my lord.
Admission
Yes.
is only money.
My lord,
15 ಆಗಿದ್ರೆ ನೀವು ತೋರಿಸಿ.
my lord, with respect,
We'll consider.
this my respectful submission before this honorable court. First year they have completed. Every
ಅಲ್ಲಪ್ಪ ಫಸ್ಟ್ ಇಯರ್ ಆಮೇಲೆ ಸೆಕೆಂಡ್ ಇಯರ್ ಅಟೆಂಡೇ ಮಾಡ್ಲಿಲ್ಲ ಕ್ಲಾಸ್ ಅಂದ್ರೆ
their distance, they are staying somewhere else and they are attending to, and also they are taking all guidelines from the supporting center.
As per 15(3), there is a method
Please, my
to
lord.
be done.
Please, my lord.
That has to be followed.
Please, my lord.
If that has not been done, then they are not responsible for it. You are responsible for it.
That has been followed, my lord. Now the
Place some
question-
document on record to show that it is
Certainly,
being
I will place some, place certain documents.
Pass over, huh?
My lord, one more submission. Here the question arisen, we have not paid the admission fee in time.
That fee is the least of it. That's why we have been telling you 14, we'll ask them to take the fees.
Please,
But provided you comply with 15. If you have not complied with 15, there is no question of 14 asking them.
Please, my lord, it may be passed over.
Pass over.
Pass over, my lord. I got some personal influence in the afternoon.
Student examinations ಗೆಲ್ಲ ಇದೆ.
ಇದು ಎಕ್ಸಾಮಿನೇಷನ್ ಅಲ್ಲಿ ಆಗೋಗಿದೆ ನಮ್ದು ಟೈಮ್ ಟೇಬಲ್
ಆಗೋಗಿದೆ.
8/5.
8/5 ಇದೆ.
8/5.
18
8/5.
Or we'll reserve
Fifth
liberty
assessment.
to move the vacation court. ನಿಮ್ಮ ಹತ್ರ ಡಾಕ್ಯುಮೆಂಟ್ ಇಲ್ಲ ಅಂದ್ರೆ
My lord, ಸೋಮವಾರ ಪರೀಕ್ಷೆ ಪ್ರಾರಂಭ.
ಮತ್ತೆ ಅದಕ್ಕೆ ತೋರಿಸಿ ಪಾಸು.
Please, my lord.
Through VC method.
No problem. You are always welcome to any mode.
16. Arvind N.
Appearing for petitioner, my lords. My lords, I am the engineering student, my lords. I
Agrale.
am seeking 1 year extension.
ಮುಗ್ದೋಗಿದ್ಯಾ ನಿಮ್ ಟೈಮು?
ಮುಗ್ದೋಗಿದೆ ಸ್ವಾಮಿ. Page number 49, my lords.
Nagrale.
Annexure G and H challenge.
Ask Ms. Nagrale to come.
20. Karthik
20.
R.
Am I audible, Lordship? Apologies for not being present.
Yes.
Lordship, item 20, 21 and 23 filed by the same petitioner.
Yes.
Lordship, item 20 and 21, Lordship, relating to the limitation. Lordship, item 20 relates to financial year 17-18. This is a GST matter.
GST
Typically,
matter.
Lordship, time limit to pass the
GST
impute order.
Madam,
I have respondent, my lord.
Assistant Commissioner, Commercial Taxes, down.
I appear for the respondent, my lord.
Yes.
May I only say this. Let me complete. Lordship
Yes.
sees with regard to the first serial number 20, it pertains to financial year 17-18. Typically, Lordship, the time limit to pass the impugned order, assessment order, Lordship, is 31/12/2021. In our case, Lordship, it has been passed on 22/12/2023, 2 years later. That is, Lordship, because of a notification, which Lordship will see in Annexure D, which is notification 9 of 2023, which Lordship is dated 30, page Lordship will get it 32. I mean WP number 13458.
Yes.
Serial number 20. Lordship will see 32. In 32, Lordship will see at the bottom, with regard to financial year 17-18 up to 31/12/2023, the time limit was extended.
Yes.
Therefore, going by this notification, Lordship, the impugned order is within time. But this notification, Lordship, has been issued under section 168 capital A of the GST Act. The GST Act, Lordship, says this extension of time with regard to, Lordship, passing these orders will have to be after the recommendation by the GST Council. Lordship knows GST Council is the composition of all finance minister and the union minister. Now, they will have to first recommend, and thereafter, Lordship, sequences notification.
That's been recommended, dealt with in other judgments. This
Exactly.
been upheld. This
Yes.
notification has been upheld.
No, there are several cases where now Honorable Supreme Court is seized of this matter, which case law, Lordship, will circulate.
They call this notification something. What is
Yes,
it
now
called?
this was ratified later. Instead of, Lordship, recommendation and then issuing notification, notification came first and then, Lordship, the ratification happened. Now, therefore, across the country, several writ petitions were filed. Most of the writ petitions were held in favor of the assessees, saying that the procedure has not been followed. Now, Lordship, the Honorable Supreme Court, in the case of, Lordship, HCC SCW, Lordship will see, I'm circulating it. Lordship, in SLP civil number 4240 of 2025, is seized of the matter. Lordship will see at para 2, page number 1, para 2. Lordship will see at the bottom. If I may read, however, in the present petition, we are concerned with the notification number 9 and 56 of 23, dated 31/3/23 and 28/12/23 respectively. These notifications have been issued in the purported exercise of power under section 168A of the GST Act, for short the GST. We have heard Shri so-and-so, the learned senior counsel appearing for the petitioner. The issue that falls for a consideration of this court is whether the time limit for adjudication of...
We'll have to stay this.
Yes, I'll be grateful.
Because the Supreme Court is seized of it.
Yes, first and second. Lordship, the next writ petition
CDP
also.
accept notice for respondent.
Yes, ma'am.
The further proceedings in terms of Annexure C state, in view of the issue in question being considered, being under consideration of the Honorable Apex Court in special leave to appeal, bracket C number 4240 of 2025, released on 20th August.
Grateful. The same thing with regard to the item number 21 also.
21.
Yes. Now, with regard to item 23, Lordship, that is not related to this notification, but it has been covered. Our High Court, Lordship, has held in Sadhana, that also I'm circulating. This is regarding claiming of ITC. Lordship will see at page number 3.
Grievance with regard to serial number 23, my lord.
Yes, 23, the amendment itself has happened. GST Act they introduced. This lordship pertains to claiming of input tax credit for March 2021. Lordship department stand is that I should have claimed the credit lordship by October 2021. I claimed it lordship on 30/11/2021, 1 month later. Therefore, they say I'm not entitled for the ITC. Now, law was amended by the last year's budget, where lordship subsection 5 was introduced.
You said there's some other order of a coordinate bench of this court. Which one is that?
With regard to relief is concerned, I'm not opposing, my lord, but there is some instruction, my lord. The same petitioner has filed a writ petition number. I will give, my lord, and it is remanded back. And rectification order is already passed on 11 April. The same petitioner, my lord.
Just to clarify,
So once the rectification is order passed, again coming and approaching issue doesn't arise, my lord.
That is for 1920. Just to clarify,
You
to my
place
friend.
that on record, madam. Learned SCGP accepts notice for respondent. The further proceedings in terms of Annexure B, he stayed till the next date of hearing in view of the order dated 3rd September 2024 in WP number 6138 of 2020, released on 12th June, 11 June.
Much obliged.
Much obliged.
Yes, Venkatesh.
In petition, there is a goods service, transport agency services, your lordship. He had rendered service to Indian Oil Corporation, your lordship. The tax liability on the recipient of the services as per notification, your lordship. Your lordship, even the IOCL has issued a memo, may I pass on that, your lordship, memo that they have already discharged the taxes, your lordship. May I pass on, your lordship. Taxes have already been discharged by the IOCL, your lordship. Therefore, there we've confirmed that the GTS are provided by you to Indian Oil Corporation, so and so. Liability as was discharged by Indian Oil Corporation under RCM, reverse charge mechanism, your lordship.
Yes.
My lord, in fact, my lord, he is a wood transport operator. Now the service tax.
To be paid by IOCL only.
No, service tax, my lord, service tax is liable to be discharged by the service receiver. In case of, that is an exception is made. Now it has.
RCM is an exception.
RCM is an exception.
Advocates do exception. Same.
So that being the case, he has a prima facie case, my lord. I don't know other issues. But
Operation of Annexure A and G is stayed till the next date of hearing, taking into consideration the letter dated 34/25 issued by the IOCL indicating that they have discharged the service tax liability of the petitioner through reverse charge mechanism. Learned counsel for respond number 2 to verify and make a submission by next date of hearing. Released on 11th June.
Much obliged.
Lordship, on submission, filing a memo for posting list at the end of the list, the GST matter, they're claiming excess of
Yes.
input credit tax.
41
Huh.
filing the return submission and
ಕೊಡಿ ಎಲ್ಲರೂ ಕೊಡಿ ನೀವು ನಿಮ್ದೇನಾ ಸಾಕಾ
3 volumes.
ಯಾಕೋ ವೆಕೇಶನ್ಗಳು ಆಗಲ್ಲ ಅನ್ಸುತ್ತೆ ನೆಕ್ಸ್ಟ್ ವೆಕೇಶನ್
Same judgments, my lord.
ನೆಕ್ಸ್ಟ್ ವೆಕೇಶನ್ ವರ್ಗೂ all of you can file anyway. It's
What has happened, I met Rajgopal. Told that he has not prepared as on form. He requires 1 day or 2 days time, he'll hand over it to the office.
2:30 ಅಂತಿದೆ ಯಾರ್ಯಾರು ಏನ್ ಬೇಕೋ ಅವತ್ತು.
Sir.
ಅಷ್ಟ್ ಚೆನ್ನಾಗಿ ಸ್ಪೈರಲ್ ಬೈಂಡ್ ಮಾಡಿಸ್ಬಿಟ್ಟು ಕಟ್ಟೋದ್ ಬೇರೆ ಏನು? ಹಾ ಇದೆ ಸರ್ ಮಧ್ಯಾಹ್ನ. ಅದೇ ನಾನು ಅವಾಗ್ಲಿಂದ ಬರೀ ಫೋನ್ ಅಲ್ಲೇ ವಿಚಾರಿಸ್ತಿದ್ದೀನಿ. ಅವ್ರವ್ರಿಗೆ ಸಂಬಂಧಪಟ್ಟಿದ್ದು ಗೊತ್ತಿಲ್ಲ. ಇದೆ ಸರ್ ಇದೆ. ಇದೆ ಸರ್.
ಇಲ್ಲ ಸರ್.
ಫಾರ್ವರ್ಡ್ ಬೆಂಚ್ ಇತ್ತು.
ಇಲ್ಲೇ ಇರ್ತಾರಲ್ಲ ಸಾಹೇಬ್ರು.
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಮೇಡಮ್. ಕೋರ್ಟ್ ಆಫೀಸರ್ ಮೇಡಮ್.
2:30 ಎಂಡ್ ಆಫ್ ದಿ ಫೈಲ್ ಬಂದಾಗ
Court officer, madam.
ನಮ್ಮ ಕೋರ್ಟ್ ಅಲ್ಲೆಲ್ಲ 5 ಗಂಟೆಗೆ ಬರೋದು.
Court officer, madam. List number 2, serial number 24 ಏನಾಯ್ತು madam? Sir, madam.
ಒಂದೇ ಒಂದ್ ನಿಮಿಷ ಇರಿ ಮೇಡಮ್. ಇರಿ ಒಂದೇ ಒಂದ್ ನಿಮಿಷ ಇರಿ. ಅಲ್ಲ ಬರಿಬೇಕು ಮೆಮೋ. ಹೇಳಿ ಮೇಡಮ್ ಇವಾಗ.
List number 2, serial number 24 ಏನಾಯ್ತು madam?
ಅದು 5/6 5th ಜೂನ್. 5th ಜೂನ್.
ಅಲ್ಲ ಅರ್ಜನ ನೋಟಿಸಾ?
ಬಿ ಗ್ರೂಪ್ ಅಲ್ಲಿ ಇದ್ರೆ ನೋಟಿಸ್ ಹೆಂಗ್ ಮೇಡಮ್ ಆಗುತ್ತೆ? ಎಲ್ಲ ಆಗೋಗಿರುತ್ತಲ್ವಾ, ಎಲ್ಲರೂ ಸರ್ವ್ ಆಗಿರ್ತಾರೆ ಬಿ ಗ್ರೂಪ್ ಅಲ್ಲಿ ಲಿಸ್ಟ್ ಆದ್ರೆ.
ಅಲ್ಲ ಹಂಗಂದ್ರೆ ದೇ ಟೇಕನ್ ಫಾರ್ ಇಂಟ್ರಿಮ್ ರಿಲೀಫ್ ಅಂತ. Court officer, madam.
ಎಷ್ಟ್ರಾಗಿಲ್ಲ ಯಾಕ ಸೂರಜ್ ಬಂದ್ರೆ ಬರ್ರಿ ನಮ್ ಕಡೆ ಲಾಗಿನ್ ಇಲ್ಲ ನಿಮ್ಮಿಂದನೇ ಲಾಗಿನ್ ಆಗುವ ನಿಮ್ದೇ ಲಾಗಿನ್ ಈಗ ಅವಾಗ ನಮ್ದು ಲಾಗಿನ್ ಇಲ್ಲ ವಿ ಕನ್ಸೋಲ್ ಅಂದಿದೆ ಪಬ್ಲಿಕ್ ಅಂದಿದೆ ಮಾತಾಡಕ್ ಆಗಲ್ಲ ಇದು ವಿ ಕನ್ಸೋಲ್
ಇಲ್ಲ ಇನ್ನೂ ಬಂದಿಲ್ಲ 19 ಇಲ್ಲ ಒಂದ್ ಬ್ಯಾಚ್ ಕಳ್ಸಕ್ ಹೇಳಿದೀನಿ 3 ಗಂಟೆಗೆ ಇನ್ನೊಂದು ಲಿಖಿತ ಆಮೇಲೆ ಅಂತ ಹೇಳಿ ಹ? ಹೌದಾ ನಮ್ಗೆ ಏನು ಗೊತ್ತೇ ಆಗಲ್ಲ. ಹೌದಾ ನಮ್ಗಂತ ಇಲ್ಲಿ ಬಂದು ಕೇಳೋದ್ರಿಂದ ನಾವ್ ವಿಚಾರಿಸ್ತೀವಿ ಯಾರು ಏನು ಗೊತ್ತಿಲ್ಲ ಅಂತಾರೆ ಫೋನಲ್ಲಿ ಏನಿಲ್ಲ ನಿಮ್ಗೆಲ್ಲ ಯಾರು ಹೇಳ್ತಾರೆ ಹಂಗೆ ಗೊತ್ತಿಲ್ಲ. ಸರಿ ಹಂಗಾರೆ ನಾವೇನ್ ಮಾಡೋಣ ನಿಮ್ಮ ಎದುರುಗಡೆನೂ ಬಂದಾಗೆಲ್ಲ ಬರಲಿಲ್ಲ ಸೀರಿಯಲ್ ಮಾಡ್ಕೊಳ್ಳೋದು ಟೈಮ್ ಆಗ್ಬೇಕು. Dharwad bench matters. Pronouncement of orders, serial number 1. Prashant Gowda.
Yes. Appear for respondent.
In this case, I am for the petitioner, my lord.
ಯಾವ್ದ್ರಲ್ಲಿ ಇದು ಧಾರವಾಡ ಬೆಂಚ್ ಮಿಸ್ ಸೋಮಪುರ್ No grounds being made out, all the writ petitions are dismissed. Needless to say, all the parties would be required to be given adequate opportunity to place all the documents in evidence that they rely upon in support of their respective cases. Made clear that the appropriate government not having expressed any opinion on the merits of the controversy, this court has also not expressed any opinion. It would be for the Industrial Tribunal Labour Court to determine the issues independently in accordance with law by considering the evidence laid.
Reporting settlement, serial number 2.
Ms. Mallikarjun Swamy?
I appear for petitioner, my lords.
Yes.
My lords, we have already filed a compromise petition, my lords.
You have filed a compromise petition.
Yes, my lords.
My lord, I am for the respondent, my lord.
Yes, Mr. Kulkarni.
Yes, my lord, we have filed the consent terms along with the affidavits of both the parties, my lord.
Yes. So this house property will go to the petitioner and the rest will go to the society.
Yes, my lord.
A compromise petition. A consent terms has been filed, which reads as under. Accepting the said partition ಬೇಕಾಗಿಲ್ಲ. The said consent terms has been signed by the petitioner, identified by the counsel for the petitioner, as also by the authorized signatory of the respondent, identified by the counsel for the respondent. Both the counsels submit that the signatures on the consent terms are that of the respective parties. Accepting the said terms, consent terms, the above petition is disposed of in terms of the consent terms.
Obliged.
Number 2, serial number 1.
Yes.
Yes, I am for the petitioner, my lord.
Yes.
I have filed my objections to the affidavit filed by the respondent number 4, my lord.
You filed your objections. When did you file your objections?
Along with the objections, I also submitted a report of the engineer regarding the situation of my building. While demolishing his building, the respondent number 4 has caused many damages to my property, and I got it inspected by one of the engineer, and he gave a report, and I also submitted that report also.
Mr. Malli?
Yes, ma'am.
You still have not rectified all these issues.
I have filed, my lord, my affidavit dated 23 April 2025.
That is what they have filed a reply on 28/4.
No, my lord, now his case is that, my lord, I have to entirely, my lord, completely, I have to get, my lord, his entire building constructed, my lord, for him. That is what his
We'll consider it after vacation. An affidavit of respondent petitioner by way of statement of objection has been filed. The same is taken on record. Respondent number 2 and 3 are directed not to consider any application filed by the respondent number 4 till the next date of hearing. Relist on 5th June.
Please.
Announcement of order. List number 1, serial number 33. That's okay.
I appear for the second respondent, my lord.
Writ petition allowed. A circular is issued. The impugned order at Annex A dated 2/3/2015, passed by respondent number 1, is hereby quashed. Liberty is, however, reserved to the Assistant Commissioner to exercise powers of inquiry in respect of transaction and/or the receipt of donation, gift, etc. post 4/5/2011 in terms of Section 69 capital B of the Act of 1997.
Obliged.
34. Mohammed Ali.
Writ petition is partly allowed. A circular is issued, direction bearing so and so, dated so and so, issued by respondent number 4 at Annex A is quashed. Respondent number 5 society can continue to function in Beechnalli Gram Panchayat as per its bylaws. The impleading applicant would also be entitled to establish a new society in Beechnalli Gram Panchayat or beyond by following the due procedure, applicable rules and statute, as regards which the petitioners or respondent number 5 have categorically indicated that they have no objection. Furthermore, the petitioner or respondent number 5 cannot have any objection for the establishment of new society, since there is no particular restriction for only one society to operate in a particular Gram Panchayat. The registrar is directed to process the application, if any, filed or to be filed by the impleading applicants in accordance with law within the time frame prescribed under the Act as expeditiously as possible.
35, H.N. Basuraju, connected.
Respondent.
Writ petition number 20877 and 23569 of 2025 are dismissed. The administrator is directed to conduct the election as expeditiously as possible in terms of the calendar of events filed before the contempt court and ensure that the election is carried out and conducted in a free, fair, transparent, lawful and peaceful manner.
Great.
Bless.
36,
Petitioner. Respondent.
No grounds being made out, the writ petition stand dismissed. Registrar is directed to give effect to the modification proposed under subsection 5 of section 12 by registering the said modification amendment to the bylaws and to continue with the holding of the elections at the earliest in terms thereof. Though the above matter is disposed, relist on 4/6/2025 for reporting compliance with the above general direction. This is as regards that
Yes.
amendment to all those things.
Grateful.
37, Pradeep Kumar and corrected matter.
Writ petition WP number 32185 of 2024 is allowed. A certiorari is issued and communication bearing reference number so and so at Annexure B issued by respondent number 1 is quashed. Writ petition WP number 32106 of 25 is allowed in view of the quashing of the said communication WP 32185 of 2024. No orders are required to be passed in WP 32106 of 24. Though both the above petitions are disposed, relist on 15/7 for reporting compliance with general directions.
38, Ahmad Zahid.
Respondent.
Writ petition allowed. Respondent number 2 and 4 are directed to count the votes cast in election, including the votes of the petitioner kept in a separate ballot box and announce the result. Since the eligibility or otherwise of the petition has been considered and determined by this court as regards section 22A4, there would be no requirement for raising any dispute under subsection 2 of section 70 of the Karnataka Cooperative Societies Act 1959, insofar as the eligibility of the petitioner concerned with reference to section 20A4. Very well. Otherwise, you can. Yes. The declaration of result shall be final insofar as the eligibility of the petitioner concerned with reference to section 22A4. Liberty is reserved to any other aggrieved party to raise any other issue other than the eligibility of the petitioner under section 22A4 in proceedings under subsection 2 of section 70 of the Karnataka Cooperative Societies Act 1959. Great.
I seek for the operative portion for for pronouncement of results.
Everything will be, they'll have to take printout, we'll have to sign.
We'll communicate.
Take some time. Probably Monday it will be web hosted.
Monday.
Please.
39, H.N. Basuraju.
Petitioner.
In view of my findings on point number 1, 2 and 3, no grounds being made out, the petition stands dismissed.
40,
Respondent.
H.N. Basuraju.
No grounds being made out, the petition stands dismissed.
Grateful.
So all these issues under 12 are finished.
Marathon hearing and great.
Further arguments, number 41.
Submitting the submissions, written submissions, everything is complete.
Shri B. Ramesh, learned counsel for the petitioner in WP number 3690 of 2024 has filed a compilation of judgment along with his written submission. The same is taken on record. Shri Ajay Kumar M, counsel for the petitioner in 41.10 has filed his written submissions along with compilation of judgment. The same is taken on record. Anybody else for the petitioner?
1.5, my lord.
Anybody else for the petitioner?
2 days time we finish in the office.
2
days time we finish in the office.
Yavadappa?
2414.22.
CL number?
Serial number 2414.
24142. 41.9. 2 days will file it.
By Monday.
Counsel for the petitioner In 41.9, submit that the written submission with compilation will be filed given 3 days time. Registry is directed to accept the same and put up on the in the file.
41.5, my lord.
41.5.
Please.
Shri Clifton Rosario, learned counsel appearing for
Petitioner, my lord.
petitioner
Please.
in 41.5 as filed as written submission along with compilation of
Please.
judgment. The same is taken on record. ನಿಮ್ದಾಗಿದೆಯಲ್ಲ? Amicus then ತಗೊಂಡಿದ್ರ ವಾಪಸ್ಸು? What about amicus?
I'll check on that. Mr. Sondi was not well, is what I've heard. I'll just check with his junior.
He was in a meeting yesterday.
Oh, okay, he must have recovered. I'll check and.
Check and let us know so that we can close it.
Great.
Reserved for judgment.
Please.
Grateful, my lord.
Interim order may extend.
Interim order granted is extended till next day.
Last four matter. This number 1, this number 2. Refund update.
Yes, madam, similar matters?
Yes, ma'am.
Similar matters have been learned. SCGP accepts notice for respond number 1. Issue notice to respond number 2, returnable by 19th June. Similar matters have been dealt with by a coordinate bench of this court, while it's ordered dated 19th March 2025 in criminal petition number 11284 of 2024. The petitioner would also be entitled to the very same interim order. As such, the operation of further proceedings in CC number 1691 of 2024, pending on the file of the principal civil judge and JMFC at Irur, is stayed till the next date of hearing.
Serial number 14. Nagaraj is Jain.
Yes. Serial number 8.
Instruction in this matter, my lord, that item number 8, recovery officer can proceed with, my lord.
One submission. 8 to 9 ಗೆ ನಾವು ಮಕ್ಕಳು ಸೂಟ್ ಹಾಕಿರೋದು ಸೂಟ್ ಪೆಂಡಿಂಗ್ ಇದೆ ಅಂತೆ ಆ ಗಿಫ್ಟ್ ಮಾಡಿ GS ನಾಗರಾಜ್ ಸತ್ತೋಗಿರೋದು ಮಕ್ಕಳಿಗೆ ಗಿಫ್ಟ್ ಮಾಡಿ ಮಕ್ಕಳು ಇವಾಗ ಸೂಟ್ ಹಾಕೊಂಡು ಪೆಂಡಿಂಗ್ ಇದೆ ಅಂತ ಹೇಳ್ತಾರೆ ಬ್ಯಾಂಕ್ ಇನ್ಸ್ಪೆಕ್ಷನ್ ಅಲ್ಲಿ ಇರೋದ್ರಲ್ಲಿ 22 ಬಿಟ್ರೆ ಇನ್ನೆಲ್ಲದೂ ಲಿಟಿಗೇಷನ್ ಇದೆ ಸರ್ ಅದರಲ್ಲಿ 1 to 7
Are there any litigations pending, Mr. Jain?
ಇಲ್ಲ suit is not filed in respect of that property, my lord.
ಮಕ್ಕಳಿಂದ ಏನು ಅಬ್ಜೆಕ್ಷನ್ ಇಲ್ಲ
No, I have plain copy. They have not filed a suit in respect of that property, my lord. So whatever suit is filed in respect of the property which is already been sold, the schedule may kindly be produced, ma'am.
Our concept.
You have no objection as the petitioner.
Yes.
Your children have no objection for sale of serial number 8. Can we take it as that?
Yes, my lord.
So you
8
give
to
a affidavit to them in 1 week's time from now. We'll restrain them from selling the petition scheduled property till the next date. If you don't give the affidavit, they'll be entitled to sell.
So I can give affidavit, my lord, so far as my daughters are concerned. They have filed the suit.
That is
Here-
why we are asking you. If you can give a property which is without any litigation,
Yes.
then we can give you this order.
Even my
If you
lord.
say illa yav property nu illa andre ee property sale ಮಾಡ್ತಾರೆ.
ಇಲ್ಲ ಇದರಲ್ಲಿ there are several other properties, lordship have produced a list of properties.
50 lakhs, 50 lakhs, 3
ಅಲ್ಲ,
crores.
ಇದರಲ್ಲಿ ಅಲ್ಲ,
You is
size-
15 crores.
There are 24 sites, my lord, you worth around 11 crores, my lord. ನಾನು
15
market
ಕೋಟಿ
value
ಬೇಕಪ್ಪ
ಹಾಕಿದ್ದೀನಿ.
ಅಲ್ಲಿ 15 ಕೋಟಿ ಬೇಕು.
ಅಲ್ಲ, apart from that, other properties are there, my lord. I am just guarantor, my property was not mortgaged in favor of the bank, my lord. That is my contention. The
Morning-
award is also very clear, my
morning
lord.
You told us serial number 8
Please.
at page 169. If you can give the affidavit of your children,
I can give, my lord, but not on behalf of,
learned counsel for the respondent seeks for 2 weeks' time to file a statement. of
lordship,
objection.
kindly.
Pre-list on 5th June.
ಅಲ್ಲ, lordship, my submission, my lord.
Your
Here, my lord,
submission?
the award is very clear, my lord. They cannot
Give
go
you an
beyond.
option.
ಅಲ್ಲ,
You
there
want
is-
to give that property, you can give it, otherwise ಇಲ್ಲ.
ಅಲ್ಲ, ನಾನು affidavit ಕೊಡ್ತೀನಿ ಸ್ವಾಮಿ.
ಯಾರ್ದು?
And as well as daughters insist for
ಅಷ್ಟ್
that.
ಕೇಳಕ್ ಆಗ್ಲಿಂದ ಯಾಕೆ?
ಅಲ್ಲ ಈಗ
ಕೊಡಿ.
2015
ಎಲ್ಲರಿಗೂ ಡಬಲ್
award
ಕೆಲಸ
ಆಗಿ-
ಮಾಡಿಸ್ತೀರಾ.
ಇದುವರೆಗೆ ಅವಾರ್ಡ್ ಚಾಲೆಂಜ್ ಮಾಡಿಲ್ಲ ಅವರು.
Lord counsel for the petitioner submits that the petitioner, as also the family of the petitioner, will not have any objection to the respondent bank bringing to auction property at sale number 8 to annexure P
ಒಂದು ಸಬ್ಮಿಷನ್
at page 169, being commercial land and building in survey number 179, measuring 6 acres 14 guntas, situated at Abbalgere Gram Panchayat,
limit.
Muttodu, Shumaga. He submits that an affidavit of the petitioner along with the affidavits of the children of the petitioner would be furnished to the respondent bank, indicating there no objection for sale of the said property. In that view of the matter, the respondents are restrained from auctioning the property described in the schedule to the petition. Affidavit to be furnished to the bank by end of day 9th May 2025. If the said affidavit is not furnished by 9th May 2025, the benefit of the above interim order will stand rescinded and the bank would be entitled to auction the petition scheduled property on 20, ಯಾವತ್ತಿದೆ? 29/5 ಅಲ್ಲ?
29
Lordship,
May ಮೇಲೆ.
On 29/5.
later more time to.
Affidavit ಕೊಡಕ್ಕೆ 10 ದಿನ ಬೇಕಾ?
ಇಲ್ಲಿ ಯಾಕಂದ್ರೆ it is that property is also not part of that original suit, my lord. That is.
Give the affidavit, that's it. Next. Released on 12th June.
Obliged.
Serial number 18.
My lord, just one submission, please. Sir, I checked with his office, they are filed.
The, really, SPST matter. On behalf of the learned amicus, also it is submitted, it's submitted that the final written submission along with final compilation of judgments has been filed. The same is taken on record.
Great.
Serial number 18.
Very good. Petitioner.
ನೋಡಿದ್ರ?
ನೋಡಿದೆ. There is a discrepancy ಅದರಲ್ಲಿನ ಮಧ್ಯದಲ್ಲಿ ಕೆಲವೆಲ್ಲ pages ಖಾಲಿ ಬಿಟ್ಟು ಇದೆಲ್ಲ ಮಾಡಿದ್ದಾರೆ. As per my.
They are anyway directing inquiry.
Please.
ಅದಾಗಿ ಆಗುತ್ತೆ, but you won't be entitled for any relief.
Even otherwise, my lord, giving up regarding the option of the petition number 7. Petition number 2 has not tendered his resignation, and even there are, then also the 6 members will be there out of the 11 elected.
ಎಲ್ಲಾಗತ್ತೆ?
ಹೌದು, 5 ಜನ ಇದು ಮಾಡಿದ್ರು.
6 ಜನ ರಿಟೈರ್ ಆದ್ರು, ರಿಸೈನ್ ಮಾಡಿದ್ರು.
5 ಜನ.
6
ಇಲ್ಲ,
ಕೋಆಪ್ಷನ್ ಬರೋದ್ ಕ್ವಶನ್ ಇಲ್ಲ. ನೀವು ಕೋಆಪ್ಷನ್ ಬಂದ್ರೆ 6 ಅಂತೀರಾ?
ಇಲ್ಲ, 6 ಜನರಲ್ಲಿ ಒಬ್ಬ ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಹೇಳಿದ್ರಿ petition number 2.
6 ಜನ ನೀವೇ ಹೆಸರು ಕೊಟ್ಟಿದ್ದೀರಪ್ಪ.
ಅಲ್ಲ, ನಾವು ಕೊಟ್ಟಿದ್ದಲ್ಲ, ಅವರು ಸಿಇಒ ಕೊಟ್ಟರು.
ಆರೇಗೌಡ, ರಾಜು, ಶಿವಣ್ಣ, ಬೈರೇಗೌಡ,
ಹೌದು, ಈ
ಶಿವಕುಮಾರ್,
ಬೈರೇಗೌಡನ is the second petitioner here before your lordship's my lord. And he is saying that he has not tendered his resignation.
That is why they'll do inquiry. That inquiry will do.
Till then, my lord.
Till then ಆಗಲ್ಲ. How can you continue? Co-option will also not happen.
The co-option, my lord, even excluding the co-option, my lord, 5 ಜನ ಹೋದ್ರುನು 6 ಜನ ಉಳಿತಾರೆ. Out of 11 elected.
That is why the inquiry, if they have given or not. ಅಲ್ಲಿ ಮೀಟಿಂಗ್ ಎಲ್ಲ ಬರೀ 4 ಜನ ಇದ್ದಾರೆ. 3 ಜನ ಸಿಗ್ನೇಚರ್, 1 thumb impression.
ಹೌದು. Even giving up that contention, my lord, that there is a co-option.
You can't give up like that. Minute book.
So far as that aspect, my lord, I will leave it to your lordship's, my lord. I don't have
the minute book. There are only 4 people who have signed. The 3 people who have signed and 1 thumb impression.
That is only regarding co-option. So that aspect, my lord, I will leave to your lordship's, my lord. I am not arguing on that point.
You can't continue until this is resolved.
Even excluding that, my lord, there will be 6 members is my contention, my lord, out of the 11 elected.
Respond number 3. He stated to have submitted 6 resignation letters of the elected directors, namely Shri Shivkumar, Shri Maregowda, Shri Raju, Shri Shivanna, Shri Bairegowda, and Shri Nagaraju. Shri Jayaprakash Reddy, learned counsel for the petition, submits that Shri Maregowda, yar kotila? Bairegowda had not submitted a resignation, and the resignation letter submitted by respondent number 3 is a fabricated document. His submission is also that Shri Nagaraju had earlier submitted a resignation on 21/2/25.
Nagaraju, son of Puttaswamy, son of Puttaswamy.
Nagaraju, son of Puttaswamy, had tendered his resignation on 21/2/25, which had been accepted on 7/3/2024, and in his place, one Shri Shivlinga Gowda had been co-opted in the meeting held on 7/3/25. The original minute book of the respondent number 3 society has been produced. The meeting of 7/3/2025 does not indicate any co-option as contended by the petitioner, nor the acceptance of the resignation of Shri Nagaraju, son of Puttaswamy.
ಅದರಲ್ಲಿ ಇದೆ, but only 4 members have attended meeting. ಅದ್ರದ್ದು ಕೋಆಪ್ಷನ್ ಇಂದು ರೆಸಿಗ್ನೇಷನ್ ಬರೆದಿದ್ದಾರೆ, ಬಟ್ ಕೋರಂ ಬರೋದಿಲ್ಲ.
ನಿಮ್ಮದ್ರಲ್ಲಿ ಇದೆ, ಅವ್ರದಲ್ಲಿ ಬುಕ್ ಅಲ್ಲಿ
ಅವ್ರದಲ್ಲೂ ಇದೆ. serial number 6. Item number 6.
ಎಲ್ಲಿದೆ ಓದ್ಬಿಡಿ, ಅವ್ರ ತೋರಿಸಿ ಅವ್ರಿಗೂ.
ಐಟಮ್ ನಂಬರ್ 6 ಮುಂದಿನ ವಿಷಯ ಅಧ್ಯಕ್ಷರ ಅಪ್ಪಣೆಯ ಮೇರೆಗೆ ನಿರ್ದೇಶಕರಾದ ಸಿದ್ದೇಗೌಡ ಅವರು ಎಲ್ ಶಿವಣ್ಣರವರು ಇವರು ಸುಮಾರು 6-7 ವರ್ಷ ಅದಾದ್ಮೇಲೆ ಐಟಮ್ ನಂಬರ್ 2 ಶ್ರೀ ನಾಗರಾಜು ಬಿನ್ ಪುಟ್ಟಸ್ವಾಮಿ ಎಂಬ ನಿರ್ದೇಶಕರಾದ ಅವರು ವೈಯಕ್ತಿಕ ಕಾರಣ ತಿಳಿಸಿ ರಾಜೀನಾಮೆ ನೀಡಿರುವುದರಿಂದ ಈ ಬಗ್ಗೆ ಚರ್ಚಿಸಿ ಶ್ರೀಯುತರನ್ನು ಸಭೆಗೆ ಕರೆಸಿ ಅವರನ್ನು ಕೇಳಲಾಗಿ ಅವರು ನನ್ನ
ಡೇಟ್ ಏನಿದೆ 21/2 ಇಲ್ವಲ್ಲ?
ಹೌದು 7/3 ಇದೆ, ಡೇಟ್ ಹಾಕಿಲ್ಲ.
5/3 resignation letters.
This is 7/3 resolution I am reading.
Correct. They are containing 5/3. This resignation is there of 5/3. You are containing 21/2. 21/2 ಅಂತ ಅಲ್ಲಿಲ್ಲ.
21/2 ಬಗ್ಗೆ ಇಲ್ಲ, 7/3 ನಲ್ಲಿ ಇದ್ರದ್ದು ಇದು ಮಾಡಿ ರೆಸೊಲ್ಯೂಷನ್ ಮಾಡಿ ಅವ್ರ ಜಾಗಕ್ಕೆ ಇವ್ರನ್ನ ಕೌಟ್ ಮಾಡಿ ಇವತ್ತಿದೆ.
The resolution does not bear reference to the resignation of Shri Nagaraju, son of Puttaswamy, dated 21/2/25. However, there is one other resolution which has been produced by the petitioners at Annexure B at page 14 to 17 of the present petition, which bears the signatures of 6 directors and 2 thumb impression of 2 directors.
5 directors and
this being contrary to the original book which has been placed on record. Hence, the Registrar Cooperative Societies is directed to cause an inquiry into the matter to determine as to which of them is the original resolution, and place a report before this court within 4 weeks' time from now. Relist on 12th June to consider the report which has been submitted. In view of there being contradictory resolution which have been placed on record, it cannot also be accepted that respondent number 3 has refused to receive the summons and summons. Hence, IA 2 of 25 is allowed. The order dated 9/4/25 stands recalled.
List number 2, number 15.
Present respondents 1 to 5.
For petition, my lord.
Yes.
My lord, with respect to
Compliance.
With respect to clause 15. This on court.
Statement of objections. Is memo of objections. Yes.
Clause 15. And proviso mentioned that one, higher educational institution is satisfied that at least 75% of the program of study stipulated for semester or year has been actually conducted. Two, for open and distance learning mode, the learner has minimum attendance of 75% in the program specific personal contact program, excluding counseling and lab component of each of the programs, and detailed attendance records have been maintained by the learner support center, regional center, higher educational institution. Three, for online mode, my lord, this the petitioner institution as well as students are distance and open university students. They are no way connected with online. This online is entirely different.
Right, 1 and 2.
1 and 2, my lord. After payment of admission fees, the portal will open.
If they attended the classes conducted,
that has to be provided by the petition institution.
So there's no document on record to show that.
There is no document on record to show, because the university has to accept the fees. Then the portal will
join them in the next year.
My lord, my submission with respect, the same student, I am furnishing copy. Second semester's internal assessment marks have been given. It will open after accepting the fee by the university, respondent university. It will be opened, my lord.
See, we can try and condone your non-payment.
Please,
can't condone your non-conducting of the classes.
No, we have my lord, my respectful submission before
but there is nothing on record to show that you are conducting.
Because it is not going to be opened. One. Second thing, with respect to class 15.
That cannot be done, Mr.
My lord, one more submission, my lord. I may be permitted to. It has been amended. The 75% is given some lenience.
Yeah, torsi.
Swami,
have to give us a document.
Copy. ನಾನು ಓದಬಹುದಾ ಸ್ವಾಮಿ?
ನಿಮ್ 20% ಏನು ಇಲ್ಲ ತೋರ್ಸಕ್ಕೆ, 1% ಇಲ್ಲ.
ಅಲ್ಲ ಸ್ವಾಮಿ,
ಪ್ರತಿಯೊಂದು one class they've attended.
They have attended, my lord. My submission with respect, my lord.
Can't go by your submission.
No, my submission
on record.
Because if they allow us to pay the fee.
ಅದಕ್ಕೆ ಬೆಳಗಿಂದ ನಾನು 3 ಸತಿ ಆಪ್ಷನ್ ಕೊಟ್ಟಿದ್ದೆ.
ಹೌದು ಸ್ವಾಮಿ.
ಏನು ಕೊಡಕ್ಕಾಗಿಲ್ಲ.
ಅವಕಾಶ ಕೊಟ್ಟಿದ್ದೀರಿ ತಾವು.
We want to help the students, but
they have attended. We
have
got records. It has to be, the portal has to be opened, my lord, because now
you pay the fees, they'll open the portal, let them attend the classes, and thereafter they can take the exam. When will you pay the fees?
Tomorrow itself we will pay the fees, my lord, because
if they pay tomorrow, you'll open the portal so that they can start attending classes for the next year.
Yes, ma'am. Next year, my lord, they can.
My lord, Monday the examination is going to open.
We can't do that. We can't override the policy like that.
My lord, it has been amended, my lord. I am not in a position to present.
In 0% ಅಂತಿದ್ಯಾ Mr.
0% ಅಂತಿಲ್ಲ ಸ್ವಾಮಿ. ಬಾಕಿ ಎಲ್ಲ ಪ್ರೊಸೀಜರ್ ನಾವು ಫಾಲೋ ಮಾಡಿದ್ದಾರೆ.
We can't pass a wrong order like that.
Because first year they have allowed, the same university allowed all the students, and also the registration numbers have been given to them.
We can't pass a wrong order like that.
I may be permitted.
Petitioner is before this court seeking for the following reliefs. The contention of Sri Vasanta A.K. Learned Counsel for the petitioner is that the portal could not be opened by the respondents on account of non-payment of fees by the petitioner, and as such the attendance or otherwise of the petitioner, students of the petitioner could not be recorded in the portal.
Please.
He, however, submits that the students have attended all the classes conducted by the petitioner, and therefore they should be allowed to appear for the exams to be conducted from
Monday, 5th May.
From 5th
of May.
From 5th May na 8th May na?
8th May. Timetable ಹಾಕಿದ್ರು, ಅವ್ರು ಹಾಕಿದ್ದಾರೆ.
8/5.
From 8/5/2025. Sri Rajan Kumar Sungde, Learned Counsel for respond number 1 to 5, however, opposes the same. Firstly, on the ground that the payments have not been made for the last whole year, and as such, respondent number 125 have not taken the students on record and admitted them as students of respondent number 125. His further submission is that there being contact classes which are held from time to time, it is required for the students to attend the same and for internal assessments to be carried out by respondent number 125 to assess the suitability of the students, and it's only thereafter that they will be permitted to take up the examination. He submits that if the petitioner were to make payment of the due fees, the portal would be opened. Thereafter, the students of the petitioner could attend the classes. They could be assessed and thereafter take up the examination for the next year.
Yes.
Shri Vasanta AK, learned counsel for the petitioner, persists by stating that the students of the petitioner have attended the classes and they are trained suitably enough to take up the exams. And as such, they may be permitted to take up the exams. Heard Shri Vasanta AK, learned counsel for the petitioner, Shri Rajan Kumar Sungi, learned counsel for respondent number 125, peruse papers. Clause, the petitioner is a learner support center within the meaning of sub-regulation R of regulation 2 of the University Grants Commission bracket open and distance learning programs and online programs bracket close regulation 2020. In terms of regulation 14, the manner and methodology of admission is being provided, and in terms of clause 15, the common provision for open and distance learning mode and online mode evaluation has been provided. Sub-regulation 3 of regulation 15 requires that the evaluation shall be of two types. One, continuous or formative assessment. Two, summative assessment in the form of end semester examination or term end examination. Provided that no end semester examination or term end examination shall be held in the subject unless the higher education institution, in this case, respondent number 125, is satisfied that at least 75% of the program of study stipulated for the semester or year has actually been conducted, and the learner has minimum attendance of 75% in the program specific personal contact program and lab component of each of the programs. The submission of Shri Vasanta Ekela and counsel for the petitioner is that since the portal had not been opened, the attendance of the students could not be captured, and as such, the non-capturing of the attendance should not be held against the petitioner. There is nothing which has been placed on record to indicate whether the learner has attended any of the programs. If so, how many programs? What is the percentage of attendance? And if the lab program component has been attended by such a person, such a learner. This being the prerequisite for summative assessment in the form of end semester examination, the prerequisite not having been satisfied, I am of the considered opinion that there cannot be an exception made out to the petitioners to take up the examination without complying with the proviso to sub-regulation 3 of regulation 15 of the aforesaid regulations. In that view of the matter, no grounds being made out, the petition stands dismissed. Liberty is, however, reserved to the petitioner to make payment of the due amounts, directing respondent number 125 to open the portal within 1 week after such payment, record the attendance of the students going forward, and enable the students to take up the examinations next to be conducted.
My lord, one submission. This is not the end semester, my lord. End semester means this is the third semester.
We can't do it contrary to law. Please.
That fee has to be paid by the students, my lord, not the petitioner college, my lord, not the petitioner institution.
Petitioner college stroke student.
Yes.
Ibral yaar kotre enante nimge.
Allah. The petitioner has no locus standi, my lord, to file on behalf of the students.
Yes.
Because they cannot.
Students only they are going to
He'll
pay.
collect it and pay it. You have to receive it. You have to open the portal.
That's of the student.
Yes.
Students can.
My lords, appearing for petitioner, my lords.
Appearing for the respondent.
I'm the engineering student, my lords. I was supposed to complete the
1 year excess
year
again.
extra.
Any golden
6
handshake?
years. My lords, if any future time ಅಲ್ಲಿ ಏನಾದ್ರು ಕೊಟ್ರೆ let them take the opportunity.
Let's ನೀವೇ my lords.
ಯಾವ್ದ್ರಲ್ಲಿ ಏನಾದ್ರು ಆರ್ಡರ್ ಆಗಿದ್ಯಾ?
Please, ಇಲ್ಲ my lords.
ಆಗಿಲ್ಲ.
Like your lordship has passed an order stating that policy cannot be in education idರಲ್ಲಿ. If any chances are being given,
Your lordship
let
only
them take
passed.
control.
ಅದರ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ has said that. ಆಮೇಲೆ ಏನೂ ಆಗಿಲ್ಲ. ನೀವು ಪಾಲಿಸಿ ಕೊಟ್ಟಿಲ್ಲ.
2016 to 22 6 years ಆಗಿದೆ. So they are not completed till now, my lord.
ಇಂಜಿನಿಯರಿಂಗ್ 4 years ಬರೀ 2 ವರ್ಷ ಎಕ್ಸ್ಟ್ರಾ ಕೊಟ್ಟಿದ್ರಲ್ರಿ.
My lords, ಇಲ್ಲ my lords, ಇದು 3 years. ಅವರು lateral entry ಅಂತ ತಗೊಂಡಿರಲ್ಲ.
6 years, my lords. The regulation.
3+3, my lords. So in future,
3 years
if the
course, 6
university-
years ಅಲ್ಲೂ ಮುಗಿಸಿ.
ಇಲ್ಲ ಸ್ವಾಮಿ, regulation page number 26, my lords. 6 years will come. Avre in the endorsement they only, my lords, in the page number 51, my lords. Avre ಹೇಳ್ತಾರೆ ಸ್ವಾಮಿ, ಕಾಲೇಜ್ ಅವರು. As presently she has no backlogs. Her eligibility for 6 years has been completed during the academic year 21-22 and she is not eligible for 4th year B as per the regulations of
You have
BTU.
done only third year.
Third year, my lords, without no backlogs. 4th year 1 year
3
extension.
ವರ್ಷದಲ್ಲಿ ಬರೀ ಥರ್ಡ್ ಇಯರ್ ಮಾಡಿದೀರ.
ಅಲ್ಲ my lords, 6 years total ಇರೋದು ಸ್ವಾಮಿ.
3+3 ಅಲ್ಲಿ.
Lords, in
4
future, if
years,
the university decides
my
to
lords,
extend, let them take the benefit of it.
ಏನು ಮಾಡಿಲ್ವಾ?
My lords, what happened, my lords, in the year COVID ಅಲ್ಲಿ my father has been expired, my lords, and financial distress,
Supreme
all
Court
these
has
things.
clearly said not to do it. We are bound by Supreme Court order.
My lords, I am
Unless the
seeking
Supreme
only
Court has said
in-
unless they come up with a policy, you won't be entitled. Our policy ಬಂದು
Because coordinate bench is also.
Let's ನೀವು we have given permission for.
ಅಲ್ಲಿ ಸ್ವಲ್ಪ ಏನೋ ಅವ್ರು ಮಾಡ್ಲಿ ಅಂತ ಹೇಳಿದ್ವಿ, ಇನ್ನ ಮಾಡಿಲ್ಲ ಅವರು. ಕೋವಿಡ್ ಟೈಮ್ ಅಲ್ಲಿ
Relaxation.
Please, my lords.
Now we can't go with Supreme Court judgment is there. But COVID time we should consider for these two.
My lords, if we receive large number of representations from students, we may extend, my lords. ಆ ತರ ಇರುತ್ತೆ.
ಮಾಡಬೇಕು. COVID time has to be considered for everybody.
Put across to the university.
We'll have it next week. Liberty is reserved to the petitioner to move the vacation bench. ನೋಡಿ, COVID ಏನಾದ್ರು exception ಮಾಡಿದ್ರೆ, we are giving exception everywhere for COVID.
Because it was like in the year 2021, later they have come now, my lords, after a period of 4 years.
Supreme Court judgment is there, now you have to come up with
Point
your.
of time,
Yes,
they
I
might have
made a
given the benefits,
representation
my
in the year 2022 itself, my lords, when
We
my.
have given the benefits during those times, my lords, but the petitioner did
Let's,
not.
they have
avail
given
it.
endorsement, VTU has
ಸ್ವಲ್ಪ
given
late
endorsement.
ಬಂದ್ರು, but reason is the same. Reason is the same. COVID ಕೊಡ್ಬೇಕು.
We'll seek instructions.
ನೋಡಿ ಹೇಳಿ.
Please.
It's after vacation on date code.
After vacation. Released on 5th June.
Please, my lords.
Please, my lords. Let's let
To
them
enable the council for respondent to obtain instructions and make a submission as to whether any indulgence would be extended by the university, taking into account the COVID pandemic
Please.
for students who did not clear the exam within that, during that time.
Much obliged.
233 matters. Serial number 1, G. Manjunath.
RFA ಏನಂತ ನೋಡಿ. Yes, Mr. Manjunath. Relief ಏನಿಲ್ಲ. Issue notice to the respondents returnable by 19 June operation of the judgment decree dated 1/4/2025 in OS number 2535 of 2013 is stayed till the next date of hearing. Process fee and copies by end of day 5th May, failing with the interim order will stand automatically vacated. Last.
Serial number 2,
Office objection to be complied by next date.
Pawan TG.
Mr. Pawan,
Lordship, for the appellant in this case, Your Lordship.
any interim orders?
Your Lordship, in this case, what has happened is the suit was dismissed for the reason stating that we have not produced the genealogical tree, wherein the relationship itself was not disputed by the defendants and
The suit
petitioners.
and the counterclaim have been dismissed.
Please, Your Lordship.
Any notice? Why have you moved it now?
Your Lordship, because they are trying to alienate the property, Your Lordship, change the possession of the property. Insofar as that,
Was there injunction before the trial court?
no, Your Lordship.
How can we grant it now?
Your Lordship, even when we filed the RFA, the liberty was granted by the this honorable court saying that you can make your rights.
If there
And
was no injunction before the trial court in appeal, how can you ask for that?
Your Lordship, because they're changing the nature of the property.
Notice
Your
to
Lordship.
respond number 1 to 31, returnable by 5th June.
Please, Your Lordship.
Serial number 3,
Counsel for the appellant is also permitted to serve the counsel for the respondents before the trial court.
A pleasure, Lordship.
This is the matter, my lord. We moved a memo that your lordship is directed to complete the
Extension of time
investigation. Yes, my lord. We are seeking for 2 months' time, my lord. That was a delay in.
The additional SPP submit that the investigation could not be completed. He submits that given 60 more days time.
2 months, 2 months, 2 months.
60 days, 2 months. Given 2 months more time, the investigation would be completed. Hence, the time granted, while order dated 8 November 2024 is extended by a period of 2 months from today.
Great, sir.
serial number 4, R. Bajaj.
This case appearing for the auction purchase and by law.
I appear for the petition. We had spoken to the auction purchase, no? As against 50 lakhs, I am agreed to pay 20 lakhs. No, but regarding, I insisted for the bank statement. What is the due? Till today, I had not been given to me.
Not
My lord, we have just given everything. my
You are
lord.
for the bank, madam.
Please, my lord.
Who is for the auction purchase?
The auction. I believe my learned friend has offered to pay 20 lakhs more. My client, I spoke to him, he said another 5 more lakhs he has insisted for. With that, he is ready to close. Otherwise, he says, let us argue.
So you are nearby.
Yes, ma'am.
Mr. Badrinath has made his effort.
Yes.
My lord,
Yes,
there
ma'am.
is
As
one
against-
more-
I'll come.
I'm sorry to interrupt here, my lord. What they are just saying is, whatever you have paid to the bank, you receive that entire amount from the bank ಅಂತ ಹೇಳ್ತಿದ್ದಾರೆ. ನಮ್ದು ಲೋನ್ ಅಮೌಂಟ್ ಎಲ್ಲ ಯಾರು ಕಟ್ತಾರೆ ಸ್ವಾಮಿ? After deducting our dues, whatever dues they are.
Bank dues, sir, I am agreeing, I will pay, my lord. I will pay. If the auction purchase with both us to be settled, then we can be doing. As against the 55 lakhs which I had paid by the auction purchaser, I am paying 20 lakhs for 9 months.
So 75 lakhs you are paying, you are agreed.
Yes, sir.
So they are
55
asking
lakhs
for
with the
80,
bank
you are
duties.
at 75. So
55 lakhs with the bank.
first week of June, you report your compliance, including the bank.
Yes.
So you have to satisfy everybody.
Yes, I'll do.
Lord,
I'll do it.
my own humble submission. One is that we are expecting 80 lakhs for settlement. Number 2, the payment has to be made to us directly. Insofar as the bank liability is concerned, it is for the borrower and the bank. We have nothing to do with that. The moment we receive our payment,
Dwelling
we will
house.
express no objection.
Yes, well.
It's a dwelling house.
My lord,
It's a dwelling house.
my lord, I am a bona fide purchaser. I have
However
got-
bona fide you may be dwelling house, we'll go this side.
no, they have
The
here.
commercial establishment, yes.
Yes, my lord, I have to make one submission, my lord, if your lordship permit me. The award was passed way back in 2019. The award was not challenged under the Karnataka Cooperative Societies Act. They should have challenged the award. They have not challenged it. The award has become final. When the award has become final, the bank has got the right to auction the property. When the auction was conducted, there is no fault found out in the auction. There is no fault against the
Now
auction
is
purchaser.
covered, you're-
My
you're
learned friend is
getting
holding the
20 lakhs
wakalat
just
for the
like
bank,
that.
not for the auction purchaser.
For nothing, you are getting 20 lakhs.
I am not denying.
For
it.
9
As far
months,
as
it's
the-
more than.
As far as the addition is concerned, I am not denying it.
My lord,
I'm not-
first they
that
have
is-
to clear a
You
bank.
also don't be greedy.
I'm not greedy, my lord.
You advise your client also. 20 lakhs you're getting for nothing.
See,
That's why I requested plus or minus.
plus or minus something, I can convince the,
Yeah, on 2 lakhs.
That's a 2.5.
I will convince. 2.5 lakhs, I will convince.
ನೀವಿರ್ರಿ madam, first town close ಮಾಡಿ. ನೀವು ಒಳ್ಳೆ bank.
Another
Don't
2.
be Shylock. First let us clear these people.
25, 5 lakhs.
ನೀವು purchaser ga?
Action purchase. 2.5 make it. This one.
Both of you are the same.
That's all.
21, I am last one.
Yeah.
That is not
Again-
fair. That is not fair, my lord.
50 as against 50 lakhs and
They say
for
that
9 months, who will be paying, madam? I can look into it.
In property, ಹೋಗ್ತಾ ಇದೆ ರೀ.
1.35 lakhs.
For small amount, don't lose your property. We can only tell them not to be greedy. You also don't lose your property.
win-win situation should be
It's
there.
come so close. They also agreed. Not very easy. No, you speak to them and close it. Yes, madam. Name them.
First, they have to clear our dues, my lord. Otherwise, what the bank is going to do is, whatever amount through action sale we have received, in that we deduct our amount and then we give the balance amount to them. That's all.
Absolutely.
As on today, I apply a 15 lakhs DD to the bank itself now itself.
How much is the due of the bank?
Due is, my lord, after deducting 55 lakhs, 25,000 is the action sale, my lord. As on today, my lord, it is 31 lakhs, 37 lakhs, 46,510. Before filing the writ petition, it was. Then after writ petition, my lord, as per the order, they have just deposited 6 lakhs. If we deduct 6 lakhs, my lord, it is 31 lakhs, 46,510. After that, my lord, they have not made any payments.
And today-
Now it comes to around 37 lakhs. No.
One crore 10 lakhs approximately.
15 lakhs, 15 lakhs is there. I'm handing over to the
First ella settlement or 15 lakhs, they'll take it to their interest and account for it. You won't give small amounts, which they will only do that. ಇಲ್ಲಿ ಸ್ಟೇ ಮಾಡೋದಲ್ಲ ಹೆಚ್ಚು ನಾವು. ನೀವು ಆಮೇಲೆ ಅಷ್ಟೇ ಅಲ್ಲಿ ಸುಮ್ಮನೆ ಹಂಗೆ ಇದ್ಬಿಟ್ರೆ ಎಲ್ಲ ದುಡ್ಡು ಬ್ಯಾಂಕ್ ಶೈಲಾಕ್. The EMI calculation is first interest, small principal. That's what we have directed in another matter also. Principal will be collected in 10 years.
Look, the conduct of the petitioner is like this. They have issued 39 lakhs for check. That check got bounced. 138 case has been filed. They have challenged the 138 case in 482 application before the High Court. Matter is pending. They have not paid single paise in that. If this is the conduct
They
of.
have paid
is
all
for
of
issued
it.
for the
Why
security
would this
purpose.
case be before us? You would also not be before us.
So the conduct I'm
They're
saying.
trying to solve the issue here. There's a human problem.
We are fine. We are fine.
You are only a purchaser. Bank will anyway get its pound of flesh. You will have to end up paying.
ನಾವು ಹೇಳಿದ್ರೆ ಚೆನ್ನಾಗಿರುತ್ತೆ ಸಂಜು. 2.5 lakhs ಪ್ರೊಟೆಕ್ಟ್ ಕ್ಲೋಸ್ ಮ್ಯಾಟರ್ನ ಕ್ಲೋಸ್ ಆಗುತ್ತೆ
ಒಬ್ಬರದಂತೂ ನೀವು ಕ್ಲೋಸ್ ಮಾಡಬಹುದು
ಅಷ್ಟೇ.
ಆಮೇಲೆ ಇವ್ರದ್ದು
Both are.
revise ಮಾಡಿ then you arrange for some time to pay. How much to regularize the account, madam?
Account is already over. The term is already over.
A top-up loan.
34 lakhs to close. As on today, to close 34 lakhs. 34 lakhs.
Top-up loan with a further time period of 3 years to pay.
That
Something
was
like
only. After that, only we have initiated all actions. He has not challenged the award passed with the cooperative societies. Appeal provision was there. That he has just not approved the cooperative society. Appeal is not filed. Award has attained finality, my lord.
As on the date of auction, what they conducted, letting collect the interest up to that date itself. After that, they cannot collect the bank interest also. To that statement, to verify that statement, I am asking for the bank statement to be produced.
Bank statement.
My lord, that we have just given. I'll give one more set of this thing that cannot be directed to the bank. My lord.
You'll send the bank statement to the email ID of Mr. Badrinath.
My lord.
By when?
By today evening or tomorrow.
Yes. Ms. Gaurav, sir, learned counsel for the bank, submit that the current and updated statement of loan would be forwarded to the email ID of the counsel for the petitioner by end of day today.
By tomorrow, my lord. let
By
us
end of
check
day
that.
tomorrow. ಅದಕ್ಕೆ ಕೇಳಿದ್ದು.
Please.
Over confident ಆಗಿ ಹೇಳ್ತಾರೆ. Shri Badrinath, learned counsel for the petitioner would submit that the petitioner is willing to make payment of a sum of 20 lakhs over and above the 55 lakhs paid
55 lakh 25,000.
55 lakh 25,000
For full
paid
amount.
by respondent number 2 at the auction. Srikanth and counsel for respondent number 5 submit that if a further amount of rupees 2 lakhs is paid,
2.5
respondent number
lakhs.
2.5 lakhs is paid, respondent number 5 would be agreeable to give up the rights under the auction in favor of
Subject to making the payment within the time frame.
in favor of the petitioner by executing a sale deed or the like in favor of the petitioner. Ms. Gaurunissal and counsel for the bank submits that as on date, the due amount is rupees 34,00,000,000. The Sri Badrinath and Ms. Gaurunissal seek for and are granted 4 weeks' time to explore the possibility of amicable resolution of in respect of the payment of the said amounts. Relist on 3rd June. Interim order idea?
Is it?
Interim order earlier granted is extended till next date.
But even bank amount, they have to simultaneously.
That is what we have said.
One
Bank, you can wait for another 2 years by collecting interest. They can't wait.
One humble request. This matter may be taken as for further consideration.
We are not treating anything as parted.
Before your lordship it comes, well and good.
You solve, all of you are there, you will solve it by yourself.
Very well.
Solve the problem.
Facts of the case, facts of the case, your lordship had come to know now.
Anybody will know the facts. You, all of you try and solve it.
Finally, date may be fixed.
Date may be fixed for payment.
11 June.
Your Lordship, one submission.
Yes.
Sorry for the interference, Your Lordship. In the 230 moved matters, serial number 2, I've just gone through, which was not there. Your Lordship, there is an interim order prevailing, please.
Earlier.
There was an interim order prevailing not to alienate. Restrain the plaintiff and D1 to D17 and 25, 27, 35.
Everybody
not-
was restrained.
Please.
One humble submission, madam. Payment for, date may be fixed for making the payment. Otherwise, they will drag it for any number of months.
11th it will come up. By then he will do it. Serial number 2. Where is that order?
Your Lordship, the order sheet.
In view of the order dated 10/3/2022.
Please, Your Lordship.
Passed in OS number 6233 of 2010.
Please.
Which was enforced till the disposal of the said suit. The petitioner, the appellant and respondents are restrained from any manner dealing with alienating, encumbering the appeal scheduled properties till the next date of hearing.
Oblige, Your Lordship. Sorry for the inconvenience.
I cleared with tragedy.
Serial number 5.
Yes, Mr. Reddy.
Very good. Please. This matter, my lord, challenge the constitutional validity of section 10, 10(2)(b), 21 of the Karnataka Sauharda.
Challenging the virus.
Please, my lord. My lord, earlier, my lord, the 2% of the education fund was collected in the diminishing manner, my lord, by the federation. Now, my lord, in the straight line method, they wanted to collect it without deducting any the
Sauharda Sahkari Act. Section
10 to 21, my lord. Roman 21. Appropriation of amount out of the net profit specifically for the following. Then, my lord, the B, my lord, relevant portion. 2% towards the cooperative education fund to the Karnataka State Sauharda Federation of Cooperative. This is here, my lord, without deducting any this thing, my lord, out of the net profits, we have to pay the 2% to the towards the education funds, my lord.
Net profit.
Out of the net profit, my lord. Earlier it was
net profit, not gross profit. Yes. After deducting of all the net profit.
No. There we should notice, my lord, your lordship kindly similar.
Net profit is after deduction of expenses.
Anej Urbi, my lord, ink page 10.
10.
Please, my lord.
Yes.
ಕರ್ನಾಟಕ ಸೌಹಾರ್ದ ಸಹಕಾರಿ ಅಧಿನಿಯಮ 1992 ಕಲಂ 62(2)2ರಂತೆ ಸೌಹಾರ್ದ ಕಾಯ್ದೆಯಡಿ ನೋಂದಣಿಯಾಗಿರುವ ಪ್ರತಿ ಸಹಕಾರಿಯು ಸಂಯುಕ್ತ ಸಹಕಾರಿಯ ಉಪವಿಧಿಯಲ್ಲಿ ನಿಗದಿಪಡಿಸಿದ ದರದಲ್ಲಿ ಪ್ರತಿ ಸಹಕಾರ ವರ್ಷ ವಂತಿಗೆಯನ್ನು ಪಾವತಿಸತಕ್ಕದ್ದು ಎಂದು ಹೇಳಿದೆ. ಅಲ್ಲದೆ ಸಂಯುಕ್ತ ಸಹಕಾರಿ ಉಪವಿಧಿ ಸಂಖ್ಯೆ 38ರಂತೆ ಪ್ರತಿ ಸಹಕಾರ ವರ್ಷದ ಸೆಪ್ಟೆಂಬರ್ 30ರೊಳಗೆ ವಂತಿಗೆಯನ್ನು ಕಳಿಸತಕ್ಕದ್ದು ಎಂದು ತಿಳಿಸಿದೆ. ಮತ್ತು ಸೌಹಾರ್ದ ಸಹಕಾರಿ ಅಧಿನಿಯಮ 1997ರ ಕಲಂ 10(2)21ರಂತೆ ನಿವ್ವಳ ಲಾಭದ ಶೇಕಡ 2
ಒಳ್ಳೆ ಲಾಭದ ಅಂದ್ರೆ ನೆಟ್ ಅಲ್ವಾ?
ನೆಟ್.
So net is after expenses.
ಸಹಕಾರ ವಂತಿಗೆಯನ್ನು ಪಾವತಿಸದಿರದ ಹಿನ್ನೆಲೆ ಸಂಯುಕ್ತ ಸಹಕಾರ we are paying the after deducting my lord, we are paying. Now they have asked to pay it.
ಎಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ? ಗ್ರಾಸ್ ಪ್ರಾಫಿಟ್ ಮೇಲೆ ಅಂತ ಎಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ? ಗ್ರಾಸ್ ಪ್ರಾಫಿಟ್ ಮೇಲೆ ಕಲೆಕ್ಟ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ ಯೋಗೇಶ್?
I will not in section, copy is not.
ಎಷ್ಟತಿ ಹೇಳದಪ್ಪ ಕಾಪಿ ಕೊಡಿ ಅಂತ.
ಇಲ್ಲ ಕಾಪಿ ಮೊದಲೇ ಕೊಟ್ಟಿದೆ ಸುಮ್ಮನೆ ಅದು
ಏಜಿಸ್ ಆಫೀಸ್ ಅಲ್ಲ, ಇಲ್ಲೇ ಇದಾರೆ ನಾಯಕ ಆಗ್ಲಿಂದ ಎಲ್ಲೋ
20ನೇ ತಾರೀಕಿಗೆ ಕೊಟ್ಟಿದೆ.
ಎಲ್ಲೂ ಹೋಗೂ ಇಲ್ಲ, ಇಲ್ಲೇ ಕೂತಿರ್ಬೇಕು.
Maybe taken up after vacation period.
And AG accepts notice for respond number 1 and 2.
2 ಇಲ್ಲ.
Issue notice to respond number 2, returnable by 12th June. And AGA is directed to cause inquiry and make his submission as to whether the appropriation of the amount under clause Roman 21 of subsection 2 of section 10 is on the basis of net profit or gross profit.
Serial number 6.
Mr. Reddy.
As per annexure A, the board millard comes to an end millard on 31/1/2025. And no elections were held. And millard, they have not disqualified also the ex-directors, but I have not conducted the elections. And now millard, without millard,
Annexure C is what?
Annexure C, returning officer millard was appointed to conduct elections. And without millard appointing the administrator.
Without?
Later millard annexure D, administrator was appointed. Actually, it's a reverse millard. Actually administrator was to be directed to millard conduct elections. The direct election officer.
Special officer under section
31.
ಯಾವ ಸೆಕ್ಷನ್ ಅಲ್ಲಿ ಮಾಡಿದ್ದಾರೆ?
Special officer millard 31B.
ಸೆಕ್ಷನ್ ಅಲ್ಲಿ ಮೆನ್ಷನ್ ಮಾಡಿಲ್ಲ.
Annexure C.
What is the provision under which sometimes you use special officer administrator interchangeably?
Regarding my lord 28B1 my lord administrator my lord 31B my lord special officer. When my lord quorum is not there my lord, then special officer will take
You are 28A5 or 31(3) na?
Copy no quoting. Copy no.
28A5.
28A5 ಇದ್ದಂಗಿದೆ ಅದು.
ಹೌದು.
To conduct election.
Please.
Conduct election ಅಂದ್ರೆ 28A5 ಬರೋದು.
A5.
ಅದು ರಿಟರ್ನಿಂಗ್ ಆಫೀಸರ್. That is on 11/4/2025.
You reserve liberty to move the vacation bench. They'll get the details by when you can conduct the elections. And AGA accepts notice for respond number 1 to 3 and 4. Issue emergent notice to respond number 4. Petitioner is permitted to take out and summons to respond number 4 and move the vacation bench after service of notice on respond number 4.
Please.
Serial number 7. Kumar SV.
Petition. The subject land matter, my lord, PDCL.
You are the purchaser.
I am the grantee. my lord.
Grantee.
1965 was the grant, my lord. The first sale was 1972 and
And
79.
AGA accepts notice for respond number 1, 2, 3. Issue notice to respond number 4. The petitioner and respond number 4 are restrained from any manner alienating dealing with so and so. Released on 26 June. Process fee and copies to be furnished by end of day 5th May, filing which interim order. By then, office objection to be complied with. Yes.
My lordship, is about an impugn notice, Your Honor.
My lord, if I may. What is challenged in the petition is a show cause notice and thereafter a follow-up notice saying we'll withdraw recognition to the institution, my lord. Thereafter, an order has been passed withdrawing recognition.
Today,
The petitioner will have to challenge that.
You have withdrawn the receipt.
Yes, my lord, it's been withdrawn. There's
Yes,
an
Your
order.
Honor.
May I furnish a
No.
copy, my lord?
Then you have to
It
challenge.
clearly shows, Your Honor. When we approach this court, we are not aware of what has happened.
Yes, now you challenge it.
Yes, Your Honor.
And then it will have to be considered.
Your Honor, only request, Your Honor. Our request is that the school is in a rural area. Admissions are going on. So we humbly
What are the
request, Your Honor,
grounds?
let the smooth functioning of school must not be withheld, Your Honor.
Now you are in vacation in May.
Admissions ಆಗ್ತಾ ಇದೆ. ಅದೊಂದು ಹಳ್ಳಿ ಶಾಲೆ, Your Honor.
What are the reasons?
Reason, Your Honor, on 14th, there is a alleged ಒಂದು food poisoning ಮಳವಳ್ಳಿ ತಾಲೂಕಲ್ಲಿ ಆಯ್ತು. ಎಂಟೈರ್ ತಾಲೂಕಲ್ಲಿ ಮಳವಳ್ಳಿ ಕಾಗೇಪುರ ಅನ್ನೋ ಊರಲ್ಲಿ ಆ ಹೋಳಿ ಟೈಮಲ್ಲಿ ಮಧ್ಯಾಹ್ನ ಒಂದು ಕಮ್ಯುನಿಟಿ ಅವರು ಫುಡ್ ಮಾಡಿದ್ರು. ಬೆಳಿಗ್ಗೆ ನಮಗೆ ಹೇಳಿದ್ರು ಮಧ್ಯಾಹ್ನದ ಊಟ ನಾವೇ ಸ್ಪಾನ್ಸರ್ ಮಾಡ್ತೀವಿ ಅಂತ ಅಂದ್ರು. 14ನೇ ತಾರೀಕು ಯಾವುದೇ ಡೆತ್ ಆಗಿಲ್ಲ. ಬಟ್ 15th 6 ಜನ ಸೀರಿಯಸ್ ಆದ್ರು. ನಾವೇ ಕರ್ಕೊಂಡೋಗಿ ಅವರನ್ನು ಸೇರಿಸಿದ್ವಿ. 16th ಮಾರ್ನಿಂಗ್ ಅನ್ಫಾರ್ಚುನೇಟ್ 1 ಡೆತ್ ಅಕ್ಕರ್ಡ್. 17th ಇನ್ನೊಂದು ಡೆತ್ ಆಯ್ತು, Your Honor. ಎಲ್ಲ ಕಡೆನೂ ನಾನೇ ಆಂಬ್ಯುಲೆನ್ಸ್ ಎಲ್ಲ ವ್ಯವಸ್ಥೆ ಮಾಡಿ ಹೋಗಿದ್ದೀನಿ.
How did you get somebody else's food to be served to your children without verifying? ಯಾರೋ ನಾವು ಮಾಡಿದ್ವಿ ಅಂತ ತಂದು ಕೊಟ್ರೆ ನೀವು you serve it is.
ಹಾಗಲ್ಲ, Your Honor. The idea is that
your responsibility, you are not discharged properly.
Your Honor, the food was served. Even public also got affected, Your Honor.
That is the reason why you should have verified that food and then made available. Why is the midday meal scheme the responsibility of the headmaster?
ರಜಾ ದಿನ ಆಯ್ತು, Your Honor. It's a holiday.
ಯಾರು ಪರ್ಮಿಟ್ ಮಾಡಿದ್ಯಾರು? Who is responsible for the 2 deaths? You can't be like that. Admission is only money. So you.
Your Honor, Your Honor. Kindly requested
AGA submits that in person of the show cause notice, the recognition of the petitioner school has been cancelled. If that be so, it is for the petitioner to challenge the same. Reserving liberty to challenge the said order, the petition stands disposed. And AGA accepts notice for respond number 1 to 6 to challenge that.
Number 9, Nagaraju.
Here for the petitioner's counsel.
Yes.
An application for registering a new society was made in March 2020 on the basis of a circular that Gram Panchayat should have another one society.
Each Gram Panchayat.
Each Gram
2006.
Panchayat. On that basis, the application was made. On the ground that a Gram Sabha is held by the Panchayat. Immediately, objections were filed by the Gram Panchayat members and the vice president, etc., saying no Gram Sabha is held. Now, but at the same time, we are also ready. It should be done in a transparent manner. From 2020 till February 25, nothing further happened. It appears in January 25, the so-called promoter deposits the share amount, so-called alleged share amount of 2,26,000. Order dated 25/2/25 is passed registering the society.
So you can become member.
Followed by election which is already held.
Election has been held.
Please, my lord.
Your Lordship may kindly direct notice. We'll point out the,
So two more seats, one more delegate. And AGA accepts notice for respond number 1, 3, 4, 5, 6. TL Karan Kumar for 2. Issue notice to respond number 7 to 19, returnable by 5th June. Petitioner is also permitted to take out hand summons
Please.
as regard the aforesaid respondents.
Serial number 10. Srinivas Prasad.
We can't take up this matter with so many objections. You comply with this. These objections you have to comply.
The stay is required, my lord. They are threatening that account will be seized.
Verifying affidavit illa, signature illa, oath commissioner seal illa, basic requirements illa. We can't take this. Counsel for the petitioner is granted a week's time to comply with the office objection. He is also reserved liberty to move the vacation bench after compliance.
Serial number 11. Shailaja.
Yes, madam.
My lords, for the petitioner, my lords.
Hmm.
Petitioner is a student, my lords. After completing her PU exams, the result, she has applied for an NID, National Institute of Design, my lords. She has completed her prelims exams. While doing the means, her candidature has been declared as void, my lords. Adana dismiss ಮಾಡ್ತಾರೆ annexure F, my lords. On the criteria is the OBC application. What she has given the certificate.
F.
Yes, ma'am.
Yes.
24, my lords, in page number 24, the result announcement. Upon the verification of
Where is
OBC,
your certificate?
my lords, it is in the first, annexure A, my lords. So in page number 19, which is issued by the Karnataka government, my lords, Revenue Department. She comes under OBC category, wherein her candidature has been moved to general category ranking 618, my lords.
This is subject to the annual income, 3A.
No, my lords, that is not the criteria. The criteria, what they say is, the certificate is not a problem. The format, what she has submitted is a problem. Technically error that it is not complying with the central government format. Our ಹೇಳೋದು ಅಲ್ಲಿ ಕೆಳಗಡೆ ಹಾಕಿದ್ದಾರೆ, my lords. Upon verification, the OBC NCL certificate uploaded by you. I'm reading it annexure F, my lords, at page number 24. You, at the time of applying online for the admission under reserved category, has been found to be incorrect, invalid. Your candidature has been moved into the general category. Henceforth, you will be considered as a general category candidate for the further admission process. Her ranking was stood at 618, my lords, out of the students who has written the exams. In below, my lords, you have not been shortlisted for the DAT, means for Bachelor of Design program at NID. This is what they say, my lords. According to them, the format is different one, wherein after
Where
knowing
do they say format is different? They say that certificate is not proper.
certificate is not proper ಅಂತಂದ್ರೆ ಅವ್ರು
Could
ಹೇಳೋದು
be
it is not.
incorrect or invalid.
ಹಾ, my lords. ನಾನು ಇನ್ನೊಂದು annexure J ಅಲ್ಲಿ page number 34 ಅಲ್ಲಿ ಒಂದು ಕೊಟ್ಟಿದ್ದೀನಿ, my lords. That is the format what they are prescribing for the 34. Later she has uploaded this also, my lords, but they are not considering the application which is later uploaded.
My lords, if I may, my lords.
Yes, madam.
My lords, I appear for the respondent 1 and 2, my lords.
Hmm.
My lords, the central government requires a certificate in which the candidate specifically mentions that the candidate belongs to the caste and the OBC, which clearly mentions the OBC list, my lords, as per the central list, and also a non-creamy layer. Now, this particular format has been uploaded on the website of NID, my lords. It has to be in conformity with that.
Is now they uploaded it.
Yes, my lords.
My lords, that is not the format, my lords.
See, the problem
The
that
format is
arises is
different.
each government has its own format. Now, they've
My lords, it
uploaded
is,
what the state government has given them.
Yes, ma'am.
There's not that you are in fact at Annexure F, the reading of it, it says that invalid and incorrect. It's not incorrect or invalid. It's not in the proper format you should have said.
yes, ma'am. Yes,
But if
ma'am.
it's a valid certificate, why should they be deprived of it on formality?
Please, my lords, regarding that, I will have to secure instructions, my lords. This matter is just listed. But
Let
this
her
is
take up
one
the
thing.
examination
Please,
now.
ma'am. Please.
Let her take up the examination. You do that, and then you should probably issue instruction to all the governments to give it in this particular format.
Please, my lords.
You can't have
Regarding
a
that, I will
different format.
secure instructions, my lords.
And tomorrow is the mains exam, my lords,
Yes,
so I
we'll
request,
permit you to take it up.
grateful, my lords.
Ms. Reshma Tamaya accepts notice for respond number
1 and 2,
1
my
and
lords.
2. Issue notice to respond number 3 to 5, returnable by 11th June. The response are directed to permit the petitioner to provisionally appear for the Bachelor of Design aptitude test bracket DAT mains examination scheduled on 3/5/2025, subject to the outcome of this writ petition.
Grateful.
The submission of Ms. Reshma Tamaya is that the proper format of the caste certificate is as per Annexure J. What has been uploaded is as per Annexure A, and that is the reason why it was not considered. The format of the caste and income certificate at Annexure A is that which is issued by the state government. There is no dispute as regards the veracity and authenticity of Annexure A. It's only the format which is under question. If that be so, it is for the respond number 1 and 2 to indicate if necessary instructions have been given to issue caste certificates in terms of Annexure J to all the state governments. Relist on so and so and
Expedite
delivery
submission
ordered.
by hand, my lords. By hand delivery, my lords.
Yes.
Grateful.
Obliged.
Satya MN.
My lord, so voting, my lord.
Petitioners, my lord, the
Election
the
on.
matter-
He
the
accepts
matter is
notice.
pertaining-
R134,
For 134,
please.
TL Kiran Kumar for 2, issue notice to respond number 5, returnable by 12th June, voting rights.
Please, separate ballot.
Separate.
Please, second, next also, my
Subject
lord.
to 26 A4, A5, 29C.
Please, please.
LI.
13 also, my lord.
13 arrow.
50,
AGA for
134, my lord. 134.
134. 134, Kiran Kumar for 2, notice to respond number 5, voting rights.
Please.
Hand delivery ordered. 12 and 13, ಎರಡು hand delivery. Yeah. ಇಲ್ಲ ಇದೆ.
Number 1.
Lordships may seem, Lord, this is the interim order passed. ಇದರಲ್ಲಿ Lordships have held.
There's a clarification.
ಅದೇ ಅದ್ರಲ್ಲಿ ಏನಾಗಿದೆ ಅಂದ್ರೆ that regulations are, my lord, the coordinate bench of this honorable court has said that, my lord, those regulations cannot be given retrospective effect. Lord, in that light, the only the retrospective effect given in any regulations notified in the so and so shall remain stayed. What your lordships have said is, my lord, that future payments will be made. Now, they should not insist on the past payments. In the light of these, my lord, this is only complementing your lordship's
Lordship,
interim
if I
order.
make one submission. Lordship, in case retrospective payments are stayed, then payments as per order dated 2012-2024 passed by the coordinate bench of this honorable court may be complied with, wherein 50% charges were to be paid by the petitioners, your lordship.
That we have anyway paid. That is, my lord, 581. Your lordships may see 581. That we are already paying. That lordship,
What is 581?
the 50% as an interim measure, my lord, 50% should be paid until the coordinate bench, my lord, had
Because, your
ordered.
lordship,
May I pass it on?
What would happen is if retrospective payments are stayed as per the new regulations.
No,
and if they
payments
have
are not stayed.
If the previous payments, even as per the orders, have not been paid, then it would amount to the petitioners making use of the infrastructure facilities at free of cost.
Yes, you can't make it retrospective.
Indeed, your lordship. In that light, I'm just seeking for payments to be made, at least in accordance with the order dated 2012-2024, your lordship.
We have made it clear to your senior that from April they'll pay.
Indeed, your lordship.
Not prior to April.
Yes,
Your
that may be
Lordship,
clarified.
Prior to April, the order dated 2012-2024 covers
That you
payments, Your
agitate
Lordship.
there. The matter has been more for a clarification as regard the order dated 28/4/25 as to whether the said order would apply prior to April 25 or not.
Your Lordship.
It is made clear that from the month of April 2025, the petitioner would have to make payment of the amounts indicated in Annexure E. There would be no requirement to make payment of any amounts prior to month of April 2025.
My sincere apologies, Your Lordship. Just now an order was passed in the coordinate bench as well by the.
I was there, my lord. In that case,
But there the
100% was
directions-
paid. They have collected 100%.
Directions were made.
We are clarifying only our order.
Yes.
If
My
all
sincere
of it you
apologies.
argue to there.
ಅದ್ರಲ್ಲಿ 19th
Retrospective,
April
you can't do
19th April ಅಂತ ಸ್ವಾಮಿ. ಆ ಬಿಲ್ ಡೇಟ್ 1st April ಮತ್ತೆ ಮಾಡ್ಬಿಡ್ತಾರೆ. 19th April.
From
bill is
19th
date.
April 25
Date.
onwards.
Serial number 2, Jayaprakash Reddy.
K-waiter ಇದ್ದಾರೆ ಆನಂದ್. Yes.
Today morning, my lord, is served copy of the writ petition.
Today itself I filed the petition. Here, my lord, after the order section C.
ಏನಿದು? What is
31,
Resignation, my lord.
31 ಕೆಳಗಡೆ special
Order
officer
passed with
appointment ಇದೆ.
assistant to start section 31, appointing special officer is under challenge. It is an appealable order, my lord.
Not
Lord,
that.
we have
106
given
of the Karnataka
representations, we have
Cooperative
given
Service.
representations
Resignation
to
of the
the ARCS, my lord, stating that we have not tendered any resignation. And based on that representations, my lord, today he has called for enquiry, my lord. In the enquiry, my lord, to my person, my lord, just now I received. Without assigning any reasons, my lord, stating that has already ಮೇರಿಟ್ ಮೇಲೆ ಮೇಲಿನ ವಿಷಯ ಮತ್ತು ಉಲ್ಲೇಖಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಚನ್ನಪಟ್ಟಣ ತಾಲೂಕು ಸೋನ್ಸೋ ಹಾಲು ಉತ್ಪಾದಕ ಸಹಕಾರ ಸಂಘ ಇದರ ಆಡಳಿತ ಮಂಡಳಿ 5 ಜನ ನಿರ್ದೇಶಕರ ಸ್ಥಾನಕ್ಕೆ ರಾಜೀನಾಮೆ ನೀಡಿದ್ದು, ಸದರಿ ರಾಜೀನಾಮೆ ಪತ್ರಗಳನ್ನು ಸಂಘದ ಕಾರ್ಯದರ್ಶಿ ಅವರು ರಾಜೀನಾಮೆ ನೀಡಿರುವ ನಿರ್ದೇಶಕರ ಆಧಾರ್ ಕಾರ್ಡ್ಗಳೊಂದಿಗೆ ದೃಢೀಕರಿಸಿ ಸಲ್ಲಿಸಿರುವ ಮೇರೆಗೆ ಆಡಳಿತ ಮಂಡಳಿ ಸ್ಥಾನದಲ್ಲಿ ವಿಶೇಷಾಧಿಕಾರಿಯನ್ನು ನೇಮಕ ಮಾಡಲಾಗಿದೆ. ಆದ್ದರಿಂದ ನಿಮ್ಮ ದಿನಾಂಕ 2/5/2020 ಮನವಿಗೆ ಹಿಂಬರಹವನ್ನು ಮೇಲ್ಕಂಡಂತೆ ನೀಡಲಾಗಿದೆ. Inquiry was called as per Annexure H today.
But the five out of 10 directors, selected directors, they tendered resignation. On 4/4/2025, they tendered resignation, which was not withdrawn within a stipulated period of 15 days.
3 of them have given.
On 21/4, my lord, the chief executive officer of the society reported the same to the assistant registrar of cooperative societies.
How many elected?
10.
10, my lord,
10 elected.
10 elected, out of which 5 resigned.
Where are the resignations?
3.
It is on 4/4/2025.
Annexure A, B.
A and B, my lord.
Next, A,
Pertaining
B
to
ಮಾತ್ರ
petition number 1 and 2.
Other 3 directors, they are not before the.
A, B, they say they are not.
We have not.
ಅಲ್ಲ ಸೈನ್ ಮಾಡಿದ್ದೀವಿ ಅಂತ ಹೇಳ್ತಾರೆ, ನಮಗೆ ಗೊತ್ತಿರ್ಲಿಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ. ಸೈನ್ ಅವ್ರದ್ದೇನೆ ಅಂತ ಹೇಳಿ. And disputed question of law, my lord, there is an appeal under 106. Let them file an
ನೋಡೋಣ,
appeal.
signatures ನೋಡೋಣ ಏನಂತ.
Next, Sharia page 12.
There must be some mechanism of collecting this, receiving this resignation.
Regarding, my lord, it is submitted to the CEO only, my lord. They should be forward to us, my lord.
ಮಾಡಿ ವಿಡಿಯೋಗ್ರಾಫ್ ಮಾಡಬೇಕು,
Please.
ಆಧಾರ್ ಕಾರ್ಡ್ ತಗೊಂಡು ಅದ್ರ ಸಿಗ್ನೇಚರ್ ತಗೊಂಡು ಮಾಡಬೇಕು ಅಂತ ಇಶ್ಯೂ
Please.
ಸಮ್ ಪ್ರಾಕ್ಟೀಸ್ ಡೈರೆಕ್ಷನ್.
To that regard, my lord, lordship, my lord.
ಸರ್ಕ್ಯುಲರ್ ಕೊಡಿ.
Even
ಎಲ್ಲ ನಾನು ರಿಸೈನ್ ಮಾಡಿಲ್ಲ, ಬ್ಲಾಂಕ್ ಶೀಟ್ ಸೈನ್ ಮಾಡಿದೆ.
even the CEO has not intimated regarding the resignations.
ಈ ಕಡೆಯಿಂದ ಆ ಕಡೆ ಚೇಂಜ್ ಆದ್ರೆ ವಿಡ್ರಾ ಅಂತ.
ಇಲ್ಲಿ
ಚೇಂಜ್ ಆಗ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಹಂಗೆ ಇರುತ್ತೆ.
ಇಲ್ಲಿ ಏನಾಗಿದೆ ಅಂತಂದ್ರೆ ಇದು ಎಲೆಕ್ಷನ್ಸ್ ಬಂದಾಗ ಬಮೂಲು ಇದಕ್ಕೆಲ್ಲ ಯೂನಿಯನ್ ಎಲೆಕ್ಷನ್ಸ್ ಬಂದಾಗ only societies will be eligible to contest and vote in the elections. ಅಲ್ಲಿ ಏನ್ ಮಾಡ್ತಾರೆ, if this society is not in my favor, if I am a ruling party candidate to the Bamul election, then utilizing the mechanism ನಾವು ಮಾಡ್ತೀವಿ.
ರೂಲಿಂಗ್ ಪಾರ್ಟಿನೇ ಅಲ್ಲ, ಎಲ್ಲರೂ ಅದೇ.
ಅದೇ
ಎಷ್ಟು ಕಮ್ಮಿ ಮಾಡ್ಬೋದು ಹಂಗ್ ಕಮ್ಮಿ ಮಾಡೋದು.
ಅಪೋನೆಂಟ್ಸ್
ನೀವು ಅದೇ
ಅಪೋನೆಂಟ್ ವೋಟ್ಸ್ ಎಷ್ಟು ಕಡಿಮೆ
ರೂಲಿಂಗ್ ಪಾರ್ಟಿನೋ ನಾನ್ ರೂಲಿಂಗ್ ಪಾರ್ಟಿನೋ ಗೊತ್ತಿಲ್ಲ. It is trying to eliminate. And you come, this requires a trial. on facts.
And most of the question, even at least, my lord, the CEO has to bring it to the notice of the president regarding the resignations. Even forget about producing the, furnishing the copies to him. In the ಕೊಟ್ಟಿದ್ದಾರೆ resignation, no, so I'm furnishing ಅಂತ ಅವ್ರಿಗೂನು ಅವ್ರ ಗಮನಕ್ಕೂ ಕೊಟ್ಟಿಲ್ಲ.
ನಿಮ್ signature, ನಿಮ್ thumb impression, Mr. Reddy.
This is not.
We'll have to say now why you gave it, what was the circumstances.
No, even in my representations, my lord, I have stated, my lord, when I submitted, immediately after coming to know, I've given a representation to the.
ಯಾವತ್ತು ಕೊಟ್ರಿ representation?
Immediately, my lord, on 22/4 ಗೆನೆ ಕೊಟ್ಟಿದೀವಿ.
22/4?
ಹೌದು.
4/4 is this one.
ಅಲ್ಲ ನಮಗೆ ಈ ಆರ್ಡರ್ 21/4 ಗೆ ಆರ್ಡರ್ ಪಾಸ್ ಮಾಡಿದ್ಮೇಲೆ ನಮಗೆ ಗೊತ್ತಾಗಿದ್ದು. So immediately very next day we have given representations to the ARCS, that is as per your ref, my lord.
21/4 is the order, you gave you this one.
And 22nd.
Very next day.
Very next day, immediately we have given, my lord.
ವೆಂಕಟ ಲಕ್ಷ್ಮಮ್ಮ ಕೊಟ್ಟಿದ್ದಾರೆ ಅಂತ ಹೇಳ್ತಾರೆ, she is not before this court.
ಅವರು ಕೊಟ್ಟಿದ್ದಾರೆ, even 20th ಅನೇಜೂರ್ ಜಿ ಇವ್ರು ನಾವು ಕೊಟ್ಟಿದೀವಿ.
The very next day they have given.
Out of 5, my lord, 5 out of 10 they tendered resignation. Out of 5 ನಲ್ಲಿ petition number 1 and Srimati Venkata Lakshmama submitted
2
representation.
7
Yes,
ಆದ್ರು.
yes, sir. Venkata Lakshmama has not filed right petition. And only 2 Giri Gowda and Basavappa. Others are not, others are the directors, they are not
The Giri Gowda and Baswappa A and B. Objections ಯಾರು ಕೊಟ್ಟಿದ್ದು?
Objections Giri Gowda ಮತ್ತೆ ವೆಂಕಟ
ಬಸವಪ್ಪ ಕೊಟ್ಟಿಲ್ವಾ ಮಿಸ್ಟರ್ ಡಿ?
ವೆಂಕಟ ಲಕ್ಷ್ಮಮ್ಮ
ಅವರು ಇವತ್ತು ಎನ್ಕ್ವೈರಿಯಲ್ಲಿ ಪಾರ್ಟಿಸಿಪೇಟ್ ಮಾಡಿ ಕೊಟ್ಟಿದ್ದಾರೆ.
ವೆಂಕಟ ಲಕ್ಷ್ಮಮ್ಮ ಇಲ್ಲಿ ಇಲ್ವಲ್ಲ?
ವೆಂಕಟ ಲಕ್ಷ್ಮಮ್ಮ is not there.
Even my lord, in response.
ವರಲಕ್ಷ್ಮಮ್ಮ ಇದ್ದಾರೆ, ವೆಂಕಟ ಲಕ್ಷ್ಮಮ್ಮ ಇಲ್ಲ.
Even my lord, in response to the notice issued.
Then also Venkat
by the second
Lakshmama
respondent.
But even then, my lord, there will be 6 members out of 10.
ವೆಂಕಟ ಲಕ್ಷ್ಮಮ್ಮ ಏನ್ ಹೇಳ್ತಾರೆ ಅಂತ ಅವ್ರದ್ದು ಬೇಕಲ್ಲ. She is not a petitioner before this court. So how can we take that into account? Even then, maximum we can take is Giri Gowda.
Giri Gowda and even Basappa has also today, as in the party, while participating in the this thing, my lord, inquiry.
Petition ಎಲ್ಲಿದೆಯಪ್ಪ?
ಇಲ್ಲ petition ಅಲ್ಲಿ ಇಲ್ಲ. Today, while participating, he has given his objection. ಇಲ್ಲ petition ಅಲ್ಲಿ ಇಲ್ಲ sir.
ಎಲ್ಲ ಫೈಲ್ ಮಾಡಿ. So Giri Gowda and Basappa ಬಂದ್ರೆ 7 ಆಯ್ತು. Quorum ಬಂತು.
ಅಲ್ಲ, but quorum ಬರಕ್ಕೆ they have submitted resignation.
Did Basappa give a representation on 22/4?
No, within 15 days.
Then it can't be taken. Venkat Lakshmama, is she with you or no?
She is now neutral.
Now not there.
She is not.
She is now neutral.
Bad luck.
Neutral. Even otherwise, let's say out of 10, 6 will constitute
ಇಲ್ಲ,
7 ಬೇಕು.
13 is the total strength.
7 ಬೇಕು.
Number next to 50% of the total strength. Rule 14.
Venkat Lakshmama is with you, then only, otherwise no. And AGA accepts notice for respond number 1, 2 and 4. Shri P. Anand was filed KVIT accept notice for respond number 3. Shri P. Anand is directed to secure the original records and place the same for consideration. Released on 5th June.
25th ಗೆ ಎಲೆಕ್ಷನ್ಸ್ ಇದಾವೆ ಬಮ್ಮೂರಿ.
ನೀವು ವೆಂಕಟಲಕ್ಷ್ಮಣ್ ಕರ್ಕೊಂಡು ಬಂದು ಮೂವ್ ಮಾಡಿ, ಇಲ್ಲಾದ್ರೆ ಇಲ್ಲ.
ಲಿಬರ್ಟಿ
ಬಸಪ್ಪ ತಗೊಳಕ್ಕಾಗಲ್ಲ.
Liberty may be reserved to move the vacation.
There is no basis unless you get Venkatalakshmama.
ಅದಕ್ಕೆ ನೆನ್ನೆ
ಮೂವ್ ಮಾಡಿ, ಯಾವಾಗ ಕೋರ್ಟಿಗೆ ಮೂವ್ ಮಾಡಿ ತಗೊಂತಾರೆ.
ಲಿಬರ್ಟಿ.
In the event of any urgency, petitioner is reserved liberty to move the vacation court. Yes.
Petitioner, my lord, is a school which runs pre-nursery, LKG and UKG classes. Lord, a report is submitted stating that, my lord, a complaint was received by the neighbors that there is sound pollution. Report says, my lord, that there is no sound pollution. That report, my lord, should find at page 87.
What is the complaint?
That there is no sound pollution to the neighbors. A
Sound pollution.
Let's take page 87, my lord. I'll just read the last paragraph that the report is submitted. The typed copy, my lord, is at page 88, my lord. ಶಿಕ್ಷಕರ ಸಂಖ್ಯೆ 5/5 87 report typed copy 88 ಅಲ್ಲಿ last 4 lines.
Yes.
ಇಲಾಖೆ ಅನುಮತಿಯೊಂದಿಗೆ ಶಾಲೆಯು ಜರುಗುತ್ತಿದೆ. ನೆಲಮಾಡಿಯಲ್ಲಿ 3 ತರಗತಿಗಳು ಜರುಗುತ್ತಿದೆ. ಮೇಲಿನ ಅಂತಸ್ತಿನಲ್ಲಿ ವಾಸ ಮಾಡುತ್ತಿರುವ ಕಂಡು ಬರುತ್ತದೆ. ಅದರ ಮೇಲಿನ ಅಂತಸ್ತಿನಲ್ಲಿ ಪೋಷಕರು ಮಕ್ಕಳ ಸಭೆ ಸಂಬಂಧ ಮಾಡುತ್ತಾರೆ. ಧ್ವನಿವರ್ಧಕ ಬಳಸುತ್ತಿರುವ ಕಂಡು ಬರುವುದಿಲ್ಲ. ಈ ಮೇಲಿನ ಅಂಶಗಳನ್ನು ಪರಿಶೀಲಿಸಲಾಗಿದೆ. This is the report.
This is a government high school.
Yes, my lord. No, my lord. It's a private school. The report is submitted by the headmaster of a government school. Now, my lord, the BU has issued a show cause notice stating that, my lord, you are running a school in a 3-floor building. You are running a school in a 3-floor building. The ground floor is required to have the minimum measurement of 2,000 square feet. We, my lord, under 39E, my lord, before they issue this show cause notice, they are required to give an opportunity to me to rectify the mistake. Now, my lord, I have obtained a CS site.
So when will you rectify?
My lord, the moment I have started construction in the CS site, my lord, in 6 months they are building.
In this building, when will you rectify?
This building, my lord, could be rectified within a period of 2 months or 3 months. I need some time, my lord.
May I submit, my lord? What is under challenge is a show cause notice to which they have not given a reply. They've been given 7 days.
Show cause notice, you
Yes, my lord.
Okay, I'll reply, my lord.
Thereafter, my lord, the first ground is that an opportunity was not given to them to rectify their mistakes. My instructions are that about a year ago, they were called in and they had sought a time period for about a year to comply with it.
You
on
reply to
expired-
the show cause notice.
No, my lord, I
Let
have
them
replied,
reply,
lord.
my lord.
Issue is this. Kindly see 39E, my lord. Before I take my lord's file, I'm saying this.
Education Act.
Withdrawal of recognition comes under 39. Kindly see 39E, my lord.
Yes.
Fails to remedy the defects in instructions or accommodation or
So you
deficiencies.
give a reply saying by when you will,
They'll have to put
you
put
asked them for 1 year, you did not do it.
No, this is the first time they're not even one notice sent to me.
They told you that they'll rectify in 1 year.
My lords, the BEO told me that there was a meeting held about a year ago when the petitioner was informed and they had sought for a year's time to rectify the defects.
My lord.
Accordingly, it was given, and now again, because a complaint is raised, a show cause notice is issued. Now, even if you are not issued, it's open to them to
Take on
contend that
School,
as in their
you
reply.
have to comply with all of it.
True, my lord. My lords, may
There's
take
no-
on instructions on my note that, my lord, prior to this letter, there was no communication on this point.
You
between my-
reply to the show cause notice.
I replied, my lord, annexure V. Now, the
they'll
problem is
consider
this.
it.
Oh, my
my
lord,
lord, the
that
show
is
cause
dated
notice.
prior to the show cause notice.
Under the show cause
Have you
notice. my lord.
replied to annexure A, Mr. Abhinay?
Yes, my lord, it's replied. my lord.
Where is the reply?
Annexure V, my lord, page
Annexure?
93. 25(4) is the show cause notice, my lord. 28(4) is the reply.
Where is that?
Page 93, my lord, typed copy.
23.
No, my lord, under the show cause notice, they are asking us not to take any admissions. There are 50 students who are already studying there.
We'll consider the response of the
Within
petition
1 week from today.
within 1 week.
And I'll tell
Petitioner
them
is
not to
before
take
this
any.
court seeking for the following reliefs. The grievance of the petitioner is that the reply to the petitioner to the show cause notice at annexure A, a reply of the petitioner at annexure V to the show cause notice at annexure A has not been considered and the recognition is sought to be withdrawn. When a show cause notice has been issued and a reply has been issued thereto, it is for the response to consider the same and pass necessary orders and only thereafter take necessary action. No order on the show cause notice having been passed, no further action could be taken without such an order being passed. Hence, I pass the following order. Writ petition is partly allowed. Respondents are directed to consider the reply of the petitioner at annexure V and pass a reasoned order thereon within a period of 7 days. from
I
date of
direct them to
receipt
also consider annexure R and S, my lord.
of
My
a
lord,
copy of this order.
7 days was given to them to answer to the show cause notice. It has now, as on today, my lord, with 2 days
reply.
exception.
So how long do you want to consider it?
No, my lord, it's 1 week, but they can't, we've not even had the opportunity to consider their response as
That
its
is why we are
first
asking you
working
to
day.
pass that order.
Very well,
You pass the order.
And not to take in procedural action until then. The problem is.
Needless to say, until orders are passed on the show cause notice, no precipitative action can be taken.
That's why I also direct them consider R and S also, my lord. R and S.
Your reply is what they'll consider.
My lord, it's also produced sought for mandamus to consider annexure R and S.
They have issued a show cause notice.
Second prayer.
They will consider, no, not that. Next.
Serial number 4. Yes, yes, sir, but
Yes, Mr. Arbati.
GST matter, out of clerical error, IGST ಕಟ್ಟಬೇಕಾಗಿದ್ದನ್ನ CGST ಕಟ್ಟಿದೀವಿ. Amount is there in the credit. And I have sought for adjusting that amount. They passed this order saying that there is a discrepancy in the annexure F is the order.
Yes, madam. Ms. Jyoti.
And also there is one input tax credit. There are two different components. Input tax credit also monthly returns have it is submitted.
my lord.
They have paid it as CGST instead of IGST. They're asking for your.
My lord, they can go alternative appeal remedies there, my lord. This honorable court, they cannot rely jurisdiction, my lord. On merit, they can go appeal. Their reply is considered. If they are not appreciated well, then they can approach honorable first appellate authority.
What is annexure F? They've already considered it.
Annexure F is the impugned order.
Is an order passed?
Yes, my lord. Before that, there is a show cause notice issued. I have not received the show cause notice. The notice before that, I have replied, that is considered, not in the impugned order. But the show cause notice which was issued, statutory show cause notice which is issued to me, DRC 01, that I have not received. Even this impugned order I did not receive for a long time until I received a phone call from the office of the assessing officer.
All these are sent by email.
But I have not, no, this is not sent by email. I have not received this. I have stated so in my petition also.
Everything is by email now.
Yes, yes, my lord.
And that is your registered email ID.
Lord, I've stated so in my email, in my petition, Lord, that I have not received this order. As soon as I received this, I came to know about this order, Lord, I've taken steps. That the amount is there to their credit. Lord, it does not make, Lord, sense to for me to go and file an appeal and seek, Lord,
You are asking them to pay a penalty also.
yes, Lord. Not only.
My lord, what happened, my lord? Nowadays.
Department come before us with some appeal banni neevu. Any office objection, we will not allow it until you comply to the dot. How can you be like this? The mistake which has happened, instead of IGST, they have put it as CGST. The consider madak badlu, you have outrightly rejected it without even any reason. Just because there is power with you, you don't need to exercise like this. Mr. Arbati's other client will exercise power against you. You want them to exercise powers? Section 12. On the complaint register madi. Please don't do this.
That gives us an idea, Lord. There are not many commercial tax GST officers in our net so far.
So you're getting
Later
ideas.
side, on the latest.
And SCGP accepts notice for respond number 1 and 2. The operation of annexure F is stayed till the next date of hearing. And counsel for respondent is called upon to make a submission as to why the mistaken payment made under CGST instead of IGST could not be regularized and the amount credited to IGST account. Released on 4th June.
Grateful.
Serial number 5, H.N. Basuraju.
Hearing first. Lord,
This matter pertaining
Friday
to
I argued
recounting, my lord, lordship, my lord, dismiss the matter.
on that day wrong
Serial
persons
number
before
39,
the
my
court.
lord.
These are the 3 other people.
Today right first one before.
Adu dismiss aito. The 3 people will have to stay.
They are agreed, my lord, paragraph 10 I made.
And
yesterday.
AGA accepts notice for respond number 1, 2.
My lord, in respect of 6 to 10 winning candidates, my lord, I may be permitted to
6 to
10, my lord.
So also accepts notice for respond number 6 to 10.
Yes, Amrit
Issue
Chowdhury.
notice to respond number 3 to 5. Returnable by 12th June.
Once, my lord,
the operation of the order date 11/3/2025 at Annexure F is stayed till the next date of hearing
Pay for hand.
My lord,
No, once.
and delivery order.
So winning kind of my lord, election petition, election is a my lord, petition is a my lord.
my lord, it is appealable order, my lord, before KAT, my lord. Before, my lord, interim order.
But these people had the benefit of it. They
But
should get
there is
the-
an alternative remedy, my lord.
That you can't take advantage of on the last day.
Great.
Our
That I
other-
lost this.
Our other petition we have dismissed. This
Right.
petition will have to be allowed actually,
Rightly, it is.
after 4 o'clock.
Also 4:23. Great.
Lord, I may be served a copy. my lord.
They'll serve a copy.
They will.
Appearing for the petitioners.
Yes.
Petitioners are members of Picard Bank. Now they are holding an election to the primary agriculture and rural development bank. I request your lordship kindly take page 25.
Which I'm directing to prepare and publish eligible list.
They have not even, they have prepared, that has been rejected by the election officer. Now the election officer having rejected appointed a returning officer.
They have published.
Please.
They submitted to the returning of election officer. We filed an objections. Since that is not in accordance with the bylaw as well as the rules, 13D, he rejected. Directed the CO, the Picard Bank, to prepare in accordance with bylaws and the rules. Thereafter, well, I will appoint a returning officer. That your lordship get it in annexure.
So why the interim prayer?
The interim prayer now, having said so, he appointed the returning officer to hold the election in absence of that.
Regarding my lord, there is a 15 days.
Page
time.
40, page 40. I
15
request.
days time is there, my lord. So it is only 14A, my lord, notification.
Well, how can you issue it if the list is not ready?
Please.
He himself said that I will appoint only after the submitting the list. Now he is appointed.
Rejected.
To regarding my lord, kindly see my lord, annexure, page number 43. Only my lord, 14-1 application, 14-1 notification. It is not my lord, 14-3 tentative.
Aitapa, but how can you issue this without the list being finalized? How did you go to 14 without 13D happening?
Please.
ನೀವು 13D 4 ಆಗೋವರೆಗೂ ಮಾಡಲ್ಲ ಅಂತೀರಾ 13D 2 ಆಗದೆ ಹೋಗ್ಬಿಟ್ಟಿದ್ದೀರಾ 14ಗೆ.
Not only that, my lord, they say the reservation. Also is
And
not-
AGI accepts notice for respond number 1, 3,
to 7.
4, 5, 6, 7. TL Kiran Kumar for respond number 2, issue emergent notice to respond number 8, returnable by 12 June. Since respond number, who had rejected it?
Respondent number
6.
4. Joint registrar is the returning officer.
JRCS had rejected it.
JRCS, he is the returning
Number
officer.
4 had rejected the list of the eligible stroke ineligible voters.
Including the reservation.
And reservation. A returning officer could not have been appointed in terms of annexure C and D. As such, annexure C and D are stayed till the next date of hearing. Pre-list on so-and-so date.
Lordship kindly.
Yes.
I'm extremely sorry, firstly, my lord, in serial number 14, list number 1, so far as that undertaking affidavit, its daughters have some cases, my lord, that's why.
On the basis of your submission, we have passed the order.
Please, my
Now
lord,
the other side is not here. You can't mention it.
I intimated him, it may be, I may be given liberty to move the vacation with, my lord, the order.
We are not going to do that.
I
Without the
intimated
other
him.
side being there, we won't change.
I intimated to him.
You intimated he is not here. ಅವ್ರು ಇಲ್ದೆ ಮಾಡಕ್ಕಲ್ಲ.
This I may
ನೀವು
be
ವೆಕೇಶನ್
given
ಬೆಂಚ್ ಮೂವ್
liberty.
ಮಾಡಿ ಅವ್ರನ್ನ ಪ್ರೆಸೆಂಟ್ ಇಟ್ಟು ಆಮೇಲೆ ಮಾಡ್ಕೊಡಿ. Not in their absence.
I may be permitted to move the vacation with liberty, may be, my lord.
Serial number 14, list 1. In the event of there being any urgency, petitioner is at liberty to move the vacation bench.
Please, my lord, in serial number 26, that is stamp matter. 26, the affidavit, ICR's affidavit in that. First list, that documents, the original file is with me, shall I hand
ಅದು
over the file?
ಇಟ್ಕೊಂಡಿರಿ ನೀವು ಇನ್ನ ಅವ್ರು ಸಬ್ಮಿಷನ್ ಮಾಡ್ಬೇಕಲ್ಲ, ಇಲ್ಲ ಆಮೇಲೆ ಎಲ್ಲಾರು ಹೋದ್ರೆ ಯಾಕೆ? ಅವ್ರಿಗೆ ಕೊಟ್ಬಿಡಿ, ನೀವು ವೆಕೇಶನ್ ನೀವೆಲ್ಲ ತೆಟ್ಕೊಡಿ. ಬಂದ್ಮೇಲೆ ನೋಡೋಣ. ಓಕೆನಾ?
Shweta.